It is 9:02, and I call to order this 12th day of July, 2022, the special magistrate hearings this morning regarding various code enforcement proceedings. There are three parts to today's program. The first part deals solely with compliance, non-compliance. And unless there is something extraordinary, it is simply a finding of compliance or non-compliance, and typically a month or thereabouts, at least till the next cutoff date for the person to come into compliance. At which time, if they don't come into compliance, then they can be reset for another hearing later on for a fine. So these typically go fairly quickly. That is then, there are 33 of these right now on the agenda. Some of them may be resolved already, and it may be a little bit shorter. There are then another 40 cases that deal with the possibility and imposition of a fine. And these are cases where there has been already a finding of non-compliance, a time period to come into compliance, and the individuals have not come into compliance, or they are here for a progress report or something of that nature. That part of the program takes a bit longer. And then the third part are lien reviews. They come at the end, and I believe there are 13 of those in this packet. So we have a fairly long day here in front of us. My name is Robert Riggio. I will be the special magistrate this morning hearing these cases. And at this time, I would like to ask Madam Secretary if there are any announcements.
Yes, sir. Starting with page 5. Case number 16. Case number 16 is going to be via Zoom.
Excuse me?
Via Zoom.
Via Zoom, okay.
Page 6. Case number 18 is also via Zoom. And case number 20 via Zoom as well. And he has another case as well, number 56, on page, I'm sorry.
Yeah, just go in order.
Okay, I'll just get to that. Page 8.
There's one on 7, page 7.
Oh, okay. Thank you, Captain. I'm sorry. Page 7 has a case number 23, SMG 07-22-182 is in compliance as of 7/11/2022.
See the property address one too.
Oh, I'm sorry. The address is 1100 South Ridgewood Avenue, apartment 82. Page 8, number 26, SMG 07-22-172, Fulton Street, parcel 533-8-66-00-0510 is in compliance as of 7/8/22. Okay, and page 12. Oh, this is the guy, wait, we just skipped that one. Sorry. The gentleman just asked. I'm sorry, we'll go on to page 13. Page 13, case number 46, SMG 04-22-122, Mina Razamani, Magnolia Avenue. Oh, I'm sorry, the number again is SMG 0422124. Mina Razamani, she's in compliance. Magnolia Avenue, 533-9-26-00-013. Compliance 7/8/2022. Page 15. Number 54, case number 54, via Zoom. Page 21. Yes.
That should be the next one.
Okay.
What I'm saying.
Page 16, number 56 is Zoom. Next page is 21. SMG,
No, it's just lien, it's lien review 2.
oh, okay. Page 21, lien review 2 and 3 are via Zoom.
Is that all you had, Brenda? Mr. Riggio, also, for part of the announcements, on page 23, lien review 8 is being pulled from the agenda, will be brought back before at a later date.
Okay.
Lien review 9 is also being pulled from the agenda. Lien review, I'm sorry, I switched pages on you. Page 24.
If I can say, as far as lien review 8 and 9, as at the request of the applicant.
Yes, I'm sorry, and yeah, at the request of the applicant. On page 24, lien review 10 and lien review 11 are both pulled from the agenda at the request of the applicant.
Thank you.
And I think that concludes our announcements, right, Madam Clerk? Yeah.
I do have one more, page 7, case number 23. I'm sorry, I already said that one. I covered it already, I'm sorry. That's it, sir, I'm sorry.
Okay, thank you. Okay. Hearing no further announcements, will those representatives of the city who will be giving testimony this morning please come forward to be sworn?
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you.
Okay. Are there any cases this morning where there are attorneys present who will be representing those cases? If you could come forward and if you could state your name and what cases you're here on behalf of?
Yes, my name is Corey Brown. I'm here on behalf of Mark and Julie Washleger on case number 11.
Okay. And
Jessica Gao, here on behalf of items 7, 12, 42, 49, 73, and MB-3. I can do that again slowly if you'd like.
7, 12, 42, 49, 73.
And MB-3.
Okay.
Yep.
What I'm going to do, since you're representing so many, I'm going to bring your compliance cases forward at the front. And sir, same with you. We'll take your case first. And then when we get to the potential imposition of fine cases, then they'll come forward, and then MB3 will come forward at the end of this proceeding. Does that work for you?
Thank you.
Okay. Very good. All right. Well, we will start now with the hearing of cases. And our first case, as I said, will be number 11. Well, actually, if you, Ms. Gow, you're lower on the totem pole here, 7. Number 7. Case number 7, SMG 07-22-176, Pelican Bay Sport Club LLC, cited for failure to correct violations of the Land Development Code for property at 350 Pelican Bay Drive. Okay. Do you have anyone here on as a witness to be sworn?
I do not.
Okay. All right. Mr. Jones, can you present your position for the
Yes,
city?
Mark Jones, Neighborhood Services. My credentials are on file. This case opened back in March of 2022 for dirt and grime, unmaintained accessory structures, and peeling paint. First notice was delivered on March 21st, 2022, with compliance to April 21st, 2022. I've had contact with the owner. They have made significant improvements, but they are still in non-compliance. So staff is requesting non-compliance with compliance due next cutoff.
Okay. Ms. Gow?
The property owner's in agreement with the cutoff.
All right. Therefore, in case number 7, SMG 07-22-176, Pelican Bay Sport Club, LLC, I find the respondent to be in noncompliance. In order the respondent to come into compliance by August 3, 2022, or be returned to a hearing before the special magistrate on August 9, 2022, for consideration of a fine of up to $1,000 per day.
No?
All right. Our next case then will be number 11.
Mr. Riggio,
Yes.
I'm just noticing that case number 8 is the same respondent to case number 7. Is that, it's not something?
Different
Okay.
operators.
Okay,
Yeah.
perfect.
Okay, case number 11, SMG 06-22-166, Mark A. and Julie L. Walshagger, cited for failure to correct violations of the Land Development Code at 1700 North Atlantic Avenue. Mr. Yates?
Inspector Yates, Neighborhood Services. My credentials are on file. This case was opened February 9th, 2022, and was part of a seawall walk. The notice of violation was issued for dilapidated seawall and areas of peeling finish. They were first notified February 24th, 2022, and compliance was due March 26, 2022. I've had contact with the owner, but the issue remains, and while a permit was pulled, it was not pulled so that it would cover the repair work. I'd like to ask for a finding of non-compliance with compliance due by the next cutoff.
Okay. Sir?
Yeah, the property is still in noncompliance.
Could you state your name for the
Corey
record?
Brown with Storch Law Firm, 420 South Nova Road, Daytona Beach.
Okay.
Right now, my client's speaking with FDEP, Florida Department of Environmental Protection, to try to get a permit. Not only do we get the permit from the city, but we have to get one from FDEP to work on the seawall. Right now, the last correspondence I saw is it may not be possible to repair or replace it, which I guess that would mean if that's the case, it would need to be removed. So my clients, as Director Yates said, my client has pulled a permit, but it wasn't sufficient. So we have to be able to get a permit from the city and a permit from FDP, depending on whether to replace engineering work and get around the turtle season. So I'm happy for it to be extended. I don't know that a month is enough, considering all the stuff that has to occur as far as permitting before we can even get someone scheduled. So I'd ask for something more 2 to 3 months to get some progress on getting the permits done.
Okay.
That's acceptable.
How many months would you like?
3, please.
3? Okay. I don't believe you can do anything during turtle season anyway if you're doing construction in that area.
And Mr. Riggio, I think the concern for us, and just kind of just to state it here real quick, is that, 3 months is probably an acceptable amount of time frame, but you still got to diligently pursue that during those 3 months, because really in dealing with stuff that's right on the beach, you really kind of need to have everything lined up and ready to go by the end of turtle season so the work can start, because the time frame is pretty short where you can actually work there. So I think that's what we see happens is people kind of kick this down the road till turtle season's over. Then they start the very complicated months-long process of getting the permits finalized, and then by that time, turtle season's about to start again.
Okay.
I mean, we can provide you with updates as far as the progress on this. I know my client really wants to get it done.
Okay.
We can provide you monthly updates or whatever you'd like.
I think, based on what you said here, I think updates to the inspector would just be fine, and we'd agree that 3 months out would probably be sufficient for it to come back.
We'll make sure to jump on this and get it ready to go before the end of the season.
Okay.
Thank you.
So is the city looking to continue this or a finding of noncompliance?
Finding of noncompliance.
Okay. And from what I hear from the city, in 3 months, the expectation hopefully is that you have permits in hand, and as soon as turtle season is over, that you can immediately begin the construction and get it done before the next turtle season starts.
That's the plan.
And there's a very short window there. So your clients will need to diligently pursue these permits. Therefore, in case number 11, SMG 0622-166, I find the respondents Mark A. and Julie L. Walshager to be a in case number, did I say case number 11, SMG 0622-166? I find the respondents to be in noncompliance, nor the respondents to come into compliance by, okay, we're looking in, let's see, we're here, by October 19th, 2022, or be returned to a hearing before the special magistrate on October 25th, 22, for consideration of a fine of up to $1,000 per day. Good luck.
Sir.
October 5th would be the,
I'm sorry, I'm looking at, I have the other set of dates. October 5th, 2022. And you would be returned if you're not complete by then in compliance for a special magistrate hearing on October 11th, 2022.
That sounds good. Thank you,
I
sir.
apologize for that. There are two sets of hearings each month, and I'm looking at the other schedule.
Excuse me, sir.
Okay.
Sir, the attorney, can you repeat your name again, please, for the
Yes,
record?
my name is Corey Brown with Storch Law Firm, 420 South Nova Road, Daytona Beach.
Okay.
Thank you.
that's everything.
Thanks, sir.
Very good. All right. And then our next case will be number 12. Case number 12, SMG 0622-170, ESH Daytona Beach LLC, cited for failure to correct violations of the Land Development Code for property at 1216 North Atlantic Avenue.
For the record, Jessica Gowa, Cobb Cole Law Firm, 149 South Roadwood Avenue, Daytona Beach, Florida.
Okay.
All right, this
Yeah.
case, I'm sorry, ready? This case was opened February 9th, 2022, and was part of the seawall walk. The notice of violation was issued for dilapidated seawall peeling paint and dilapidated steps. They were first notified February 17th, 2022, and compliance was due March 19th, 2022. As of June 1st, I've had contact with the owner, and the owner is currently working with contractors to get bids for the repair. And I'd like to ask for a finding of, can you leave that photo right there? A finding of noncompliance with compliance due by the December cutoff, due to the fact that if you'll notice, there's a turtle nest that's actually directly against there. So they can't start work until October or November 1st. So we'd like to give them to the December cutoff to finish.
Okay. Ms. Gow?
The property owner's in agreement with that cutoff.
Okay. Therefore, in case number 12, SMG 06-22-170, I find the respondents, ESH Daytona LLC, to be in noncompliance, nor the respondent come into compliance by December 7th, 2022, or be returned to a hearing before the special master on December 13th, 2022, for consideration of a fine of up to $1,000 per day.
Thank you.
All right. Now we will go back to taking these cases in their order. We'll start with number 1. Case number 1, SMG 07-22-179, MHP Daytona Air LLC, cited for failure to correct violations of the Land Development Code for property at 620 Brentwood Drive. Sir, we will need you to state your name and be sworn in by the board secretary.
I'm Jerry McKinn.
You said McCann?
McKinn, M-C-K-I-N.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. McKinn, what is your relationship to MHP Daytona Air LLC?
I'm their property manager.
Okay. All right. Mr. Butler, if you can present the city's position on this matter.
Good morning. Inspector Roosevelt Butler, credentials on file with the City of Daytona Beach. As it pertains to 620 Brentwood Drive, this case was a field-generated case. A site inspection was conducted on February the 21st, 2022, where it was determined the property had the following violations: overgrown landscaping, outdoor storage, dilapidated soffit, dilapidated doors, damaged internal walls, exposed wires, an outdated fire extinguisher. First notice was received on February 28, 2022. On March the 30th, 2022, the violation was to be in compliance. Last date of reinspection was June 29, 2022. Result of my reinspection was non-compliant. I've had contact with the property owner. Staff requests non-compliance, compliance next cutoff.
Okay. Mr. McKinn, this is your opportunity to present your position.
Okay, I've cleaned up the place best we can, and I've got a rotor. They're going to do the pull the permits for the sewer line. I had to fix it because the DC's running down the road. It was clogged up. So I went and did what I had to do because they said they couldn't get to it for 90 days. And it's on the paper here, but I paid them. They're started it today, matter of fact. They pull in all the permits. I got Mark's Electric, which we've done,
I'm
cleaned
sorry.
everything else up.
If we may, just 1 second, sir. The facts that you're addressing seem to be the facts that are actually for case 2.
Correct.
I don't know if you were aware that there's 2 cases for this property.
Yes.
The first one that Mr. Butler just presented was related to the building on the front part of the parcel.
You mean the house?
Yes.
Yes.
Yes, I got Mark's Electric pulling the permits. I couldn't go in the place. The people just had a brand-new baby, and it wasn't feasible for us to go in and work on the place. See what I'm saying? So I had to bring Mark's Electric. As soon as they moved out, he went in, estimated it. He's going to pull all the permits for that also. And all of this is being tore out as we speak. The drywall, everything. I got to rip it out so he could rewire the whole place. New windows, new doors is going in.
Okay. Mr. McKinn, is the property currently vacant?
Yes, they left last Friday.
And can you get everything done by August 3rd?
It's possible, maybe. If not, we'll keep working at it the best we can.
Does the city have a cutoff date in mind are you asking for the next
The
cutoff date?
next cutoff, sir.
Okay. All right, well, then, sir, I will set it for the next cutoff. If you run into problems, please be in contact with Mr. Butler and let him know
Yeah.
if you've run into
I've
any
wanted
kind
to
of...
meet him out there a few times already.
Mr. Riggio, Anthony Jackson, attorney for the city. Based on the nature of the violations, I'd ask if you would order as well that it not be occupied until the property is brought into compliance.
It won't be.
Well, I will also order that.
Yes,
just so-
nobody's going to move into it till it's 100%.
Okay. Therefore, I find the respondent, MHP Daytona Air LLC, in case number SMG 0722-179, to be not in non-compliance, in order the respondent to come into compliance by August 3rd, 2022, or be returned to a hearing before the special magistrate on August 9th, 2022, for consideration of a fine of up to $1,000 per day, and furthermore order that the property remain vacant until the violations are brought into compliance.
Yes, sir. Did you want to see this paperwork as well? Okay.
Okay. Next case is number 2, SMG 0722-204, MHP Daytona Air LLC, cited for failure to correct violations of the Land Development Code at 620 Brentwood Drive. This pertains to the plumbing permit, the outdoor storage, and exposed wiring. Mr. Butler, if you can provide the city's
Yes, sir.
position on this matter?
As pertains to 620 Brentwood Drive, this is the parcel. This case was a field-generated case. A site inspection was conducted on February 21st, 2022, where it was determined the property had the following violations: no plumbing permit, outdoor storage, and exposed wiring. First notice was received on February 28th, 2022. On March 30th, 2022, the violation was to be in compliance. The last day of my reinspection was June 29th, 2022. Result of the reinspection was non-compliance. I've had contact with the property owner. Staff requests non-compliant. Compliance next cutoff.
Okay. Mr. McKinn, do you have any problem with that?
What you've seen there is what I had to do to get the sewage flowing, just to clean the place up a little bit where people wouldn't have to stuff. But I hired, like I say, Roto-Rooter. They're doing all the plumbing work, pulling the permits. It's all right here on the paper. And they the one that told me it was 90 days. I didn't know you was filing the other case today. It said the 12th on my paper, the first case.
Okay.
But if it's good, we get them both done now. But Roto-Rooter, they're digging the whole sewer system all the way through and redoing it, pulling the permits, everything.
Okay. It sounds like
just they
you're on the
couldn't get-
right path.
They couldn't do it at the time. That
Okay.
I could be in compliance with everything. But I hired them a long time ago, and here's the paperwork to prove it.
No, that's fine. Your testimony is sufficient.
Okay.
And at this point, again, the August 3rd date, but keep in contact with Mr.
Yes, sir.
Butler if you run into any problem. Therefore, in case number 2, SMG 0722-204, I find the respondent, MHP Daytona Air LLC, to be in noncompliance in order the respondent come into compliance by August 3, 2022, or be returned to a hearing before the special magistrate on August 9, 2022, for consideration of a fine of up to $1,000 per day. Good luck on getting these things remedied.
Thank you, sir.
Case number 3, SMG 0722-191, Sarisha Gadaparty, cited for failure to correct violations of the Land Development Code at 838 North Ridgewood Avenue. Is there anyone here on behalf of Sarisha Gadaparty? The respondent is not present. Mr. Wiggins, can you present for the city?
Mr. Riggio, just before we start, I just want to point out that this is a repeat violation. It's a finding a noncompliance and a potential for a fine as well.
Inspector Wiggins, Code Enforcement, City of Daytona Beach. Credentials on file.
Okay.
Again, this is a repeat violation. This case is a repeat violation that was opened on May 24th, 2022 as a police complaint. This property was in violation for sanitation, rubbish, and garbage, and this is a repeat violation. This property was before the special magistrate on September 8th, 2020, and found in non-compliance. SMG 10-20-141. The case was again before the special magistrate on September 14th, 2021, as a repeat violation once again, and received a one-time fine of $350. After a verbal communication with the owner about these violations, the property was in compliance by the next day. The staff requests a one-time fine of $500.
Okay. Mr. Jackson?
I would say that that would be, sounds a little generous, seeing that it could be a fine of up to $5,000, but it is being escalated as been reported by the inspector.
Okay. And Mr. Wiggins, by the trash, you're talking about all the stuff that's shown in the
Yeah,
picture,
boxes.
boxes and other stuff thrown out. Almost looks like a sidewalk, or is it a building
No.
driveway?
Yeah, it's a drive-through.
Okay.
Yeah.
Okay. All right. Therefore, in case number 3, SMG 0722-191, I find the respondent Sarisha Gadaparty to be in noncompliance, and that this is a repeat violation, and ordered the respondent to come into compliance by August 3, 2022, and to be fined in the amount of $500 due to this being a repeat violation. And if the property is not brought into compliance by August 3, 2022, that it be returned to the special magistrate on August 9, 2022 for consideration of a fine of up to $1,000 per day.
Right.
There would be, I'm sorry, it's on a per occurrence fine, so there would be no reason, I believe, to bring it back before you. It's already in compliance.
It is already in compliance?
Right. It came in compliance the next day based on
Okay.
the inspecers.
Then
Can you give
this
the date
is-
again for him, or Inspector Wiggins? Can you give them the date that it came into compliance?
May 25th, 2022.
Okay. Therefore, I amend my order to strike those provisions relating to bringing the property into compliance as it is already in compliance. But the fine for $500 still is imposed. Case number 4, SMG 0722-173, Daytona Beach Club Condo Association, care of Marlene K. Kirian, Esquire, cited for failure to correct violations of the Land Development Code at 800 North Atlantic Avenue. Mr. Stenson,
Morning.
good morning.
Inspector Stinson, my qualifications are on file with the city. This is a field-generated case. They were cited for outside
Excuse
storage
me.
of junk and debris and lack of dumpster enclosure. Notice of violation was received
Excuse me, Mr.
on
Rizzo.
May
Excuse
18th,
me.
2022.
It's Mr. Stenson?
This one is via Zoom.
Oh, is it?
Yeah, she should Zoom.
Okay. Do we have someone on? I would expect if there is an attorney that is handling this matter, is Marlene Kirian?
I'm sorry, Xavier, I couldn't hear you. You said you do have somebody?
Yeah, he said he's letting her in.
Perfect, thank you.
Mr. Stenson, you'll have to start again once Ms. Kirian
No problem.
hears.
Yeah.
Good morning. Can you hear us?
Yes, I can hear you.
Okay. Ms. Kirian?
Yes, but I do not represent this client anymore. I have not represented them in 2 years. So I do not know why I received this notice. I did forward it to the former client.
Okay, so you're not here on behalf of them?
No, I'm here on behalf of number 16, though, Harbor Beach.
Okay. We are going through these in order, so we'll get to you shortly.
Okay.
So therefore, we don't need, you're not here on behalf of them, so they are not.
That's correct.
The Daytona Beach Club Condo Association, is there anyone here on behalf of them? No. I see nothing, no one. So, thank you. Mr. Stenson, you may proceed.
Inspector Stinson, qualifications are on file with the city. This is a field-generated case for outside storage of junk and debris and the lack of a dumpster enclosure. The property owner received notice on May 18th of 2022. I have received call from the association member, also been in contact via email. They had to get funding approved for the enclosure. Compliance due date was on 19 May of 2022. There have been multiple inspections and re-inspections, the last one being yesterday. The property remains in non-compliance. We're asking for non-compliance next cutoff.
Okay. Mr. Stenson, is there any reason that that material isn't in the dumpster that is right next to it?
None that I know of.
Okay. Therefore, in case number 4, SMG 0722-173, I find the respondent, Daytona Beach Club Condo Association, to be in noncompliance, nor the respondents to come into compliance by August 3, 2022, or be returned to a hearing before the special magistrate on August 9, 2022, for consideration of a fine of up to $1,000 per day. Case number 5, SMG 0722-175, Carson James Waters, Jr., cited for failure to correct violations of the Land Development Code at 1700 North Halifax Avenue. Is anyone here on behalf of Carson James Waters? The respondent is not present. Mr. Stenson?
This is the complaint-driven case at 1700 North Halifax. Property owner was cited for unmaintained landscaping, outside storage of junk and debris, a junk vehicle, and a refrigerator that was maintained outside. I've had one phone call from this property owner. The first notice was received on 23 May of 22. Compliance date was on 14 June of 2022 with multiple re-inspections, the last one being yesterday. The property remains in non-compliance. We're asking for non-compliance by next cutoff. And just as a note, the refrigerator has been moved.
Good. All right. Therefore, in case number 5, SMG 0722-175, I find the respondent, Carson James Waters, Jr., for property at 1700 North Halifax Avenue to be in non-compliance, in order the respondent to come into compliance by August 3, 2022, or be returned to a hearing before the special magistrate on August 9, 2022, for consideration of a fine of up to $1,000 per day. Case number 7, SMG 0722-176, Pelican Bay Sport Club, LLC, cited for failure to correct violations of the Land Development Code at 350 Pelican Bay Drive.
Mr. Riggio, I think you skipped number 6, and we already heard case number 7.
We did?
That was Ms. Gow's case.
Oh, I'm sorry. Case number 8.
No, did we,
I think they're both together, aren't they?
case number 6, I don't think we called yet.
Oh. My apologies. My notes were one off. Case number 6, SMG 0722-189, Total Maker Over Properties, LLC, cited for failure to correct violations of the Land Development Code at 701 North Grandview Avenue. Is anyone here on behalf of Total Maker Over Properties, LLC? I believe we have a respondent present.
Mr. Riggio, there's also a Scrivener's error in that the name of that company, it should be Makeover Properties LLC, according to the property appraiser's site.
Okay. Sir, if you could state your name and be sworn in if you're going to give testimony.
What's your name?
Jean Womel Semexen.
I'm sorry, repeat that, please.
Jean Womel Semexen.
Can you spell your last name for me, please?
S as in Sam, E as in Edward, M as in Mary, E as in Edward, X as in X-ray, A as in Alex, N as in Nelson, T as in Tom.
Thank you. Can you raise your right hand now? Do you swear to tell the truth? Swear or affirm to tell the truth, nothing but the truth?
Yes, I do.
Okay. Mr. Stenson?
This case is complaint-driven from the building department. They were cited for work without permits. Permit R 2203-152 was approved on 6/15, but has not been issued. The first notice was received on 2 May of 22. I've had no contact with the actual property owner. The compliance due date was on 16 May of 2022. Multiple re-inspections, the last one being yesterday. The property remains in non-compliance. We're asking for non-compliance, next cutoff.
Okay. Mr. Stenson, do they currently have the necessary permits to do the work that needs to be done?
The permit has been applied for and approved, but has not been issued.
Okay. So they need to pick up the permit and they need to complete the work?
That's
Would that be
correct.
correct?
Yes.
Okay. Sir?
Can we get this gentleman's relationship to the property?
Yes. Sir, what is your relationship to Total Makeover Properties LLC?
I'm the owner.
You're the owner of that LLC?
Correct.
Okay. Sir, if you could state whatever you want to state at this point in your defense or ask questions.
We when we get the first violation, the permit was in a process, but we had several reviews, so we were doing prep work expecting that we will get approval soon, but the reviews keep going on. So we went to 6 different reviews before they approved the permit. So in the meantime, they asked us to stop working. So we plan on started work again on the 15th of this month.
Okay. Sir, it sounds that the permit has been issued. You haven't picked it up yet.
Correct.
Okay. Okay. Mr. Stenson, they've been cited for doing work without a permit, and they now have the permit. What is the city asking for in terms of
Ms. Ridger, if I could,
remedying this violation?
if I could speak to that. The mere possession of the permit would not be compliance because a permit, the value and the expectation of a permit is that it's completed work so that it has a final review. So it's not in compliance until he has a final review on his permit.
Okay.
Understand. We started work on. We have another property to complete. It's already completed, but we're getting our crew together to start work on the 15th of this month on that property.
Do you believe that you can have the work complete on this property by August 3rd?
No, you will take 5 weeks to complete all the work.
Okay. Is the city asking for an August 3rd compliance date or a later date to allow them to complete the work?
We can allow them to the September cutoff.
Okay. Is that agreeable to you?
Yeah, September 3rd would fine.
Okay. Therefore, in case number 6, SMG 0722-189, I find the respondent Total Makeover Properties LLC to be in noncompliance in order the respondent to come into compliance by September 7th, 2022 or be returned to a hearing before the special magistrate on September 13th, 2022, for consideration of a fine of up to $1,000 per day for the property at 701 North Grandview Avenue. Good luck.
Thank you.
All right, our next matter is going to be case number 8, SMG 07-22-177, Pelican Bay Sport Club LLC, cited for failure to correct violations of the Land Development Code at 110 Gazuk Drive. Is there anyone here on behalf of Pelican Bay Sport Club LLC?
There.
Sir, if you could state your name and be sworn in if you're going to give testimony.
My name is Niraj Datt. Last name is D-A-T-T. I'm the single owner of Pelican Bay Sports Club.
Your first name again, sir? I missed it.
Niraj, N-E-E-R-A-J.
Will you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
All right. Mr. Jones.
Yes, this case opened back in March of 2021 for an unmaintained accessory structure, the tennis court and the fencing, exterior wall deterioration, and exterior lighting. The property was posted on May 5th, 2021. I have met with the property manager, or the owner, numerous times. The fence has been repaired. The concrete has been filled in where the tennis courts were. There was depressions. What still remaining is just the finishing of the tennis courts and the lighting for the tennis courts. Staff is recommending non-compliance with compliance due next cutoff.
Sir, does that work for you?
A couple of things I want to point out first. The previous case number, you had number 7, was also listed as our company, but it's actually a different company. And there's been a confusion from the start, going back since last year. The golf club and the tennis club are 2 different entities. And you can see case 7 and 8, which are 2 different entities, are listed as the same in our.
I had my own questions about that,
Yeah.
seeing that there was counsel for
Right.
one and not for the others.
Yeah. Well, you see, that's one of the challenges is the whole case started where some residents had complained about the golf club, about the pool, and then, code enforcement, Mr. Stetson showed up at our facility and says, hey, you have these, looking around for a pool, and says, oh, well, wait a second, you have some depressions. So when we purchased the facility about a year and a half ago, it was unused and abandoned for the last 15 years. So, and we purchased it, right at the start of COVID, so it's been a challenge getting specialty contractors and repairs and refurbishment and so forth without having the revenue to support it. This tennis facility is not supported by the homeowners association, so it's basically a club within a gated community, but it's a private club. So we've gotten, in the meantime, the permits to fix all the sinkholes, the depressions. It was quite time-consuming because it had to be excavated, replace the drainage, fill it in with road base, and then wait till heavy rains come to see if it sinks more, and then fill it in again. So there was multiple times of filling, and then getting the asphalt was a challenge these days. So last step we have is refinishing or repainting some of the courts. But there currently are courts that are in use. So this court is not in use, but there's other courts in use, and we don't really have the capacity or the members using this court. So that's why it wasn't a priority item. In fact, we were kind of leaving it up to residents and staff, saying that, okay, in case they wanted to, there's not as much demand for tennis, to maybe play shuffleboard or some other games or basketball courts. So that's another reason why we didn't really immediately decide to, repaint that court. We figured, okay, it's safe, it's accessible, there's no tripping hazards, no one's going to fall in a hole. So that's why we kind of left that. Now, the lighting, when we purchased it, we were told that previously, before the prior hurricane, the previous owners had taken down all the light fixtures so that they wouldn't fall down during the hurricane, so they closed and capped them. So at the moment, we are operating from dawn to dusk. There's no overnight play, so we figured, okay, we don't really need light fixtures at this time. We are getting estimates to do that, but, there wasn't, again, a rush to do light fixtures because, it's outdoor tennis courts that can be open dawn to dusk.
Okay. Question I have for the city is, if I hear your testimony, you're basically saying that you want to operate this as a dawn to dusk type facility as opposed to having the lights placed back into those, whatever the fixtures or the supports.
Correct.
Is there something that needs to be amended or changed to satisfy the city so that the city, because I know there are dawn to dusk tennis courts.
Right. So this structure, this property was built in a certain way, and from the code enforcement perspective, it's supposed to be maintained in that condition.
Okay.
And that's the issue that you're running here too. Now, with any property, if you want to make modifications or changes to it, there is usually an application process where you can go through and apply with the city to make those modifications. But for example, it may require, when they go through the application process to remove those lights, it may require that they remove the poles at that time. I'm not sure what those parts would be because you'd have to make that application and kind of go through that review process with the permits and licensing and possibly even the zoning department in some cases. But those are things that need to be considered during that application process. So if that was a modification or a change to the use of the property, then you would just want to come in and make that application.
Okay. Sir, as I understand this right now, the ball is sort of now in your court. This is not, I'm not imposing a fine at this point, but there would be a compliance date. And Mr. Jones, did you ask for a compliance date of August 3rd?
Yes, sir.
And between now and August 3rd, you need to make a decision on how you wish to proceed forward with this. If you're going to have lights, then you need to have them installed. If you're not going to have lights or some of these various things, then you need to make the appropriate modifications and get that in process. But right now, you can't have it both ways.
Yeah, but I understand, but I never heard of having a permit to operate lights versus a permit not operating lights, you know what I'm saying? So if I can understand, okay, if you have a parking lot and there's no lights, well, that's one thing, but if you have a tennis court and it's not open at night, well, okay, is it necessary to light them? I mean, that's kind of strange.
I don't want to be an engineer or anything of that nature, but obviously there is probably electricity running to that pole. And so that in itself poses an issue as to what is the future of that pole.
Yeah, and I
Whether it
understand that.
needs
What
to
I'm
be
saying is,
properly
so-
disconnected or something of that nature.
Right.
And so the ball's in your court right now. All I can do at this point is find you a non-compliance and give you until August 3rd, and you can resolve your issues with Mr. Jones or whoever is appropriate in the building department to get these things resolved one way or another. You either fix them or you modify them, or as Captain Lee said, or modify plans and get all that straightened out.
Okay.
And this is not the place to be discussing that. Those are the individuals.
But the issue is just the lighting then, right? Is that what we're talking about?
Mr. Jones, are there other things that need to be resolved?
What was on the original violation from back in March of 2021 was also finishing the tennis courts and the lighting. Those are the last two remaining items. They have gone ahead and filled in and got it finally stabilized where the tennis courts aren't sinking, but they haven't finished in the sense of getting them resurfaced. I know we had discussed this at one time, and you were trying to work with a contractor to get them refinished so that it was complete. The two violations remaining is the finishing of the tennis courts and the exterior lighting.
Okay.
And then it's really in the same kind of scenario that we talked about before. It was built as a tennis court. It should be maintained as a tennis court unless you intend to modify its use or change it. And it's meeting the minimum requirement of the permit as far as filling in those holes and stabilizing it. That's only the first part. The second part is finishing it off so it returns back to the original design use.
So, sir, this basically comes down to your discussion with the city as to how you want to proceed forward with the tennis court. And doing whatever is appropriate, whether either somehow taking them out of, resolving it to satisfy the city that that tennis court is now either operational or has somehow been taken out of operation in some fashion that meets code and the original, or if there's original plans that they are necessarily modified or whatever, so that you are now fully in compliance. And that's a question between you and Mr. Jones and the building department and trying to work all of that out.
Okay.
And again, you have until August 3rd to get all of that resolved.
Okay.
Okay.
And Mr. Riggio, if I could ask as well, no, we already handled number 7, and I'd ask if we'd be able to come back to it afterwards. But if Ms. Gao have any difference of opinion as to the definition of ownership, if she could address that, that may help us in terms of if they have any disagreement there.
I think it was just a typo. Item 7 should have been Pelican Bay Golf Club, but we received notice. We're here. We're working on it, so it's no big deal. It's just a typo.
Okay.
And I did confirm in the case file that these cases, the notice is still with the proper address, and only case 7 was the one where the scrivener's error for the name of the LLC occurred.
Okay. All right, therefore, in case number 8, SMG 07-22-177, I find the respondent Pelican Bay Sport Club LLC to be in noncompliance, nor the respondent to come into compliance by August 3, 2022, or be returned to a hearing before the special magistrate for consideration on August 9, 2022, for consideration of a fine of up to $1,000 per day for property at 350 Pelican Bay Drive.
110 Go Shark Drive.
No, Neil.
Oh, I'm sorry. 110 Gozuk Drive. All right. So are you here also for the next one, case number 9? SMG 07-22-178 Pelican Bay Sport Club LLC, cited for failure to correct violations of the Land Development Code are at 110 Gozuk Drive. Okay.
Yes, this case was opened on April 26, 2022, for work without permits. They completely resurfaced the total parking lot without permits and had not yet striped it. First notice was received on May 3rd, 2022, with compliance due May 19th. I've met with the owner, but as of today, there has not been an after-the-fact permit submitted for the work that was done. Staff is recommending non-compliance with compliance due next cutoff.
It looks like it's paved and it's striped. They just
Well,
need the
it's paved
permit
and they
an
have-
inspection.
Well, it was paved without a permit, and they have 5 stripes done.
Okay.
But that all requires a permit for not only resurfacing, but then the parking layout.
And then it would be inspected at that point for compliance with the permit.
Correct, that would be the building department.
Okay. Sir, you're here on behalf of
Yes.
Pelican Bay Sport Club again?
Yeah, yeah. It was actually the contractor who was, going back to the tennis courts. He said that, that was too small a job, so he wanted to do the parking lot also at the same time, and told us since it was an existing parking lot that we didn't need a permit, but then we found out from Mr. Jones here that you need a permit. So we told him, hey, hold off on that and file the permit. Then we found out that I guess he couldn't obtain the permit because he was from Orlando or out of town. So now we're having a little difficulty finding another contractor to take over the job. And we had told him to stop striping because he was not doing it correctly to the requirements.
Okay.
So that's why the striping was halted. So it's, still needs the striping and still needs the plans. I have brought in the permit application survey and striping plan today, so hopefully I can get it filed with the city. We'll see what happens with that.
That's nothing we can resolve
I know,
today.
of course.
And again, I will give you until August 3rd to get this resolved.
Okay.
And hopefully you can get somebody to get the permits and the plans, get inspected, and be done.
Good.
Okay. Therefore, case number 9, SMG 0722-178, Pelican Bay Sport Club, LLC. In case number SMG 0722-178 for property at 110 Gossack Drive, I find the respondent to be in noncompliance, nor the respondent come into compliance by August 3, 2022, or be returned to a hearing before the special magistrate on August 9, 2022, for consideration of a fine of up to $1,000 per day.
Okay.
Good luck.
Ms. Ritchie, I don't know if you feel it necessary to recall Ms. Gow on number 7, just to acknowledge the scriveners, or are we sufficient?
Ms. Gow, if we could recall you on case number 7, SMG 0722-176, Pelican Bay. It's on the agenda as Sport Club LLC, but if my understanding, the proper name of this is Pelican Bay Golf Club LLC?
That's correct.
Okay.
And it is LLC?
Yes.
Okay.
I'm saying we will stipulate on the record to receiving notice. So, yep.
You received notice,
Yep.
and you're recognizing that my order in that case number 7 was being issued to, and I would amend that to Pelican Bay Golf
Correct.
Club LLC.
Absolutely.
Okay, thank you.
Thank you.
Case number 10, SMG 0622-164, Doran Nissim, trustee, cited for failure to correct violations of the Land Development Code at 1915 North Atlantic Avenue. Is Doran Nissim present? There is no response. Is there any Doran Nissim appearing by Zoom? No, okay. Mr. Yates, the respondent is not present.
All right. This case was opened January 26, 2022, and was a citizen's complaint. The notice of violation was issued for unpermitted work to the electrical, mechanical, demo, and window systems. They were first notified February 24, 2022, and compliance was due by March 26, 2022. I've had contact with the owner, but the issue remains. I'd like to ask for a finding of noncompliance with compliance due by the next cutoff.
Okay. Therefore, I find the respondent, Doran Nissim, trustee, in case number SMG 0622-164 for property at 1915 North Atlantic Avenue, to be in noncompliance in order the respondent come into compliance by August 3, 2022, or be returned to a hearing before the special magistrate on August 9, 2022, for consideration of fine of up to $1,000 per day. Okay, our next case is number 13. Case number 13, SMG 0722-185, 1825 Brentwood Road, Inc., cited for failure to correct violations of the Land Development Code at 1541 South Ridgewood Avenue. Mr. Yates?
This case was opened May 24, 2022.
Excuse me, we have someone coming up.
Sir, if you could state your name, and if you're going to give testimony, be sworn in.
Okay, my name is John Sobel, District Manager for Dollar Tree. Capital S-O-B-O-L.
Can anyone hear me? Kate Cooper, also here on behalf of respondent.
Can you repeat the spelling of the last name again, sir?
S as in Sam, O, B as in boy, O-L.
Okay. We also have someone present on Zoom on behalf of the respondent. If you could state your name, please. I didn't.
Yes, thank you. Good morning, Kate Cooper. I'm counsel here on behalf of the respondent.
Cooper, okay.
Sir, can you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay. Ms. Cooper, just so you're aware, we're here on a compliance, non-compliance proceeding. There's no fine being levied today.
No, this is a repeat violation.
Oh, is it a repeat?
Yes.
Okay.
So we will seek a fine today.
Okay. I withdraw my statement regarding that. Mr. Yates, can you present for the city?
All right, this case was opened May 24th, 2022, and was part of a police complaint, and this is a repeat violation. The notice of violation was issued for trash and rubbish accumulation. The property was posted originally on September 14th, 2021, and compliance was due by October 6, 2021, as part of SMG 0921-267. I have had contact with the owner, and the violation was not corrected until July 11, 2022. We'd like to request a one-time fine of $500.
Okay. And if you could just show it says trash and rubbish accumulation.
Yes, they had some tires in the parking lot for about 2 months, and then along the fence line, you can just see they had some of that rubbish and debris.
I see the tires.
Yeah.
I see the trash.
Yeah.
It is now completely cleaned, and I have pictures here showing it. I was there personally doing it yesterday.
Okay. Ms. Cooper and Mr. Sobel,
Yes.
if you can state your position regarding, you heard what the city is asking for.
If I may,
Go ahead.
if I may, Magistrate, I have been in communications with Mr. Sobel. The origins of the debris, it seems, come from a homeless camp that's been on the property. The respondents have been trying to get the property cleared. They've hired a vendor who had to come out 3 separate times to clear debris. They weren't as effective, perhaps, as we had hoped each time that they went to the property to clean it up. And as Mr. Sobel indicated, store employees and actually him himself went out there yesterday, cleared the debris. I understand they took out 12 bags of trash. So we'd request that the city consider a reduced fine.
Okay.
Would you like to see the pictures that I took yesterday?
Do you have pictures that you
Yes.
can show us?
Yes.
And the property is now in compliance.
Okay.
I would point out, as I did in the prior case with trash and debris, that it is generally for us an escalating fine. The $500 is a very generous fine in itself, in that the maximum fine for repeat violation is $5,000. And what we just hope is that they stay diligent in keeping up with it, of course, and addressing whatever complaints may come their way.
Well, may I state that we have had the landscaping people come out and make significant improvements to the property. Along the north fence line is starting with Ridgewood Avenue. There's been a homeless kind of hangout where most of this debris has been accumulating. And it goes, yes, you can see right there in that picture. As it goes along the fence line towards the street behind it, that's kind of where we've had an issue. So we've had a landscaping crew come in and cut down some of the branches, places where they can hang out to kind of deter them from returning. As a matter of fact, they're there right now finishing the job. But that has been our biggest concern, is trying to prevent the homeless people from being attracted to that location, because it is shady. And there's a bus stop on the other side, right there on Ridgewood Avenue, that they use for transportation. And I do have pictures that show that we have cleaned everything up, and we have removed some of the smaller bushes and shrubs that are in the front of the store where things tend to get thrown and hidden as well, and replaced it with mulch. So there's been a lot of improvements done in the last few weeks.
If I could make 2 recommendations just to kind of help out. The first one would be, before you leave, to get Officer Lamp's contact information. This officer right here. He can come down and kind of give you a septet analysis of the property, kind of tell you what environmental design issues you could kind of adjust. Sounds like you've done a lot already. I will tell you that properties that are this transitory, where you have a lot of people coming and going throughout the day, we do find that it really takes having a staff member routinely come out and do it on a daily basis. It's not something that usually a landscape crew once a week or even every other week can keep up with. And just that's just the two pieces of advice I can give you.
Thank you.
Is the property currently occupied? Or is it looks like a bank building. I see
Well, it was a
drive-through.
former CVS or Walgreens record, something like that. It's now a Dollar Tree.
Oh, it's a Dollar Tree.
It's the Dollar Tree right at Bellevue and Bevel and Ridgewood,
Okay,
right down at that corner.
all right. And question on the timing. I see that the respondent was first notified on September 14th of 2021. Do we have a date for when, or do you have a date for when the property was brought into compliance?
Yeah, 7/11/22, July 11th.
Well, no, we had a code enforcement hearing last year and were cleared last year.
Oh, you mean from the original? No, I do not have the original hearing compliance date.
Do you, I think I think the confusion is we have the first notified as the first notified from the previous case. What was the first notified for this occurrence, this new case?
I don't have that in front of me.
I have the citation. Is that what you're looking for?
Yeah,
I can tell you when it is.
I can probably find it here in just a moment.
Okay.
I have a citation here. Let's see. Dated, bottom says dated on June 20th, 2022, that we have the citation. Yeah, that's what I have on here as far as the notification.
And
I'm sorry, just one.
Yeah, there's one before that.
I think the visit was in May sometime.
Yeah, that's when we did the site visit after we had,
I don't have the date that it was received, but I can tell you that the notice making him aware of it would have been the 23rd of May, I'm sorry, 24th of May of this year.
okay. And when was the site brought into compliance?
July 11th.
Okay.
That's, I think, an additional point to what Mr. Jackson was saying earlier. $500 is a pretty gracious request, considering that it took several days to come into compliance, and really the city could be asking for an occurrence for every one of those days, but we're not in this scenario.
Okay, it's looking to me that it took almost a month and a half to come into compliance from the 24th of May when, give or take a few days for mailing and everything. So therefore,
If I may. Just as a couple additional factors I'd ask the magistrate to consider is that Dollar Tree is and has remained a essential business open throughout COVID. When the first notice of violation was issued in October, it was done right at the beginning of the holiday season. Not trying to make excuses, but there have been some logistical considerations in terms of supply chain shortages and the vendor issues that we sort of experienced in trying to get a vendor out there and trying to get the property compliant.
well, I fully understand the issues for last year, but we're now dealing with this year from May 24th to 22nd of May until July 11th to basically remove a couple of tires and various trash and things that could have easily been disposed of by just an employee walking out in a parking lot and taking those things and throwing them in a dumpster or properly disposing of them.
Unfortunately, it's not quite as simple as that because it continues to be a place where the homeless people congregate. That's why we've had to have landscaping come out and we'll have pictures because we actually cleaned it up, part of it on Thursday. And yesterday when I went back out there, there was a homeless clothing and drug paraphernalia and It just keeps coming back.
Well, I understand that, but if I understand correctly, what Mr. Yates observed on May 24th was not removed until July 11th.
Correct.
And that has nothing to do with people bringing new stuff or anything. That is stuff that just stayed there for a month and a half and could have been removed. And I understand your situation that you may be dealing with folks who are bringing new stuff, but I suspect that if we were here arguing about new materials being brought as opposed to existing materials that's sitting there for a month and a half, you would have a much different argument at that point. And I'm seeing the fact that the materials remained there as a month and a half before they was finally, and I know you're taking steps now to keep from having this occur in the future, but I still see that action should have been taken more quickly to basically bring this matter to a resolution. And you really didn't need to be here. If someone had gone out and immediately responded, this matter wouldn't be here today. So the fact that fact, and it, also relates to this, is that there should be some benefit for taking quick action, and there should also be some, I hate to say punishment for languishing and not taking immediate action. So therefore, in case number, do you have anything further to say, Ms. Cooper?
No.
Okay.
Thank you for your time and attention.
All right. Therefore, in case number 13, SMG 07-22-185, for a respondent, 1825 Brentwood Road, Inc., property at 1541 South Ridgewood Avenue. I find the respondent to have been in non-compliant of the Land Development Code, Article 9, Section 9.2.A, for the property at 1541 South Ridgewood Avenue, and have subsequently come into compliance on July 11th,
Yes.
2022, and hereby order that respondent shall pay a fine in the amount of $500 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to, is this a $15,000 or
It's $5,000.
$5,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
Thank you.
Case number 14, SMG 07-22-200, 1405, 1431 South Atlantic LP, cited for failure to correct violations of Land Development Code at South Atlantic Avenue, parcel number 531601000011. Is there anyone here on behalf of 1405, 1431 South Atlantic LP? Gentlemen, is there anyone on Zoom? No. Thank you. The respondent is not present. Mr. Bostwick?
Good morning, Inspector Bostwick, Neighborhood Services, credentials on file. This case was opened on February 15th of 2022 on part of a seawall walk. It was open for peeling paint, loose material on seawall. First notification was on March 14th of 2022. Compliance was due by April 15th of 2022. Last day of reinspection was July 7th of 2022. Result, noncompliance. I've been in contact with a local representative of the company. Staff requests a finding of noncompliance with compliance due next cutoff.
Okay. Well, the respondent isn't present, and that seems reasonable. It appears, Mr. Bostwick, though, that you may have to discuss with them the fact that they are now moving towards the potential for imposition of a fine, and they also, being on the beach, are going to have to deal with obtaining proper permits, both, I take it, local and state. So they have some work in front of them. So therefore, in case number 14, SMG 07-22-200, respondent being 1405, 1431 South Atlantic LP for property at South Atlantic Avenue, parcel number 531601000011. I find the respondent to be in noncompliance, nor the respondent come into compliance by August 3, 2022, or be returned to a hearing before special magistrate on August 9, 2022, for consideration of a fine of up to $1,000 per day. Case number 15, SMG 0722-201, 1405, 1431 South Atlantic LP, cited for failure to correct violations of Land Development Code at South Atlantic Avenue, parcel 5309, 39000070. Is anyone here on behalf of 1405, 1431 South Atlantic LP? There's no respondent present. Mr. Boswick?
All right, this case was opened on February 15th of 2022 during a seawall walk for dilapidated accessory fence, peeling paint on the seawall, loose material. First notification was on March 15th of 2022. Compliance was due by April 16th of 2022. Last day of reinspection was July 7th of 2022. Result, non-compliance. I've had no contact with the owners. I've spoken to the local representatives. Staff requests a finding of non-compliance with compliance due next cutoff.
Okay. Therefore, in case number 15, SMG 0722-201, 1405, 1431 South Atlantic LP, for property at South Atlantic Avenue, parcel number 5309-39000070, I find the respondent to be in non-compliance, or the respondent come into compliance by August 3, 2022, or be returned to a hearing before the special magistrate on August 9, 2022, for consideration of a fine of up to $1,000 per day. Case number 16, SMG 0722-202, Harbor Beach Resort Watson Association Management, cited for failure to correct violations of Land Development Code at 701 South Atlantic Avenue. Is anyone here? Sir, are you here on behalf of the respondent? We have several people here on behalf of the respondent.
Marlene Kirtland-Curian on Zoom, Your Honor. I'm the attorney for the association.
Okay. Could you state your name again, please?
Marlene Kirtland, Kirtland, Curian, Kirian.
Okay.
With South Millhausen,
Okay.
1000 Legion Place, Orlando, Florida, 32801.
Okay. There's a gentleman present with you on the Zoom.
Yes, Your Honor, that's Mike Hall. He is the president of the association.
Okay. And there's a gentleman present here.
My name is Christopher Petralia. I'm the on-site licensed community association manager. I've been in contact with Mr. Boswick regarding this case.
Okay.
Can you state your-
If either of you gentlemen or both of you intend to give testimony, you will need to be sworn.
Can you repeat your name again, sir?
Christopher Petralia, last name Petralia.
And the gentleman on Zoom, your name is Mike Paul?
Mike Hall, Hall.
Okay. Can you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
I will.
Okay. Mr. Bostwick.
All right, this case was opened on February 11th during a seawall walk of 2022. Property has rust and corrosion, peeling paint, loose material on the seawall, cracks. First notification was on February 17th of 2022. Compliance was due by March 20th of 2022. Last day of reinspection was July 7th of 2022. Result of reinspection was non-compliance. I've had no contact with the owners directly. I have spoken many times with email, phone conversations with Chris from Watson Realty. Staff requests a finding of non-compliance with compliance due next cutoff.
Okay.
Your Honor, on behalf of the association, they have hired an engineer who is in the process of doing specs for the seawall, and will be getting a general contractor hired in order to fix the seawall As you're aware, it is turtle season, so anything with regards to fixing the seawall would not be able to be done until after the November 1st deadline. However, the association is aware of the problem, has hired the engineer to address the issues, and is in the process of getting the specs as well as general contractors.
Okay.
The city would ask that, you just diligently pursue, like we discussed in the other cases, diligently pursue obtaining every approval and permits you need before the end of turtle season so the work can be done in that small window of time when it is able to be completed, and that you keep the inspector up to date with your process as you go through.
We can do that. We can have the management company reach out to the general contractor. I will be reviewing the contract and inform them to try to get the permitting as soon as possible so that they can have that fixed during that portion when turtle season is not in effect.
I think on this particular case, I think we'd like to do like the other one, an October cutoff, so that we can make sure all those things are in place prior to the turtle season completing, and hopefully we'll be able to amend it for whatever timeline they have at that point, if needed.
Okay.
We're in agreement with that.
Okay. Keep in mind that your state permits move much more slowly because you also have a time period for people to object to state permits. I believe it's 21 days, so your permit's not really official until you have gone through all of the hoops and hurdles, which means you need to get started early so that you can be ready to roll once turtle season arrives. All right.
Yes, Sean.
Therefore, case number 16, SMG 07-22-202, the respondent being Harbor Beach Resort Watson Association Management for property at 701 South Atlantic Avenue. I find the respondents to be in noncompliance and order the respondents to come into compliance by October 5th, 2022, or be returned to a hearing before the special magistrate on October 11, 2022, for consideration of a fine of up to $1,000 per day. Good luck getting your permits.
Thank you.
Case number 17, SMG 06-22-157, Robert P. Klink, cited for failure to correct violations of the Land Development Code, Street, parcel number 533932000010.
Morning.
Good morning.
Larry Hughes.
Are you here on behalf of Mr. Klink?
I am, and Mr. Clank is here. Mr. Order is here.
Okay. Is Mr. Klink or his daughter going to give testimony? If so, they will need to be sworn in.
I don't think so, but they probably should be sworn in anyhow.
Okay.
Ma'am, what's your name?
You need to come more.
We'll just need you to step up to the microphone. Can you say it into the microphone?
CHAR, then the state of Maine, Clink, Findley, Findley.
I'm sorry, the last part was
Robert Blank.
Findley.
Finley. Okay.
All right.
It's Robert Clenk, K-L-E-N-K.
Yes, sir. I got you. Will you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you.
All right. Ms. Kirk, can you present the city's position?
Good morning, Sarah Kirk, Inspector with the city. My credentials are on file. This is a complaint-generated case that was opened on February 24th of 2022 for no business license for the 2021 to 2022 business year, parking on an unimproved surface, vacant parcel, no appropriate development permits, heavy equipment sales, rental, or storage. First notification was March 18th of 2021. I have had contact with the owner. I re-inspected the property on July 8th of 22, non-compliance. Staff's requesting an order of noncompliance with compliance by the next cutoff.
Your Honor, this
Mr.
is not
Hughes?
this is not a simple case by any stretch of the imagination. I have been involved with this property probably for the last 12 years, maybe longer, with Mr. Vukelja, with the Code Enforcement Board. We had hearings back in 2009. I have a little pack. May I approach, Your Honor?
Sure. Thank you.
We had hearings back in 2009 regarding this particular parcel, and I've highlighted the appropriate sections on the notice of violation where there is a violation of an occupational license. I've also attached an affidavit of compliance, which would be the last page in the exhibit, which again shows compliance, and it's signed by Daniel Garcia, a code officer inspector. Your Honor, what happens with this property? This is a large tract of property, and it's several parcels that are located together that have always been treated as a group, as you'll notice by the notice of hearings and the case numbers. It's our position that we have an occupational license, but I think that this is going to require a fairly extensive hearing. I would anticipate it would run between 3 hours and 4 hours. So I would suggest that perhaps we special set this before Mr. Vukelja, who has he and I have had an ongoing history with Mr. Jackson on this particular file. It's our position that we are in compliance with an occupational license. And it's their position that occupational license applies to a specific address and not to the overall group of parcels. So this is not a simple issue. It's also our position that the appropriate remedy in this is a $250 fine at maximum. It's a one-time fine, not a continuing violation pursuant to the code.
So I need some clarity if we can. My understanding was that you are already seeking to remedy this situation with other city departments, is my understanding, and that.
I'm sorry,
I'm
go
sorry,
ahead. Sir.
just-
Go ahead.
So I'm a little confused on, if you're contesting, are you contesting that the compliance versus non-compliance?
I do not.
I should say, I'm sorry, before you answer, the issue prior, Mr. Riggio, was that we brought a case before related to this property. Upon staff review, we realized that we cited just simply the business tax requirement, and as a result, there was a one-time fine of $250 that was assessed. We went back in, conducted some more research about the property and the case as it is, because we have numerous complaints from neighboring folks. And as we looked into it, we discovered that there was just a process that wasn't followed with the city. That process would be a combination of things, but it would go through a TRT process, a review process, and they would either have to combine the lots together for the use to extend to those lots, or there would be some kind of overarching document that would give them some type of approval through that planning process that would alleviate this, but that has never been sought or recorded anywhere, and as a result, that's what this citation is related to.
And Ms. Charmaine will testify that she attempted to combine the lots, and the city refused to sign an affidavit that would be required by the property tax assessor. So that's why the lots were not combined, because you guys refused to sign an affidavit.
Nevertheless, I guess they weren't combined. Mr. Riggio, Anthony Jackson, attorney for the city, and Mr. Hughes is right. I'm well aware of the history and been part of the history even beyond Ms. Vukelja and the other boards that Mr. Klink have gone before, as we've dealt with his properties over the years. I don't know, have any thought that would need a 3 to 4 hour hearing, but I don't know if the staff have any thoughts on this, a special hearing. If the issues go beyond just the business tax license. If that was the only thing, he's right, we would only be talking about a $250 fine or fee, and we've addressed that at the previous proceeding. Obviously, well, not obviously, but he remains in non-compliance with that, and that's why it's recited. However, in addition to that, there's other things that have to be accomplished, which, as Captain Lee expressed, we thought they were working on, and we were appreciative of that they are working on it. So I'm not quite sure why we're in such a state right now. We would allow them, I think, the time to continue to work with the other city departments. That's what our anticipation was, and we think that's reasonable. We realize it has some elements, at least from their perspective, and maybe rightfully so, it has some elements of complications that have worked itself through the years, and so we understand that. And so we're allowing them to get that all figured out through the departments that's necessary to get those things worked out.
This is a business that's been operating for 30 years and substantially on this location the same way. And they're looking now to make us jump through all hoops, put in paving, engineering, surveying, probably handicap spots, and we've been operating.
I assume that you are going to claim that there are a lot of non-conforming issues involved here.
Oh, yeah.
I am involved in a matter in another city with a very similar property, and I think Mr. Hughes, I know, is probably correct in terms of the amount of time this is going to take. And Mr. Bukelja has past history on this, and it kind of puts me at a big disadvantage if I have to learn all of that, because Mr. Hughes would have to educate me on his client's arguments, and you would have to educate me on why you feel perhaps those arguments are not appropriate. And these may be things that Mr. Bukelja has already been through and may have a better idea on this. And I'm inclined to agree with Mr. Hughes that these types of situations are probably dealt with, and it's going to take some time at this point. And so I would rather continue this matter as opposed to making a finding of compliance or non-compliance until the August 9th.
Can I suggest that we just special set it and just order that a special set and have staff coordinate with my office?
If the intent is for them to challenge the compliance and non-compliance, I think city would also agree that a special meeting would probably be.
Yeah, and if you could just coordinate with that with my office, I'm not looking to delay it for a long time. I'm just saying it's not fair to these folks.
Right.
Oh, yeah.
I agree.
We
Yeah.
agree with that, and obviously we can't do it this moment because we will not know Mr. Bukelja's schedule or any of those things, so we'd be happy to make sure that happens.
Okay.
Okay.
Then what I would like to do is to continue this to a date that is agreeable between the parties, but we do have to set some kind of outer limit so that the matter does ultimately get determined. Otherwise, I can't have an open-ended.
So a later date prior to August 31st?
It would need to be probably around August 31st. We'll be on until towards the end of August.
That's fine, August 31st.
Well,
And I know that's not the date we're setting it sometimes.
that's the outer date, so if you're.
Why don't we do September 10th?
Okay.
That's
Yeah.
fine with me.
Okay, that's fine with me also. We'll coordinate a date.
That's, okay, it's the outer date, fine.
Yeah.
Sometime between now and then, we've got to figure this out, as far as setting a date.
And hopefully whatever they're working with the other divisions, that they continue that, and
Okay,
maybe
perhaps,
that can help resolve
perhaps
some things.
Mr. Jackson and Mr. Lee and Captain Lee should meet sometime. I'll try and coordinate that, sir. I'll get your card before I go.
Okay.
Good.
Okay, have a good day, folks.
Therefore, in case number 17, SMG 06-22-157, respondent Robert P. Klink for property at Marion Street, parcel number 5339-32000010. I hereby order that this matter be continued for a hearing to occur at a time agreeable to the parties on or before September 10th. 2022.
Does your order include that if that doesn't occur by then, that it would be brought back before the magistrate in October?
I can add that
the
to
next
it.
available.
And if the matter is not, if a hearing does not occur on or before September 10, 2022, then the matter will be brought back to the first available special magistrate hearing that should follow that date.
Thank you.
Mr. Hughes, is that okay with you?
Yes, sir.
Fine.
I may be on the next one, too.
Oh, okay. This is, okay. Case number 18, SMG 0722-192, Alonzo Emil Dotel, cited for failure to correct violations of Land Development Code at 536 Park Drive and 583. I assume that's Park Drive.
There's a gentleman on Zoom, Michael Alversano. I believe he just popped up.
Okay.
And he is also on a case which is later on the docket, I believe, and I had it flagged, I believe it's case number 58, and he asked that both of them be heard together because I represent him on that other case.
We're hearing case number 18 right now. Is this number 58 or number 18?
This is 18, and the other case is 56. It's the same person.
Okay.
That's why we're asking to be heard together, if that's possible.
Does the city have any objection to that?
I don't think we'd want to combine the cases.
We're not combining them.
But yes, we have no problem if they want to be heard right one after
You're
the
saying,
other.
can we, I'm sorry.
I'm just saying, he can hear his one that's the 15, but then I'd like to do my 56 while he's here.
Oh, that's absolutely okay with us.
Okay.
That's okay with this request.
Do you mind if I stand here? I'm not on the first case.
Okay, you're not on the first case.
We got
Okay.
you.
This is, just so we're clear, this is case 18, SMG 0722-192, Alfonso Emil Dotel, cited for failure to correct violations of the Land Development Code, 536 Park Drive and 583. And there is a gentleman on Zoom. Is that Mr. Dotel? Or-
No, sir.
Yes, sir? No?
I'm just giving you this just
No.
to see what we're doing.
Is Ms.
Michael Alversano on Zoom.
Okay. Is anyone here on behalf of Mr. Dotel? Oh, you are on behalf of him?
Yes, sir.
And in what capacity are you on behalf of him?
I am one of the property managers for him.
Okay. Then if you're going to give testimony, can you be sworn?
Yes.
Okay.
Can you state your name, please?
Michael Dennis Abrasano.
Will you raise your right hand? Oh, you already had it.
Sorry.
It's okay. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Thank you.
All right. Ms. Kirk?
Okay. This is a tenant complaint generated case that was opened on February 2nd of 2022. Site inspection revealed defective plumbing, unpermitted plumbing, damaged interior surfaces, and exposed electrical. The first notice was February 5th of 2022. On a reinspection on June 1st, 2022, I observed other unpermitted work. So on June 1st, I posted an updated notice with a compliance date of June 9th. I reinspected the property again on July 1st, non-compliance. Staff is requesting an order of non-compliance with compliance by the next cutoff.
Okay. Mr. Alvitano?
Abrasano and Michael, please. Thank you, sir.
It's your turn. Do you have anything to say?
Yes, Your Honor, Magistrate. We're received the notices. We did hire people to do the work, and unfortunately, being we're in Miami and the properties are up there, we didn't get very far. They were all done incorrectly, and I apologize for that. We've hired GC to go out there, do an after-the-fact permit to take care of everything, and we believe everything will be done by 7/25.
Okay. Is there open electric on the property?
There is, on the interior, the 538, which I have not re-inspected, there is a light fixture that was exposed where the roof was leaking right there.
Okay.
So that would be the electrical. I did want to mention one thing. On June 1st, when I re-inspected, I found new violations, which new windows were installed and one window was blocked out completely. I didn't state that.
Okay. All right. Well, Mr. Alvitano, if you have a new GC involved, it would appear that your GC needs to coordinate with Ms. Kirk to make sure that you are getting all the proper permits and approvals from the city. But if that's going forward, then you would be on the right track. Today's hearing is simply a finding of noncompliance, and I think that's pretty obvious that there is noncompliance. And the city is asking that you be given until August 3rd to wrap those up.
Thank you.
And if you testified, you, excuse me, you hope to be done by July 25th, that shouldn't be a problem. But if you do run into problems, contact Ms. Kirk and keep her notified.
Yes, sir. Thank you.
All right. Then therefore, in case number 18, SMG 07-22-192, Alfonso Emil Dotel, for property at 536 Park Drive and 583. I find the respondent to be in non-compliance, nor the respondent come in compliance by August 3, 2022, or be returned to a hearing before the special magistrate on August 9, 2022, for consideration of a fine of up to $1,000 per day. Okay. Now, Mr. Hughes, you have another case
Yes.
with this gentleman?
Yes, sir.
All right. And that's 56?
Yes, sir.
All right. So why don't we move to 56 quickly? Case number 56, SMG 10-21-285, Kasi Investment LLC, and Emil A. Dattel and Miriam P. Aversano, cited for failure to correct violations of the Land Development Code at 612 George W. Ingram Boulevard.
My name is Barry Hughes, and I represent the respondents, Mr. Dotel and Ms. Aversano.
And my name is Sarah Geltz, and I represent the respondents, Cosi Investment.
Are you an attorney?
Yes.
Okay.
With the Law Group in Maitland, Florida.
Can you spell your last name?
BELTZ.
Thank you.
All right. Mr. Jones, can you state city's position?
Yes. Since the last hearing on April 12th, 2022, I've had no contact from the owner or any of their representatives. There's been no application submitted for a parking area, which was part of the violation, and the other part of the violation was junk vehicles on site. Those are still there and have not been removed. Staff is recommending a fine of $200 a day with a cap of $20,000.
And when would you like the fine to start? Would it be today's date?
Yes, sir.
All right. All right. Do you have anything further, Mr. Jones?
No, sir.
Okay. Mr. Hughes?
I don't know who'll go first, so I'll go first. I was present at the last hearing, and there was finding of noncompliance. The hearing was set for today's date to determine, to impose a fine, but the reality was to determine what progress had been made in trying to resolve this particular case. At the time of the last hearing, I had advised the special magistrate that we had retained an engineer, Zahn Engineering, to complete it, and that we were going to go forward with the progress. Unfortunately, funding has become a significant issue. My client had made a claim against the title insurance company regarding some issues with regard to deeds, which was coverage was denied. However, there is Chicago Title has indicated that it's going to accept responsibility for renovating the parking area to bring it in compliance. This case is particularly complex, and Ms. Geltz can probably give a better history than I can because she's been involved for a lengthier period of time. But my client purchased the property aware that there was a lien against the property, but was not aware that there was an ongoing problem with regard to compliance. And that has been a source of contention between my client and Ms. Geltz's client. But but in reality, this hearing was set to determine progress. Now, I did receive from my client a letter from Chicago Title dated June 15th, and if Your Honor doesn't mind, I'll approach.
Sure.
And I highlighted the appropriate sections of this letter. I'm not sure if it's Kelsey. You have that? Oh. Okay, I'm going to show Ms. Geltz this too, I'm sorry. But it's indicating, you know, as I indicated before, the financing was the problem. It's because what the city is requiring to happen is that they do a site plan, which requires engineering, which requires a survey, which requires figuring out the drainage, figuring out the handicap, figuring out the landscaping. And that became I've already shown it to Mr. Jackson, so he's showing it to Mr. Scott, I believe his name is.
Captain Lee.
Wasn't even close.
Scott Lee.
Okay. But in any event, that seems to be the progress where we've now got in place the funding for the renovations. So I would suggest that we continue this for a period of 2 months so that we can coordinate with Chicago Title. Now, where I think because I got an email this morning from Chicago Title at, it was while I was driving over here, as a matter of fact, so it was probably around 10 of 9, indicating that they are going to cover it, but they were looking at an invoice that my client had sent to them back in probably March for $30,000. And that, I don't think that invoice, it was a general contractor saying this is what it's going to take, but it wasn't the general contractor coming in and saying, well, I've gone through the steps that I know the city's going to require, so I think it's going to be more than that. I need to make sure that they're aware of that, and I have not had a chance from 8:50 today till now to get that across.
Yeah.
I'm sorry I speak a lot.
Mr. Jackson.
Mr. Riggio, we're looking at 56, right? And I guess, Mr. Hughes, things become complicated that don't start complicated.
My cases do seem to be a little bit more involved.
Yeah, for what they were cited for, I don't know if we need all of that. However, we never want to stop a whole bunch of good progress if that's what they're working on. Well, the promises that I've seen through the response from the title company looks like they're trying to make improvements. My conversation with staff is that we're willing to allow them the time if that's all of the stuff they're trying to do, recognizing that what they're cited for is, overgrowth, outside storage, junk vehicles, and parking, which can be resolved. I don't know if it would take all that to resolve it.
My understanding in looking at the project, I personally viewed this property is it looks pretty good, and I think that the people with I saw your license plate, a 2021 plate, but I think that's just a tenant didn't renew his license plate and is driving illegally on the streets of Daytona Beach.
Well, I think that's the issue here for us is I think that's what Mr. Jackson was kind of speaking to. This case has been going on since September of 2020, and it seems like it's never going to end. And we've been told many times during this process that we see an end in sight, but then later to come find out that there is no end in sight yet.
I think I'm sorry.
So, I think what Mr. Jackson's getting at is some of those things, can simply be resolved, like the parking of cars on an unapproved surface by not having the tenants park there anymore. And, that starts to resolve some of the complaints and the issues that are in here. Now, ultimately, does it resolve everything? Probably not. And I think we would agree that, if we're on a path to resolving this, permanently, that's where we want to be with you. But, we're very cautious as we proceed forward as to what timeframes we would be willing to, concede to. And really, it would be, what is the time frame? Like, if you say you've got it resolved through the title company, or you believe you do, and you have to have communication, I mean, what's the expected time frame when the surface is installed and the parking lot's there? Do we know that yet?
No, we don't, and that's why I said I got this email from them this morning at 8:50. So I can't answer that question. I can tell you it's been an ongoing problem. I'm telling you that we're trying to work on it and come up with a financially feasible way to do it, and I've shown you the correspondence. So that's how I can answer it. But this is a residential rental property. It looks like a quadruplex to me. And we try to control our tenants the best way we can, but we can't force them to register their cars. And I'm sure that vehicle that you showed the picture of looks like a vehicle that goes in and out every day. That's a nice-looking car.
Well, I mean, at the end of the day, it meets the definition of a junk or abandoned vehicle in the city because it's not properly registered. And those are things that as a property owner, whether it be a rental property or you personally own the property and live there, you're responsible for addressing and dealing with. So those are things you'd have to address with your tenants. If your tenants aren't following the law, then you have to take the appropriate actions you feel necessary to make sure that they are complying. But I think in this scenario, Mr. Riggio, we're probably looking at, basically, continuing like we did before to the next meeting with a progress report with the consideration of a fine at that time, and with the hope that you guys would come in with a more established timeline at that point. And our desire would be in that next meeting to be able to set a compliance date that is whatever meets your timeline, and we just never have to come back here again, and it just gets resolved. And that would be the city's desire. But will we get there? I think it's yet to be seen. We got to come back next month and see where you've gotten.
Yeah, and I don't mind with the time frame and coming back with a report, but it's not going to be completed in August. It's not going to be.
No.
But I know you just want to see. Okay, we
Right.
made this progress. We made contact with Ms. Askew. We did whatever we need to do.
Right, but our hope is that when we come back in August, we've identified a completion date, and then we could set out a compliance date that's in line with that completion date that you guys bring back to us. That's what we're hoping for.
And we're going to run into a problem with your planning and development because they're going to say, hey, look, this is a non-compliant property, so we can't issue permits and stuff and do this site plan review that they're going to require.
Well, you're already calling me about another issue, so you can call me about this one too. And we'll organize a meeting and try to work through that.
Thank you, sir.
Yeah.
Okay.
I don't know if Ms. Geltz wants to say anything.
I represent the former owner and have been working with him on the resolution between the two. So it's my understanding we cannot come off the property come off the case until it's compliant. So just keep coming back.
And Mr. Riggio, the one vehicle has remained on the property without moving for the last 4 months. If we could ask them to talk to whoever their property manager to have the junk vehicle or get it licensed.
Is that the black one or the gold?
Well, the black ones, if we do a close-up on the black one has been in serious accidents. It's got pieces and parts hanging off of it, but it does have a current tag. The gray vehicle has been sitting there for the last 4 months, and we would just like, if it's a running vehicle, get a current tag. I mean, I'm sure the landlord or whoever is managing this property can ask them to get that taken care of. Or we can...
What about the outside storage and the overgrowth?
The outside storage and overgrowth at this time is in compliance.
Okay. So we're really focusing now on that car, which could easily be
We'll deal with that.
resolved.
If Mr. Aversano gives me the permission, I'll go ahead and I'll send out a notice of noncompliance on the lease, saying that he has improper vehicle there, needs to remove it within 7 days, or that he's subject to eviction, and I'll get that served on him.
Exactly, and narrow it down. It looks like parking will resolve itself with a parking lot, assuming that you can get the money, the funding to build it, and it sounds like you're on the way there.
It's a process. Okay. I don't know why mine are hard.
Then what I'm going to do is, as Captain Lee suggested, is I'm going to do, basically continue it to next month. But hopefully at that point, you're going to be able to come back with some real answers to some of these questions as to, hopefully you're further along the line with Chicago Title in terms of where they stand, and parking. I assume there's going to be a contractor involved. There's going to be the work, as you already have mentioned, with the city planning, and be able to outline all of that so this thing starts to have some form to it rather than being very loose as it is right now.
It's loose right now, I concede.
And I think it's very important to just make sure that we're keeping Mr. Jones keep in contact with him, keep him up to date on what's going on between now and that hearing. Because I think it just doesn't work in your advantage when he comes in and says he's had no communication since the last.
I understand that.
Yeah.
I'll send him a copy of the notice to the tenant.
Therefore, in case number 56, SMG 10-21-285, Kasi Investment LLC and Emil A. Dotel and Miriam P. Aversano for property at 612 George W. Ingram Boulevard. I hereby continue this matter until the next special magistrate hearing on August 9th, 2022, at which time there will be a progress report and consideration of the imposition of a fine.
Thank you, Your Honor. Have a good day.
You too.
I think we're going back to case number 19, Mr. Riggio, if that helps you.
Okay, thank you. Case number 19, SMG 07-22-193, SP Daytona LLLP, cited for failure to correct violations of the Land Development Code at 513 Jean Street. Is there any,
Yes.
we have respondents present. If you could state your name and if you're going to give testimony, be sworn in.
Okay, Bruce Williams, property management agent.
Michelle Hart, Community Manager.
Michelle Hart.
Yes.
H-A-R-T.
H-A-R-T.
Okay. Will you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
I do.
Thank you.
All right. Ms. Kirk?
Okay. This is a citizen complaint generated case that was opened February 23rd of 2022 for a damaged fence and trash and debris. I have had contact with one property manager, not this gentleman, but a different one. First notice to the owner was March 28th of 2022. I re-inspected the property on July 1st, non-compliance. Staff is requesting an order of non-compliance with compliance by the next cutoff.
Okay. Mr. Williams?
Okay, we would ask, well, on the fence case, we have contracted a fence vendor, Dave's Fence. They have applied for the permit, and once it is approved, they will have the fence you're looking at is 123 feet of fence fully replaced. We would only ask in that case that if we could push to the September, because once everything is approved, they will have to install it, then have to have re-inspection to verify everything is done. I don't think that's going to happen by August 9th for them to do that section. And as far as the trash situation, we have hired one personnel to literally 8 hours a day pick up trash. We have been in touch with Miss Sandy Van Cleef of the Solid Public Waste Authority with the City of Daytona in regards to picking up all of our open top containers. And in 2021, July, we actually upgraded them from the 4-yard to, I'm sorry, the 6-yard containers to 8-yard containers to,
What size container is that?
these are 8-yard now.
These are 8.
So we upgraded to 8-yard containers, and we have 3 different blocks that we have 4 of the 8-yard containers per block. So we have like 12 different pickups. So we have and we are doing what we can to control the trash issue. There are a couple, while we have to contact her, there are a couple they miss when they come to pick up. So she actually has to call them back, have them come back, pick up the trash, and like you're seeing where it's on the outside, that's when they're missing a container for a pickup.
Okay. Ma'am, do you have anything to add?
Nope, that pretty much says it.
Is this a condominium or homeowners?
This is an apartment community.
Apartment community?
Yes,
Okay.
Your Honor.
All right. Mr. Jackson, it sounds to me, Ms. Kirk, that they are asking to essentially put the compliance date in September as opposed to August.
I'm okay with that. I mean, the case has been opened, since February, and it is a citizen complaint. So I could go one more month to September as long as they're diligent in getting it done.
Okay. Now you understand that if you come back in September and things haven't changed, you're likely to walk out of here with a fine.
Yes, Your Honor.
And so there is, if something comes up, make sure Ms. Kirk knows about it. If there's a delay or something, you know, anything can happen this time of year. And if those things happen, then you want to be able to make sure that you've protected yourself to the best of your abilities and explained why you can't meet that September, it would be September 7th.
Yes, Your Honor. And
Deadline.
the property management agent, Ms. Cindy, I believe, who you've been speaking
Yes.
with? Yes, she will still be in contact with you, Ms. Kirk, so that she can make sure that you verify when the fence is installed and on our efforts to maintain the trash.
Thank you.
No problem.
Okay. Therefore, case number 19, SMG 0722-193, SP Daytona LLP for property at 513 Jean Street. I find the respondent to be in noncompliance and order the respondent to come into compliance by September 7th, 2022, or be returned to a hearing before the special magistrate on September 13th, 2022, for consideration of a fine of up to $1,000 per day. Good luck.
Thank you. Have a great day, guys.
All right, case number 20, SMG 0722-194, RimSim Inc. This is being via Zoom.
Yes.
And we have a gentleman on the screen. Sir, can you identify yourself?
Yes, sir. Michael Aversano.
Okay, Alfano?
Yes, sir. I was with Barry a few minutes ago on Ingram and on the 536, 538 Park Drive.
Okay. All right. And your relationship to RimSim Inc.?
I am one of the managers of the corporation.
Okay. Right.
Okay, this is a,
Oh, we need to have Mr. Alversano sworn.
You was previously sworn, right?
Yes.
You were on the other prior cases, weren't you?
Yes, sir. Two of them.
He's previously sworn?
Yes, sir.
Okay.
this is a citizen complaint generated case that was open on March 29th of 2022 for an unpermitted roof and outside storage. First notice was April 15th of 2022. I have had contact with Mr. Aversano. I re-inspected the property July 8th, non-compliance. Staff is requesting an order of non-compliance with compliance by the next cutoff.
Mr. Alversano, what do you say to that?
I agree with Sarah, and I do not deny it. We're waiting for Lowe's to pick up the material in the front, which I'm having issues getting them out there. The roof, we have hired a roofer who has already filed the permit last week to get the permit for the repair of the roof, which presently is in the office of Daytona, I am told, and I am patiently awaiting for that, and that will be taken care of.
Okay. And that's August 3rd cutoff date?
Yep, the August cutoff date.
Okay. Therefore, in case number 20, SMG 0722-194, RimSim Inc., for property at 532 Park Drive, I find the respondent to be in noncompliance, or the respondent to come into compliance by August 3, 2022, or be returned to a hearing before the special magistrate on August 9, 2022, for consideration of a fine of up to $1,000 per day. Thank you.
Thank you, sir. Have a good day.
You too. Case number 21, SMG 0722-180, Joseph Jeans, cited for failure to correct violations of Land Development Code at 1500 Virginia Avenue, Apartment 111. Sir?
I am Joseph Jeans, the property owner.
Okay.
Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Right. Mr. Clegg?
Yes, sir. Good morning, Officer Clegg. My credentials are on file. This is a complaint-driven case cited November 23rd of 2021. He was first notified November 29th of 2021 with a compliance date of December 13th of 2021. I've had contact with the owner here with progress being made in interior plumbing, electrical, and renovation. He's waiting on permits. Staff's recommending non-compliance next cutoff.
Mr. Jeans?
I am working diligently to upgrade this property. The long delay was in part to the fact that the tenants had to be evicted. It was a drawn-out process considering everything. I was able to get rid of possession, and the tenants were vacated by the sheriff on March 11th.
Okay.
Due to family matters and financial constraints, it was slow getting the tenants' refuse and garbage out. I've also had unfortunate difficulties with plumbing contractors. I've got an electrical contractor working with me. We have made, I can
You
show
don't need to go into details
Okay.
on that because if you get everything resolved by August 3rd,
I sincerely will strive to that.
This matter will be closed out, so.
Perfect.
I wish you best of luck on that. So in case number 21, SMG 07-22-180, Joseph Jeans for property at 1500 Virginia Avenue, apartment 111. I find the respondent to be in noncompliance, nor the respondent come into compliance by August 3, 2022, or be returned to a hearing before the special magistrate on August 9, 2022 for consideration of a fine of up to $1,000 per day. As I tell everyone, if something unexpected comes up, please contact Mr. Cleek, make sure he's aware of it, and good luck.
Thank you so much. Thank you, and I'll be in contact.
All right, thank you.
Thank you.
Case number 22, SMG 07-22-181, Martin Harold, cited for failure to correct violations of city code, land development code at 432 South Seagrave Street. Is Mr. Martin Harold?
This case is in compliance July 7th of 2020.
Oh, it's in compliance?
Yes, sir.
Okay, good. The next case is also in compliance. Case number 23, correct?
Yes, sir.
Okay. Case number 24, SMG 07-22-183, Kalpana Patel and Haresh M. Patel, cited for failure to correct violations of the Land Development Code at 810 South Ridgewood Avenue.
Yes, sir. Mr. Praveen Patel.
Okay, sir, if you are planning to testify, you will need to be sworn in.
The owner is right now in India, so we need some time frame to comply. Yes, yes.
Can you repeat your name again? I'm sorry.
Praveen M. Patel. Pravin. Last name is Patel. Patel.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you so much.
Okay, Mr. Patel, I have a question. In your relationship to Kalpana Patel and Haresh Patel?
We are just operating. My brother is right now in India.
Your brothers?
Brothers.
That's what I wanted to know.
Yeah, brothers.
And you're authorized to speak on their behalf?
Yes, sir.
Correct?
Yes, sir.
Okay. Mr. Cleek?
Yes, sir. This is a field-generated case cited November 17th of 2021. First notified November 20th of 2021 for failure to maintain fence in the rear. Compliance date was November 25th of 2021. I've contacted the owner. Was no progress with his brother, but I did come in contact with this gentleman yesterday. Staff's recommending non-compliance next cutoff.
Okay. Mr. Patel?
Yes, sir. Lot of homeless on the backside the property, so they fell down the fence. So we are trying to get the quotation, and I spoke to my brother in India. So we need a 1 month time limit, please, so we can comply.
Well, the order that would be entered today would be a finding of non-compliance, giving you until August 3rd.
Yes, sir. No.
And I believe, and I know...
Keep up to 31st August, sir, because my brother is coming by the end of July. We don't have the authority to negotiate the fence company, how much price you want to pay.
I believe you'll need a little bit more time.
So
because of
are you
the
willing to
permit
go
needs-
to September 7th?
Yes, sir. That'd be
Okay.
That will do, sir. No problem.
And I don't see Captain Lee here, but I know that he had mentioned that there was an officer who could perhaps help these gentlemen with respect to issues with people who may be knocking fences down and
yes.
things of that
We'll
nature.
pass the information on.
Okay, good.
Thank you, sir.
All right. Therefore, case number 24, SMG 0722-183, Kalpana Patel and Haresh M. Patel for property at 810 South Ridgewood Avenue. I find the respondents to be in non-compliance, or the respondents come into compliance by September 7th, 2022, or be returned to a hearing before the special magistrate for consideration of a fine, did I say September 13th, 22? That would be the hearing date for consideration of a fine of up to $1,000 per day.
Thank
And
you.
Mr. Patel, again, as I said, if there's a problem, you need to get with Mr. Klieg
Okay.
and let him know that there
No
is
problem.
any kind of issue.
Yeah, okay. He's cooperative, sir. Sometimes.
I know your
yesterday I
brothers are
spoke
the
to him.
owners, but you're going to have to be their spokesman if there's something that comes up, and
Thank you, sir.
good luck.
Thank you. Thank you.
All right, case number 25, SMG 0722-184, Denise A. Moore, cited for failure to correct violations of Land Development Code at 833, 835 South Palmetto Avenue. Is Denise A. Moore present? The respondent is not present. Mr. Klieg?
Yes, sir. This is a field-generated case cited May 3rd of 2022, first notified May 12th of 2022. It was cited for failure to maintain permits for the upper deck renovation and the garage area renovation. Compliance date was May 27th, 2022. I had contact with the owner. She's trying to obtain permits. Staff's recommending non-compliance the next cutoff.
Okay. Therefore, in case number 25, SMG 0722-184, Denise A. Moore, for property 833, 835 South Palmetto Avenue, I find the respondent to be in non-compliance and order the respondent come into compliance by August 3, 2022, or be returned to a hearing before the special magistrate on August 9, 2022, for consideration of a fine of up to $1,000 per day. Case number 26, SMG 0722-172, Howard Harris, trustee, cited for failure to correct violations of the, this has been in compliance. Case number 27, SMG 0622-167, Abdul Wahab FN Al-Qatami and Faisal Al-Qatami, cited for failure to correct violations of the Land Development Code at School Street, parcel number 5339-8302-0060. Is anyone here on behalf of Abdul Wahab FN Al-Qatami or Faisal Al-Qatami? There's no respondent present. Mr. Garcia.
Good morning, Inspector Garcia, Code Enforcement with Daytona Beach. Credentials on file. This case was opened as a citizen complaint for an unmaintained vacant lot. Site inspection done on August 31st, 2021. Notice was open on September 21st, 2021. Compliance deadline was on October 2nd, 2021. Last day re-inspected was on July 5th, 2022. Resulted in re-inspection, finding in non-compliance, and I have no contact with the owner. Staff requests the finding of non-compliance, compliance by next cutoff.
Okay. Mr. Garcia, is the lot the area that's covered by that tree and all the grass that's growing up?
Yeah, it's from the post on your left all the way to your right, going north to that red overhang there.
Okay. All right. Therefore, in case number 27, SMG 0622-167, Abudul Wahab FN Al-Qatami and Faisal Al-Qatami for property at School Street, parcel number 5339-8302-0060. I find the respondents to be in non-compliance and order the response to come into compliance by August 3, 2022, or be returned to a hearing before the special magistrate on August 9, 2022, for consideration of a fine of up to $1,000 per day. Case number 28, SMG 07-22-186, MGB Real Estate Investment. Cited for failure to correct violations of Land Development Code at Lockhart Street, parcel number 523906290200. Is anyone here on behalf of MGB Real Estate Investment? Respondent is not present. Mr. Garcia.
This case was opened on November 2nd, 2021 as a citizen complaint for an overgrown vacant lot. Notice was posted on December 23rd, 2021. Compliance deadline January 4th, 2022. Last day re-inspected was on July 5th, 2022. Result of my reinspection finding in noncompliance. I have had no contact with the owner. Staff requests a finding of noncompliance, compliance by next cutoff.
Okay. Mr. Garcia, to bring that lot into not being an overgrown lot, what would they have to do?
They'd have to cut the grass from the sidewalk all the way to the rear, and then on both sides, all the way from both property parcel limits.
Okay.
And if there's fencing, all the way to the fencing line. Also cut any of the canopy effect, which is the branches 8 feet up high, and also to edge the sidewalk.
Okay. Well, the respondent is not present. Doesn't sound like it's a difficult thing for them
No,
to
sir.
resolve, but nevertheless, in case number 28, SMG 07-22-186, MG Real Estate Investment for property at Lockhart Street, parcel number 523906290200, I find the respondent to be in noncompliance in order the respondent to come into compliance by August 3, 2022, or be returned to a hearing before the special magistrate on August 9, 2022, for consideration of a fine of up to $1,000 per day. Case number 29, SMG 07-22-195, Daytona Lands 1. Cited for failure to correct violations of the Land Development Code at 161 East International Speedway Boulevard and 155, is that also East International Speedway Boulevard?
Yes, it is.
Okay. We have a respondent, and if you could provide us with your name and your relationship to Daytona Lands 1, and also be sworn in if you're going to give testimony.
Dana Spear, S-P-E-E-R, and it's, I'm agent for owner.
Will you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
All right. Mr. Jean-Baptiste?
Hi. This was a fire department complaint that we received. The violations are as follow. There was a damaged and unsecure entrance gate, the damaged wooden stairs, hang on just a second. I have the two cases confused. Case 29 and case 30.
This is case
Sorry.
number 29.
29, right. So I was just giving information for 30. I apologize. Case 29, it was a failure to repair damaged fascia board, failure to clean dirt and grime on the exterior of the property, failure to repair exposed damaged wood, failure to clean and paint exterior walls, and unmaintained landscaping. Notice of violation was generated and sent certified mail. It was delivered on January 22nd, 2022, with a compliance date of February 22nd, 2022. Upon a site reinspection on May 13th, facility is not in compliance. I've had contact with the owner's representative. At this time, staff is requesting a finding of non-compliance, compliance by the next cutoff.
Okay, the inspector,
Say that again.
So this is kind of one of my issues. The original violation was actually sent with the address of 149, but I believe it was now, we've kind of figured out it was meant for 161. That's the address on here, but that's not what was on the violation.
It's been corrected, ma'am, and it's
Yeah,
been sent.
so, but hopefully we
yeah,
can.
if you can give us just a moment.
Okay.
Get some clarification from the inspector.
Well, not part of the agenda. Are you saying that the testimony you gave us was for 149?
149, correct.
Okay, the testimony that he just gave was for case number 30 for 149, which is also the ones that are, I think the pictures that are up as well. So I don't know if we've got them flipped in the computer system.
Are these both the same building, but
They're right next door to each
violations?
other.
Or
They're
the
right-
adjacent building?
Yeah, they are adjacent properties owned by the same property owner.
Okay. Well, I want to be clear that we have the proper building cited for whatever it is that is wrong on that building.
Yeah, I think the appropriate thing would be to do, if you agree, is that let's have him pull up the pictures for 161 East ISB, since that's the case that you announced, and have him read his testimony as relates to that property. Can you do that for us, Joe? Is that right?
Yes, that's correct.
Thank you.
Sorry.
Sorry for the confusion.
Okay.
So this is for SMG 0722195. Once again, this was a fire department complaint, and the violations are damage and unsecure entrance gate, the damaged wooden stairs and loose planks, rotten wood, exterior storage, trash and debris, discolored walls, peeling paint, broken windows, dirt and grime, damaged screen enclosure, damaged window, and unmaintained landscaping. Notice of violation was generated and sent certified mail. It was delivered on December 14th, 2021, the compliance date of January 14th, 2022. Upon a reinspection on May 13th, 2022, the facility is not in compliance. I've had contact with the owner's representative. At this time, staff is requesting a finding of non-compliance, compliance by the next cutoff.
Okay.
And Mr. Ridgeo, if I could ask the inspector, would you, the reference of the SMG 0722195, that's regarding the property at 161 East International Speedway Boulevard
Correct.
and 155?
Correct. That's what we're saying right there.
Okay.
Okay.
And nothing further.
You have anything further? No? Okay. Ms. Spears?
Okay, so when this case number 0722195 was originally sent with the address of 149 East International Speedway, so it was assumed that it was the same case because they were both for 149 East International Speedway and kind of have some of the same items. The first time I got notice of case 29, the one that we're talking about now, was just recently in June when we had the hearing. So my hopes would be that we can kind of start, what's going to eventually happen with the building is it's being taken down. It's being demolished. It's had tenants in it at the end of, mid-June. We were able to finally evict the last tenants. It was purchased. It was supposed to have been vacant, and the tenants remained. We had to evict them. So that's kind of what we've been going through. It's really needs to just be taken down. So we've gotten estimates, but it'll be a process because we have to get approval from the lender has to approve it being taken down. And of course, we have to get somebody to actually do the work and the permits. So we're only in the stages of, got some estimates to, what it's going to cost to take it down. And they're from.
Okay. I want to be clear on this. Are you saying that the notice you received cited another building?
Yes, correct.
In fact, these particular issues pertain to 149 East International.
No, these issues pertain to 161.
They pertain to 161.
But the notice that I received, even for the hearing, which I have here, had 149 on it.
It's worth noting that it was quickly, there is another picture that I have there, that it was quickly updated to reflect the correct address.
This is case
However, nonetheless, she
29. Okay. 161. So there's a corrected notice of violation that is dated
correct.
June 30th.
Right, that's for the hearing and the initial, excuse me, the initial case, according to the USPS service, it was delivered with an individual that signed for it.
Well, I want to be sure that the respondent has had proper notice before I start making findings of noncompliance. And what I have here is that the original notice, well, the corrected notice of violation that I have is, the notice of violation says 149 East International Speedway Boulevard, and that is signed and subscribed to before you on June 21st, which is, and then it was corrected on June 30th. You see, I'm just trying to understand this. It's corrected on June 30th. So there is a 9-day gap between the first notice and then the second notice.
And the correct, if I may, Mr. Ridgeo, it appears the corrected notice was personally served.
It was posted at the property
was
as well as
posted
City
at the
Hall.
property on June 30th, according to affidavit.
Okay. And it sounds to me that some of this is all somewhat irrelevant, but I'm concerned. I mean, the respondent obviously is here and has notice of it, but the notice as it relates to this particular building, you were only notified of it, or at most would have been 11 days ago.
Correct, which is 1 day more than necessary from the state statute.
Okay. But it seems like it may be, the issues may end up being moot if this building is torn down.
Yes, it's
But-
just,
The
Sorry.
question that I hear you raising, though, is that you have a lender who is involved,
we do,
and you have to get approval from the lender before you can tear it down.
before we can do anything. And before we could even start that process, we had to vacate the building as well. So my hopes were that if we correctly notice, that will give us a little bit more time, and then as well, you know, coming in to ask for a little bit, because I would say it's gonna be a 6-month process before we can
But
get the building demolished.
you said you have to vacate the building as of,
It's vacated.
it's vacated.
In June, that was completed.
Okay.
So if we could maybe just notice properly, start that, I will keep in contact as we've discussed, and
Mr. Jackson,
Yes.
it appears to me that their intent is to knock the building down, so, but there may be certain things that the city may be requiring, I suspect, of them, if there are things like stairs that are not safe or things of that nature that would need to be addressed as well before as part of this.
From their own admission, and it's anticipatory of not being in compliant in the time period in which we would request. I can't really try and solve right now what may be confusion as to which piece of paper went to which property. Specifically, I see that it was we did recite it and tried to remedy that. They did appear to address these matters, and so I don't think a finding of noncompliance would be improper, and allowing them time to comply is all we would be doing at this point anyway. It's just asking for them to move forward to compliance. She's saying it's going to take more than just a 30-day situation because they plan to do more than just fix things, and then that's fine. The ultimate fix would be demolition, and we understand that. We can't compel that necessarily. We can compel compliance. So something can change in the middle. We have no control over that. So we'd like to have it, the finding, and have it under the jurisdiction of the magistrate as she moves forward. So that's.
Are you saying that you might be thinking about a later compliance date?
Yeah,
So that gives
I
them-
would think the inspector's perspective would be that. This is started in January. The testimony we're hearing is that these have been newly purchased by the respondent. I see one that was started in December.
Right.
So a little bit of time, more than just the 30 days.
Correct.
or-
So if in fact there will be a demolition that's going to happen and going through the process of getting all the proper requirements from the building department, and then we'll see how it goes. The city would like to request a finding of noncompliance, compliance by September cutoff, if that's okay. At which point you would just come back and tell us
okay.
where things are.
And it sounds to
So-
me maybe your biggest hurdle is your lender's approval.
Yes, and finding somebody to do the work, I mean, there's a lot of hurdles. But does that mean by September, we should have compliance as in the building down or fines start? Because that's not going to happen.
No, it's not an automatic, I'm sorry if I could speak that. It's not an automatic fine.
Right.
What we'd be doing is coming back in September. If you keep the inspect up to what's going on. He may even be able to tell you the position of the city. Very likely the position would be that would allow you the time if you're diligently working towards trying to get something accomplished.
Okay.
Okay, and unless, I would feel under the circumstances that my order would also include that the building remain vacant.
Yep.
Correct.
And that it would be properly secured, because you've mentioned there are stairs that may need work, and so that nobody, kids or whoever, walks up the stairs and the stairs fall apart.
One of the sets of stairs we've actually removed completely.
Okay,
I've been here before for somebody it was a different case, mentioning the egress issue. Are we okay that it's vacant, that we remove the other stairs?
Did you get a permit?
To remove the stairs? No, we did not. Okay. So,
You're gonna just get with the inspector.
I mean,
make
they
sure
were
you got
falling.
it properly.
okay.
yes.
Okay.
All right.
Got it.
But the magistrate will have to request a, what do you call it, a progress report, right?
Do we need a progress report?
Now, if we do the notice
mind.
of,
Disregard.
if we do a compliance
Right.
date, then that opens the door for communication between the two of you to find out how far along you are in compliance.
Okay.
If it comes back before me, I always work with people who are trying to resolve the problem, especially in this one where you're going to knock the building down or plan to. And it doesn't do you any good, because in terms of not knocking it down to some extent without getting relief from my order that would say the building has to remain vacant.
Right.
So, I mean, if suddenly you decided you want to rehabilitate the building, you're also stuck with an order that says you have to keep it vacant, so you'd have to get that lifted as well.
Okay.
So, I think that adequately covers all of the different situations.
Okay. Understood.
Therefore, in case number 29, SMG 07-22-195, Daytona Lands 1, for property at, is this one now 161 East International Speedway Boulevard and 155?
Yes.
Correct.
Okay. 155 International Speedway Boulevard. I hereby find the respondent to be in non-compliance, or the respondent come into compliance by September 7th, 2022, or be returned to a hearing before the special magistrate on September 13th, 2022, for a fine of up to $1,000 per day. And I also order that the property remain vacant during this period until some resolution of this matter is obtained, and that the stairs and other areas that might be pose any risk to the public be secured.
Okay. Understood.
Okay.
Okay.
All right. Then case number 30, SMG 07-22-196, Daytona Lands 1, for property at 149 East International Speedway Boulevard.
So once
Mr.
again,
Jean-Baptiste.
Once again, this was a fire department complaint. This was a failure to repair damaged fascia board, failure to clean and remove dirt and grime, failure to repair exposed damaged wood, failure to clean and paint exterior walls, and unmaintained landscaping. Notice of violation was generated and it was sent certified mail. It was delivered on January 22nd, 2022, with a compliance date of February 22nd, 2022. Upon a site reinspection on May 13th, 2022, the facility is not in compliance. I've had contact with the owner's representative. Staff is requesting a fine of non-compliance, compliance by the next cutoff.
Okay.
We do have a contractor that's going to take care of all of these, but they cannot start until the 16th of August. So my only question would be if we could also move this one to the 7th, then we should have it done by then.
Mr. Baptiste?
That sounds agreeable.
Okay. If you run into any unexpected problems, let the inspector know.
Absolutely.
And just clarification, this when you're saying y'all intend on repairing this?
Yes, this is just,
This-
yes,
okay.
yes, we are repairing that. That building will stay.
Okay. Case number 30, SMG 07-22-196, Daytona Lands 1, for property at 149 East International Speedway. Find the respondent be in noncompliance, or the respondent come into compliance by September 7th, 2022, or be returned to a hearing before the special magistrate on September 13th, 2022, for consideration of a fine of up to $1,000 per day.
Thank you.
All right, case number 31, SMG 07-22197, Robert Arbogast and Haley Arbogast, cited for failure to correct violations of Land Development Code at 131 South Halifax Avenue.
Hello.
Morning.
Morning.
And your name is?
Janessa Whalen. I'm on behalf of
Jean?
the owners. Janessa?
Janessa?
Yep, I'm the owner's property manager.
Okay. Are you planning to give testimony?
Correct.
If you would be sworn in?
You said your name is Janessa Williams?
Whalen.
Whalen. Will you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay. Mr. Jean-Baptiste?
Hi. So case 31, SMG 07-22197. This was an online complaint for the following violations: failure to repair leaking, damaged sewage pipe, failure to clean and remove rust, failure to clean dirty sidewalk and driveway, failure to remove derelict and operable vehicle, failure to remove exterior trash and debris and unmaintained landscaping. Notice of violation was generated and sent certified mail. The property as well as City Hall were posted on November 18th, 2021. It's also worth noting that the property management at the time was also posted on November 18th, 2021, with a compliance date of December 18th, 2021. Upon a site reinspection on June 2nd, 2022, the facility is not in compliance. I've had contact with the previous management company, and I've had several tenant complaints. As such, staff is requesting a finding of non-compliance, compliance by the next cutoff.
Okay, Ms. Whalen?
Hi. So we took over management in May, and we have been working to get this situation handled. It actually was all taken care of yesterday, pressure washed. So it's all gone. It's all fixed. The car was removed. We took over landscaping. The last property management company just didn't do anything. So everything was overgrown. We came in, got the landscaping all taken care of. As for the debris outside, like I was telling you before, there is an eviction that she's being removed today. She was the one putting all that stuff out there, and we keep removing it. She keeps putting it back out there. So there's probably going to be more stuff out there today, but as of tomorrow, it should be all good to go to reinspect.
Sounds good.
So you expect to be resolved by August 3rd?
Yes.
Okay. Then, in this case, number 31, SMG 07-22197, Robert Arbogast and Haley Arbogast for property at 131 South Halifax Avenue. I find the respondents to be in noncompliance in order the respondents to come into compliance by August 3, 2022, or be returned to a hearing on August 9, 2022, before a special magistrate for consideration of a fine of up to $1,000 per day. But it sounds like you're on the road to resolving it. Very good.
Ms. Whalen, would you spell your name again for me, first and last?
Sure. Janessa, WHE as an elephant, L, A as in apple, N as in Nancy.
Thank you.
Okay. Thank you.
Thank you.
Case number 32, SMG 07-22198, Thomas M. Halstead and Teresa M. Halstead, cited for failure to correct violations of the Land Development Code at 226 North Peninsula Drive.
Hi.
Good morning.
I'm Teresa Halstead.
Okay. And are you going to give testimony?
If I need to, yes.
If you do, then you need to be sworn in.
Do you solemnly swear or affirm to tell the truth? I'm sorry. Do you solemnly swear to affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
All right, Mr. Jean-Baptiste.
This was a field inspection for the following violations: discolored paint, damaged soffit, dirty fascia, dirt and grime. Notice of violation was generated and was sent certified mail. It was delivered on December 22nd, 2021, with a compliance date of January 22nd, 2022. A site reinspection on May 28th, 2022 found the facility not to be in compliance. I've had no contact with the owners. Staff is requesting a finding of non-compliance, compliance by the next cutoff.
Okay. Ms. Halstead.
Yes, we have since power washed the house. I have photos. I don't see any damage or missing pieces of fascia or soffit. It's all intact. And the parts in there that needed to be repainted, I finished up over the weekend. So I have photos.
Ms. Halstead, the process generally is that the inspector inspects it and signs out. At this hearing, this is still sort of in limbo. You're testifying that you've resolved the problems, but until the inspector actually inspects it and signs off on it, I'm sort of powerless to call the matter to close. Now, the inspector can close out the matter if everything meets his approval. But the process would be that I basically, as in the other cases, find a non-compliance, but then give you till August 3rd to get it resolved. And during that time, you get with Mr. Jean-Baptiste, and he inspects it. Hopefully, he finds everything meets his satisfaction. Matter's closed.
Okay.
So that's it. So case number 32, SMG 07-22-198, Thomas M. Halstead and Teresa M. Halstead for property at 226 North Peninsula Drive. I find the respondents to be in noncompliance or the respondents to come into compliance by August 3, 2022, or be returned to a hearing before the special magistrate on August 9, 2022 for consideration of fine of up to $1,000 per day. Sounds like this one, though, will close itself out. All right. Last case in the compliance cases, case number 33, SMG 07-22-199, GEA Seaside Investments, Inc., cited for failure to correct violations of Land Development Code at 444 North Peninsula Avenue. Anyone here on behalf of GEA Seaside Investments, Inc.? There is no respondent present.
This was a citizen complaint for failure to remove unpermitted sign. Notice of violation was generated and it was sent certified mail. The property, City Hall, were posted on October 14th, 2021 with a compliance date of November 14th, 2021. It's also worth noting that this case started back in April of last year, and there were no movements at that time, so the property had to be posted to make sure that they had the proper notices. A site reinspection on May 25th, 2022, the facility was not in compliance and still remains out of compliance. I've had no contact with the owner. As such, staff is requesting a finding of non-compliance, compliance by the next cutoff.
Okay. Mr. Jackson, is there any resolution with GEA Seaside yet?
No, Your Honor. We hadn't been hearing from them, and they still have the active bankruptcy, but we have a process on how we're handling that case.
Okay. Therefore, in case number 33, SMG 07-22-199, GEA Seaside Investments, Inc., for property at 444 North Peninsula Avenue, I find the respondent to be in non-compliance and order the respondent to come into compliance by August 3, 2022, or be returned to a hearing before a special magistrate on August 9th, 2022 for consideration of fine of up to $1,000 per day. All right. It is approaching noontime, and I'm going to ask how you would like to proceed. We have finished up our compliance, non-compliance cases.
Yeah, you're asking about, staff was going to request that we take a 30-minute break if we could before we go into venue cases. Is that what you were asking? I'm sorry, I was in the middle of something else.
Yes. All right. Well, we are going to resume after the break with the cases where there may be a fine imposed, and hopefully we get the lien reviews in. So therefore, it being 11:50, I call this morning proceeding to be in recess and to reconvene in 30 minutes at 12, let's say 12:30. It is 12:36, and the special magistrate proceeding for July 12th, 2022 is reconvened. And as I indicated earlier this morning, I was going to handle the Ms. Gallagher cases first this morning, or well, now we're into the afternoon, and that will be 42, 49, and 73.
Yes.
Okay, our first case is going to be 42 SMG 0821 236, Vishnu Limited and MMA Shantashi, cited for failure to correct violations of Land Development Code at 1000 North Atlantic Avenue. I believe that we are today to have a progress report and to set a compliance date.
Yes, and for the record, Jessica Gao, Caldwell Law Firm, 149 South Ridgewood Avenue, Daytona Beach, Florida. I don't know if this wants to go first.
All right, since the last hearing, they have attained brand approval and they continue to work under permit. The staff would like to recommend a date be set for the October cutoff, at which point they should have all their permits necessary.
Okay. So essentially just continue it to the October cutoff?
Yes.
Okay. Is that agreeable?
Sure, happy to work with staff as it keeps going through the process. Excited about this one.
Everything is going fine?
Everything is going great. Like I said, we're waiting now for them to get their final approval and their permits to actually start the renovation. They've done all their demo work, and I think they're just going over the last details of the plans, correct?
Yes, I would say we have elevations, we've submitted them. It's looking very nice. We've got Marriott brand approval, so we're excited to see this happen out there. And then, just for clarification, the permit issuance would be compliant. Like this now, or
No, you have to have them
continue to
finalized.
have it work?
Yeah.
Okay.
Okay. Now, if we continue it to the October hearing, is there anything that would be considered at the October hearing other than progress on this project?
I mean, at that point, we would expect them to have permits unless the city is the holdup.
Okay.
And that would be what we're looking for in terms of to continue to allow it to move forward. We're looking
Okay.
for them to have their permits in place.
And I guess I'm sort of echoing the same question. What type of action would be considered at the October hearing?
What type of action? If they didn't pursue their permits, then possibly a fine.
Okay. All right.
This case has been a little difficult for us, mainly because we don't disagree that ultimate completion is like a total remodel of the hotel, and that won't be done until quite a while in the future here. So this case kind of keeps reoccurring. From the staff's perspective, we continue to keep asking for a compliance date to be set, knowing that we will most likely have to amend that somewhere down the road, but giving us the ability that if for some reason they leave this diligent pursuit to remedy it that they're on, we could then assess that at that situation and potentially ask for a fine if need be. So far, they haven't had, so far since Ms. Gal's been involved in the process, we haven't had an indication that they haven't been diligently pursuing. Everything's on track, like the inspector said, and we feel confident that we will get to an end to this eventually. It's just that these they're complicated because the project's so big.
Can I ask this? And just because I don't recall, maybe I'm supposed to already know this answer, but is there a timeline that's already in place, or are we?
So completion of construction is scheduled for the end of 2023. That's when they should be open to the public.
Okay.
So we absolutely understand. We want to keep an eye on it. We're happy to come back and provide status updates for better, for worse, for you here anyway.
So we have like some benchmarks so we can possibly look at. I don't know. Is this something that should happen in the next 3 months or?
Yeah, so permit issuance is next, and then, not really groundbreaking, it's already here, but renovation work would be the next step from there. So I think we've given a rough outline of the timeline for those items before, and we're kind of tracking those as we move forward.
Yeah, we have the timeline, and we're confident that they have been staying to that as best they can.
Okay.
We're really, I guess I say all that to say that if you were to choose to continue this for a progress report at that time, we're not opposed to that either. We just obviously advocating to put ourselves in the best position possible if we need to take action further down the road.
I'm just trying to be clear on if I'm continuing something to a date certain at some point in the future, what it is that will be on the table so that the respondent knows that, for instance, if they don't comply, they could be looking at a fine or something of that nature. And what I'm hearing right now is that we would continue it for a progress report, whether or not one is necessary. It sounds to me like there may be issues that might warrant it, might not. That would be determined at that time. Setting of a compliance date and consideration of a fine if it's warranted under the circumstances. And I'm unfamiliar with your project, so I don't, that's why these cases started from consideration of a fine, and then usually they move on and on and on in this fashion. So does that sound agreeable?
Yes. Yep.
Okay. Okay, therefore, in case number 42, SMG 08-21-236, Vishnu Limited and MMA Shantoshi for property at 1000 North Atlantic Avenue. I hereby order that this matter be continued to the October 11, 22 special magistrate hearing, at which time there would be consideration of a progress report, compliance date, and a fine should one be warranted.
Sure.
Okay.
Perfect. Thank you. And we'll keep in contact with Kevin. I know you've been working with Nika, who's the head kind of land use attorney on this, so she'll keep giving you updates, but we'll stay on it.
Perfect, thank you.
Yep.
All right. The next case is number 49.
Yes.
Okay, that's, see, this is, and I said that's the October 5th? That was, we continued it to October 5th? am
I think you said
correct?
October 11th hearing.
Oh, to October 11th,
Yep.
yes, the special magistrate. Okay. Case number 49 is SMG 02-2287, Karen Hollums Broom, cited for failure to correct violations of the Land Development Code at 407 Main Street, parcel number 530403190130.
I'm sorry, we just reviewed this one right before the hearing, and this one's actually in compliance.
It's in compliance.
It is. Yep.
That solves that.
Thank you.
And then, let's see, the others.
Today.
42 and 73.
Yes.
Case number 73, SMG 03-22-111, 9I Capital LLC, Percentage Vienna Capital Inc., cited for failure to correct violations of Land Development Code at North Atlantic Avenue, parcel number 5305-0139-0051. Okay. Mr. Jean-Baptiste?
Since last hearing, management has had contact with the owner's rep. At this time, staff is requesting to amend to the September cutoff, please.
Okay.
And I say we're in agreement with that, just for a status update to you guys as well.
Correct.
We are meeting with the city manager and planning director on site on Thursday to get an idea of the general overall vision for the Plaza Hotel and this site. So that will be in the works, but in the meantime, in the next 30 days, the gravel and the boulder should be in place to stop the parking on the site.
Sounds good.
Okay. And you said that would be the September?
Yes, please.
7. All right, then in case number 73, SMG 03-22-111, 9I Capital LLC, Percentage Vienna Capital Inc., for property at North Atlantic Avenue, parcel number 5305-0139-0051. I hereby order the previous order of noncompliance be amended to allow the respondent until September 7, 2022, to bring the property into compliance or be returned to a proceeding before the special magistrate on September 13th, 2022, for consideration of a fine of up to $1,000 per day.
Thank you.
Okay. All right. We will go back to where we left off, and that would be case number 34. And we will now move sequentially down the remaining cases. Case number 34, SMG 09-21-247, Jonathan Worsham III, Allison Worsham, Patrick Worsham have been cited for violations of the Land Development Code at North Charles Street, parcel number 5338-4402-0010. Okay, and we have the respondent. And if you could state your name and...
Allison Worsham.
Allison Worsham, are you going to give testimony? If you could be sworn.
Will you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Thank you.
Okay, Mr. Reckenzone.
Since the February 8th hearing, I've had no contact with the property owner, but as of June 15th, the property was rezoned from RP to M1. It's still in an unmaintained vacant lot. The fence and wall are still not permitted, high weeds, unpermitted storage, and rubbish on the property. With the zoning complete, they can move forward to bring the property into compliance, and the city would like to amend to next cutoff.
Is that agreeable?
Yes. When's the next cutoff?
September 7th? And in there, if...
August would be the next.
Oh, I'm sorry, I'm a month off.
Video.
August 3rd.
When you say it's unpermitted, the permit is open, right? And you're just wanting us.
No, the permit is expired, so you have to get that permit reactivated and then finalized.
Okay, I was aware that it expired. When did it expire? Because we just got it reopened.
I don't have that on me.
Okay, I believe that the permit is open for the wall. It was reopened. Yes. It was this year, and I believe, doesn't permits expire within a year? I believe.
Yeah, for the masonry wall,
Yeah.
is showing it's in an expired status. I'll give the dates here. My mic's not on, I'm sorry. Yeah, the masonry wall permit was applied for 10/27 of 21. And it is showing currently in an expired status, but it does not even look like it's gone through the full process of being approved and issued initially. So that would be something you just need to go to the Permits and Licensing Department, get with, tell them, ask them, how do I get this reopened? How do I resolve this? And they'll help you through that process.
Okay.
And the permit number on that is R2110-482.
All right.
Okay. Is the August 3rd cutoff? That gives you basically about a month or a couple weeks or a month to get these things resolved. Okay. Therefore, in case number 34, SMG 09-21-247, Jonathan Worsham III, Allison Worsham, Patrick Worsham, for property at North Charles Street, parcel number 5338-4402-0010. I hereby order the previous order of noncompliance be amended to allow the respondent until August 3, 2022, to bring the property into compliance or be returned to proceeding before the special magistrate on August 9, 2022, for consideration of a fine of up to $1,000 per day. Ms. Worsham, if there's a problem, please get with Mr. Reckenzone. And that should do it. Thank you.
Okay.
Case number 35, SMG 0522-144, Wesley v. Wellman, cited for failure to correct violations of the Land Development Code at 515 Silver Beach. Ma'am, are you here on behalf of Wesley Wellman?
Yes, I'm sorry, I have laryngitis. My name is Melinda. Last name is, I'm going to spell, it's T like Tom, H-E-O, F like Frank, A, N like Nancy, O-U, S like Sam, Theophanous, and I am the agent for the owner.
I'm sorry, your first name?
Melinda,
Melinda.
M-E-L-I.
Okay. And are you planning to give testimony?
Yes.
You'll need to be sworn then.
When you raise your right hand, do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
And your affiliation again, I'm sorry?
Excuse me?
Your affiliation?
I'm the agent for the owner.
Thank you.
Okay. Mr. Boswick?
All right. Since last hearing, I've been in contact with the owners. The repave and restripe had started. I got a couple emails that they had an outbreak of COVID from the company, PaveMax. And also, they hit a water line that he had to come in to get fixed. So staff requests amend to the next cutoff.
Ma'am, does that work for you?
Yeah, the paving is completed. The striping is going to be done tomorrow, so we're happy to have an extension. We appreciate that.
Okay. Therefore, in case number 35, SMG 0522-144, Wesley v. Wellman for property at 515 Silver Beach, hereby order the previous order of noncompliance be amended to allow the respondent until August 3, 2022 to bring property into compliance or be returned to a proceeding before the special magistrate on August 9, 2022 for consideration of a fine of up to $1,000 per day.
Thank you.
Next case is number 36, SMG 0522-150, Camara Holdings LLC, cited for failure to correct violations of the Land Development Code at 421 Silver Beach, Apartment 9. Anyone here on behalf of Camara Holdings LLC? There does not appear to be a respondent present. Mr. Bostwick?
All right, since the last hearing, I've been in contact with the owners, done some progress on the property, steps, walkways were painted, outside storage was removed. However, they repaired the stairwell without getting a permit, and the kitchen cabinets in apartment number 9 were also not completed. So staff requests a fine of $100 a day with a max of $20,000.
To start on today's date?
Yes.
Okay. Therefore, in case number 36, SMG 0522-150, Camara Holdings LLC for property at 421 Silver Beach, Apartment 9. I find that the respondent, who was previously found in noncompliance, remains in noncompliance and therefore order a fine in the amount of $100 per day to commence on July 12, 2022, and to continue each day thereafter until the fine has reached the amount of $20,000 or the property is brought into compliance.
All right, thank you.
Okay, case number 37, SMG 0422-136, Daytona Beach Housing Authority. Cited for failure to correct violations of the Land Development Code at 1200 9th Street. Ma'am, are you here on behalf of Daytona Beach Housing Authority? Yes, I am. If you could provide your name, and if you're going to give testimony, please be sworn.
Kara Leonard.
Is that K-A-R-A?
Yes.
Will you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay.
I'm sorry, and your affiliation again?
I'm the Director of Development for the Housing Authority.
Thank you.
Mr. Butler.
Yes, as it pertains to 1200 9th Street, since May court proceedings, I've had both email correspondence and verbal conversation with the property manager. Currently, majority of the fencing has been installed throughout the property. However, the manager is waiting on a back order materials to complete the project, which they're looking at July 24th, 2022, for that to come in. So staff requests amend to the August cutoff.
Okay, is that agreeable?
Yes.
Okay, if something comes up, please get with Mr. Butler. If they come in late or the fence company has trouble installing it or what have you.
I will.
Okay, so therefore, in case number 37, SMG 0422-136, Daytona Beach Housing Authority for property at 1200 9th Street, hereby order the previous order of noncompliance be amended to allow the respondent until August 3, 2022 to bring property into compliance and be returned to a proceeding on August 9, 2022 before the special magistrate for consideration of a fine of up to $1,000 per day.
Thank you.
All right, case number 38, SMG 0821-229, Rosalind Page is cited for failure to correct violations of the Land Development Code at 555 Oak Street, apartment number 3. Is anyone here on behalf of Rosalind Page? There is no respondent present. Mr. Butler?
I did have a conversation with her. She's in Orlando at this time, and she sent me all the information, so she won't attend today.
Okay.
Okay.
You have a recommendation for?
Yes, I do. As it pertains to 555 Oak Street, since last month court proceedings, I've had contact with Mr. Morris and Mrs. Page, who has hired a painter, and currently the structure is now fully painted, and staff requests amend to the September cutoff.
Okay. That's agreeable. Case number 38, SMG 0821-229, Rosalind Page, for property at 555 Oak Street, apartment number 3. I hereby order the previous order of noncompliance be amended to allow the respondent until September 7, 2022 to bring the property into compliance or be returned to a proceeding before the special magistrate on September 13, 2022 for consideration of a fine of up to $1,000 per day. Case number 39, SMG 0522-157, Fei Hung in Hung Hang Lu Lo, cited for failure to correct violations of the Land Development Code at 582 Mason Avenue. We have a respondent present, sir?
Yes, sir, right. My name is Harry Lowe. I will be
Harry Lowe,
representing the
okay.
case.
And are you planning to give testimony?
Yes, sir.
If you could be sworn.
You raise your hand. Oh, it's already raised. Sorry. Do you solemnly swear or affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
And your affiliation?
Harry Lowe, L-O.
Yes, sir. Your affiliation?
No, I'm the parent. I'm the son of my parents' property.
Oh, it's your parents' company. Okay, so you're the son.
Okay.
Thank you.
Okay, Mr. Butler.
As it pertains to 582 Mason, since May court proceedings, I've had contact with the tenant and the owner. On July 11th, 2022, I walked the property with Mr. Harry Lowe, and there has been significant improvement. However, still non-compliant. Staff recommend amend to the August cutoff.
Okay. Does that work for you, Mr. Lowe?
Yes, sir, right.
Very good. Then in case number 39, SMG 0522-157, Fei Hung and Hang Lu Lo for property at 582 Mason Avenue. I hereby order the previous order of noncompliance be amended to allow the respondent until August 3, 2022, to bring the property into compliance and be returned to a proceeding before the special magistrate on August 9, 2022, for consideration of a fine of up to $1,000 per day.
Yes, sir. May I have one more question?
You certainly.
I probably would take it offline, Mr. Butler. I know we walked the property yesterday. I know you point out a few things. Is there something I can talk to you offline, make sure those are the listing I have before I
I think Mr. Butler is finished as far as his cases today, so if you want to talk outside.
Sure. Okay.
I should be able to.
Yes.
Is that correct, Mr. Butler?
Yes.
Thank you.
Mhm. All right. Case number 40, SMG 0522-147, Daniel G. Langton, cited for violations of the Land Development Code at 428 Pelican Avenue. Good afternoon.
Good afternoon, Your Honor.
Okay. And could you state your names?
Yeah, Daniel G. Langton.
Okay. You
I'm
have other
Marianne.
people with you. Are they going to testify, Mr.
Yeah,
Lincoln?
yeah, Mary Ann takes care of a lot of my
Mary Ann
business.
Wilson.
Okay.
Mhm.
And
And this is,
Your name again, sir?
Vishnu Hari Prasad.
Can you spell that for me?
VISHNU. That's HARRIPERSAUD.
S-A-U-A?
UD.
Oh, U-D. Thank you. And will you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you so much.
All right. Mr. Yates, can you state the city's position on this matter?
Yeah. Since the last hearing, we've had contact, but unfortunately, a permit has still not been pulled for the unpermitted driveway. I would like to make a recommendation of $100 a day to a maximum of $10,000.
Okay. Has the permit been applied for?
No, sir.
Oh,
Could I give an overview?
please.
Okay. As citizens, we depend on the authorities to give us a little guidance, and there's been a little confusion on this whole matter. I was using a form that was provided to us by the city, which describes what you need to, what you can do with a permit and what you cannot do without a permit, or the things that you can do such as repairs, with a permit. So while we were going through the initial stages of improving this property, we discovered some things that we were not really aware of. For example, in the rear of the property, which is to the west of the property, which is shown right here in this photograph.
That's the east.
Excuse me, the
Yes.
east of the property. We had some workers there that unveiled what I've been told are called ribbons. So in the initial inspection that Mr. Yates gave, he cited us for several things, all of which we have found a remedy for. But the bone of contention with the driveway is the fact that we unveiled what were existing ribbons on that portion of the property.
Ma'am,
Since-
are you referring to those two, are those strips? of
Those are
concrete?
strips, yes.
Yes, two
And
strips.
those are described to me by the building department here as ribbons. Okay, so they're not actually a driveway, it's just two strips of something, whether it's pavers or concrete. So when we had our workers out there doing some landscaping things, they discovered these old well, I call them deteriorated, but really in bad shape ribbons.
They were grown over, and they had a lot of sand and stuff.
A lot of sand
Yeah.
and grown over and everything. So, but they said, hey, you know, you need to know about this. I said, well, let's go ahead and get those repaired and beef them up. You know, make them nice. So that's how we came to this point. We didn't know that we had to pull a permit to make a repair for something of that nature. Now, I will say this, that when they started making the repairs, we decided that in the future, we do want to have ribbons and what they call an apron, which goes to the road, so that we would be able to use that side of the property as a driveway if needed.
Yeah, we weren't able to do like a circle driveway. We had talked to the city, and it was too close to the utility. And I said, well, you know, we have to scratch that because you can't go near the water, you know, incoming to the house.
So the reason we
So-
didn't pull the permit on that
Yeah.
is because we thought that we were okay with the repairs. But when I would mention this to Mr. Yates, he told me that those ribbons did not exist before. So I've brought a witness with us today to attest to the fact, because he was extremely familiar with the property, to tell us that his brother-in-law owned the property. Let me,
My
go ahead.
brother owned the place for about 20 years, and he was renting it. And there was the ribbon was there, as you call it, but it was grown over with grass. So,
And he maintained the property there for your brother-in-law.
yeah, it was collecting the rent.
And he didn't want to improve the property to the extent that we wanted to, because we live there. We've improved this property because it's our residence.
Yeah, it was for us.
So,
Could we go back up?
sure.
That
There you-
is the one in question. I just thought I saw another picture of another.
Yeah, so if you can see that picture right there, it's a little hard to see, but that is pictometry showing January 2021. As you can see, there are no parking ribbons. It goes all the way back to the early 2000s, and at no point were there any parking ribbons shown. So those are new, unfortunately.
Let me correct.
And
Go ahead.
as we've heard, and as we heard in the previous hearing, they were told that they needed to go get a permit for the driveway. This is, you know, since December. We've made very clear what they need, and they have thus far refused to get it.
Okay, first of all, let me make something clear to
Let
you.
me ask Mr. Yates a couple questions.
Yes,
First
sir.
of all, Mr. Yates, generally, new concrete looks different than old concrete.
So if we go to that and you see how white it is, that looks like new concrete. That's not old concrete.
Okay. Secondly, would that type of, I guess, call them ribbons,
It's a driveway in the end. It's a ribbon-style driveway.
could that satisfy their requirement to have a driveway on that property?
I have no idea if they would allow that to be permitted or not. That's, unfortunately, I can't speak to the permit department. I can tell you this, it doesn't have the matching apron, which is generally required, which is another clue that lets you know it was done without permit. Because if it was done with permit, it would generally have the required apron.
Yeah, I think the answer is probably, generally speaking, there's probably a way you could get a,
I would do that.
there's generally a way that you could get a ribbon-style driveway approved. I think the issue here is that, you know, there's pretty good documentation on all the aerial footage going back to 2006 that this didn't exist, that this was added. And this would be a second driveway being added to this property. It actually has a driveway on the other side in front of the house. So that's not something you typically see on a smaller beachside lot either, that they'd have two driveways. It can happen, but it's just not something that's very typical. Usually there's a permit documenting that it was installed.
And I really don't know that they had any permit to do what they did way back when, and I'm pretty sure that it was way before 2006. But I do know this, that when the people that we had working for us were digging, and they were digging because we had to install, not only were we moving the shed from one side of the property to the other, but we were also doing some improvement on the grade of the property, which was, we were cited by the city. We hired general contractor services to do that wall, which is right parallel to these ribbons. But when my workers that were doing landscaping, basically yard things, not really looking for any ribbons, unveiled these, we went to repair them. So I reference this right here, that the repairs is the reason we didn't initially go for the permit. We stand corrected on this now and know that the city wants us to get a permit to do a driveway, and we're very, very good with that.
Continuing
However,
ribbons and an
yeah,
apron
but the
on the front.
repairs that we did, I don't want to be punished for something that I considered as a repair. And yes, that photograph that you're showing right there does not show the ribbons because there's soil over it. There's also grass over it, and there was all kinds of sand. Next, that photograph is not very, very realistic because the mound that is on the property is higher than that side of the property. So therefore, just because of normal and natural, things.
That looks very
like
flat.
rain, it looks very flat.
Yeah.
The lot is 168 foot deep, so it's not just a standard, small lot, that you have sometimes over there in that area. But the ribbons did exist there since the house structure initially was built in 1949, somewhere between 1949 and, we know it didn't happen when we purchased the property. It happened prior to our purchase of the property, which was in 2021.
I mean, what we're talking about at this point, we've kind of gotten off basis. If you believe that there's no reason for you to have to apply for the permit because they existed, that's something that you're going to have to prove through that existing use. I don't think what I've seen in the case, and what it's been relayed to me by the inspector, that I've seen any evidence presented to us. For example, like if your landscapers, when they found it, took photos of the concrete, at that time, those would be evidentiary things that we would be able to consider during a case. If you had some documentation about when the house was built that showed that it was installed at that time, that would be something that would go to the case. But what there is here in this case is there's at least 15 years of clearly established photography of the property that shows that if there were concrete ribbons there, they were not in use, and that use was pretty much abandoned at that point. And, for 15 years, they didn't exist, and all of a sudden, they just pop up again.
Yeah.
Well, not again. They just pop up. According to our records, they just pop up for the first
We
time.
weren't aware of it, and we didn't intentionally, I just want it to be known that we didn't intentionally try to violate the city. However, when I get into a conversation with Kevin Yates and I say, Kevin Yates, we know that they were there before because they're there, and apparently, someone along the line is saying, oh no, they were never there. The next door neighbor has only been there, I don't know, maybe 15 years, and he seems to have a very tough time with any improvement to the property. And so it's a continuous, the cycle is such. We know that we need a permit to do the ribbon driveway. We know that we have to obtain that because we were considering general contractor services in doing that work because they did a very good job and everything else. We paused because I wanted it to be clear here that we didn't intentionally violate this by saying, oh, we're just going to put in ribbons with, but
I've done everything to help on this thing. Even the dirt that was disturbed, general contractors made me build a retaining wall, which cost
they
me
didn't, the city did.
Well, the city, but
Let me
$15,000.
get this back on track.
Yeah.
Okay, Mr. Yates. the breakdown here, there may be other things. There was an unpermitted shed, unpermitted driveway.
took care of 'em.
Unpermitted paver installation, and unpermitted grading.
Yes.
Has any of that been resolved?
They have permits for it, as none of it has been resolved.
Oh, I beg your
wait.
pardon.
No,
You're wrong on that.
I understand that it's not really resolved until Mr. Yates takes a look at it, and the burden is on you to notify him.
But yes, so
Come-
the permits aren't finalized, so that's why I'm saying that they're not resolved.
Okay.
okay.
Can I address that subject?
And
Yeah, let him go.
I'm trying to
And
work
I-
my way through this, but you
Yeah.
have permits for everything, and we're now focused on this driveway.
yes,
Now, my experience, when I look at that, grass doesn't seem to grow. Is that sandy soil?
yes,
Grass, I'm looking at the soil, and the existing grass is only a fraction of an inch above the paver, and typically when grass tries to grow over something like that, it cooks in the sun. And so, the city has looked back on old aerials.
yes, sir.
However, I mean, if you want to pursue that, there's two ways. Either you can get it permitted, or you can, I guess you would call it forensic concrete analysis.
Oh, my God.
Because there's a difference, if I'm correct, between new and old concrete.
Yeah,
But I'm not going to say I know anything about that.
fair enough.
But what I'm hearing is that you have the permits, but the work has yet to be completed,
Yeah, yes.
okay? And we have this unresolved issue as to the driveway. The burden is going to be on you to prove that this driveway, when the city goes back to, was it 2006?
Yeah.
And can't find a driveway, and the lawn looks pretty much kept up and clear, how does it suddenly, these two strips of concrete appear? And obviously, when you look at something like this, you've got an entire long length, and any piece along that where it gets exposed should pop up.
And just one more thing to note about the concrete. What you'll note about what they've said is that they did improvements to the concrete, but yet it's all the same color, which means it was all at the same time, which means there's no way that it's that old. It's just, two things can't be true at once.
It's over the top of
Let
that.
me
Yeah.
explain,
Well,
let me just clarify.
Yeah.
I'll cut through this.
This will way beyond that.
Yeah,
Sorry.
Yeah.
here's what I want to do.
Mr. Riggio, can I just
Go ahead.
to one of the things you brought, I want to clarify. There is not, and I know you said there's permits that exist for quite a few of these items here. Just to be clear, the driveway issue, there has not been a permit issued for that. There's not been even one applied for that, and they've known about this violation since the beginning of this case, which is over a year ago. So I think that's what's really led us to being here today. There can be an understanding at some point about not knowing that you needed a permit, but a year down the road, it should have, at some point, it's been explained to you multiple times. And that's why we need to move forward with this case.
Right, and this driveway was discovered back in June of ¡21?
It's addressed, it's addressed in the first notice that went out, where it talks about unpermitted paver installation or
Those
unpermitted
pavers.
unpermitted driveway.
Yeah.
Can I
And that
just,
is that driveway right there. So this has been around for like a year now.
and that was, what you're seeing in that photograph, let's not, no, I don't want to be misleading, and I don't want to be misled either. Okay, when the old ribbons that were in need of drastic repair with grass and sand grown over them, when they were unveiled by our workers that were doing the landscaping work, the workers said, oh, great, they got all excited, and they brought the concrete in, and everything that you're seeing there, the soil was dug, and that is all new. None of what you are seeing visually right now was pre-existing.
Yeah,
Okay,
no.
so
Concrete
let's,
that was poured on top of concrete?
yes, sir.
Yes.
It was poured on top of the existing ribbons
And
as
around
a
it.
repair to that. Now, we've since unveiled the fact that there should be a permit requested when you're, when we want to do an extension on that driveway. But for just the repairs, we weren't aware of the fact. Now, can I bring up one other issue, sir? Because this is very, very important. I do want it to be known that when a city truck pulls up into your driveway or into your yard, and it has the city tag and it has a label on it, and the person driving the truck introduces himself as the inspector, his name is Jurgen Betts, and Jurgen Betts inspected this property. When he inspected the property, not knowing your chain of command and how it works here with your building department, your zoning department, I've learned a lot now, but as a citizen, if I have a person representing the city that tells me he's an inspector and he's making an inspection of the property, I consider that
You guys,
final, okay? Then from that point forward, if I tell Kevin Yates that it has been inspected, and Kevin Yates argues back to me and says, no, it hasn't been inspected, but I know that a gentleman by the name of Jurgen Betts gave me his card and he inspected the property, I consider it as a citizen to be an inspection, because we paid a considerable amount of money to put up this wall.
And hire general
when we
contractors.
moved our shed from the eastern part of the property to the western part of the property, we knew that a permit had to be handled with that, and we did all of that. And yes, all of that is finalized.
Okay, what I'm going to do is I'm going to go with an amended order of noncompliance, okay? And at the next hearing, you're going to have to provide something regarding Jurgen Betts.
I can respond to that right now.
You can?
Yes.
Yeah.
Okay.
Yeah, so Jurgen Betts is a individual that is a permit inspector. He is summoned to the property to inspect the permit in which they applied for and that was issued at the time. It's totally different than code enforcement. They know this, they've known through the process, and during this process, what they're doing right here is they're picking and choosing which city official to listen to. So at the point at which they challenged it with Inspector
Whoa,
Yates, can I please just finish?
Yeah.
The point at which they challenged it with Inspector Yates and he said, that's not sufficient, I need to come out. Well, the appropriate response to that would be, come on out and let's get it done.
Sure.
And and that instead it was an argument. And I think that's where we've taken a position of trying to argue your way out of a situation rather than working through the compliance.
Absolutely not. I have nothing against anybody here. I'm just trying to do exactly what's right to get this thing done. I've spent so much money, more money than anybody has on any residential property in order to get things right.
But
I just don't understand.
repeat-
I'm not playing dodgeball
And we
to
don't wanna
anyone.
argue.
Mr. Jackson, you
Yeah.
seem to want to say something.
Yes, Mr. Riggio, I think we're at this point where the issue is regarding this driveway, this ribbon driveway. And by their own admission, they don't know anything beyond when they purchased it. Even if we accept their claim that it was there, there's nothing that says it was ever permitted. All what they need to do is get permits. They've been told that from now for a year. I understand the possibility of someone being confused about the building inspector versus, or the trade inspector versus the code inspector, but they've been in a code case. They've been in a code case for a year. They've had the interaction with a code inspector, and the mere fact that they refuse to accept the information or even come and try and verify it at a higher level in terms of what the inspector's telling them shouldn't be a basis for rejecting the reality that they need a permit and they need to get it resolved, and that's something they needed to do now for a year. So our position just remains that they need to get a permit.
Yes, I'll
And
do that.
I think they keep acknowledging they need to get a permit, but they hadn't gotten one.
I'm sorry for not. I will do anything.
What we were considering is the repairs that were done. I guess when the argument comes into the play, then things get very complicated.
Let me ask.
The permit is not.
The citation is for an unpermitted driveway. Is it for these two ribbons?
I can't speak to that, but what I can say is I think the conversation is going from whether it was ever permitted to whether or not they permitted whatever action they've taken. And the reality is there's nothing that says was anything ever permitted,
Mr. Jackson.
whether the ribbon was there or not. Is that correct, Inspector?
That's correct, and
Definitely.
there is a significant amount of history related to this property and the owner, and basically every permit they have at this point, just about, is as a result of us basically forcing them to get that, and that's been a repeated, constant complaints from the neighborhood about
But we've done it.
extensive
It's by
amount
one
of
person, too.
extensive amount of unpermitted work done to a property, and we found that when we visited the property, that there was extensive amount of work to the property done without permits and without the proper inspection process being
We
followed.
do have,
Mr. Yates, if you could answer a question for me.
Yes, sir.
They were cited for an unpermitted driveway. Are those two ribbons?
Yes, sir.
And that was on 6/23/2021, or thereabout.
Yes, sir.
That's a year ago.
Correct.
And has there been a permit application for those?
No, sir.
I don't need to hear anything further. Okay, if you have an issue regarding that, then there should be a permit application. A building official should be going out, reviewing it, and determining it. And it's now been over, what, a year?
but we thought that what we were doing
You
here
don't,
is
you can't,
repairing them.
just because you feel that you found something, well, it still requires a
Yeah.
permit.
Yeah, I
I'll do
agree.
it, and
We
I'll do the
agree.
whole thing. I'll finish
And
it.
we want to do the right thing.
Yeah,
We
everything.
just don't want it to.
You've
be
had a
Absolutely.
year to
carelessly-
do the right thing.
I want to do the right thing.
We wanna do
Believe
the
me,
right
I do.
At this point, this has gone on for too long.
I'm sorry. I just didn't really know.
The citation was for unpermitted driveway. The solution to an unpermitted driveway is to seek a permit.
Okay.
And we are a year later, and has there been a permit application for this driveway?
No, sir.
Then,
Only on that one, I guess.
The sheet that I was abiding by, which was provided to me by the city, stated very clearly that if you do repairs, that you are not required to have a permit. So maybe this needs to be amended. And then the other thing that I would say is that the confusion really took place in the inspection. You know, on our last visit here to this magistrate, we went downstairs and found out we did have an inspection. So if that could kind of be cleared up for the next guy, I would appreciate that too.
I'm feeling like I'm being confused. And that is not the proper thing. I mean, if you're cited for an unpermitted driveway, you obtain a permit, or at least you apply for a permit. Has there been anything applied for?
No, sir.
No. Then and what is the recommendation, Mr. Yates?
$100 a day to a maximum of 10,000.
Jeez.
That's so ridiculous.
How long does the permit take? You know.
And that would be starting today?
Yes, sir.
Okay. I'm going to reduce that to $50 a day. And if they can get a permit,
How
then
fast
they
can
would
I get
certainly
one?
have a basis for coming back for a lien review.
Absolutely.
And, but if there's something that is found that requires a permit, you get a permit, and a year later is just a year too late.
Can I go downstairs and get one right now?
Well, like I said, if you can get one, then I would see that if you come back and ask for a reduction or
Yes, I
removal
mean-
of a lien review, that's correct, but you're not going to get a permit today, I know.
Mr. Magistrate, can I say this too, that a lot of times when you're trying to apply for a permit, the things that require an engineer, engineers are very, very, very low.
Next to impossible to
We
get.
literally tried to get an after-the-fact permit for some other things
I did.
with the house, and it did take us 3 weeks to find an engineer that could stamp that. You know, it's very, very difficult to find good workers.
I understand, but I've made my determination. Therefore, in case number 40, SMG 05-22-147, Daniel G. Langton, for property at 428 Pelican Avenue, I find that the respondent was previously found in noncompliance, remains in noncompliance, and therefore order a fine in the amount of $50 per day to commence on July 12th 2022, and to continue each day thereafter until a fine has reached the amount of, is it $10,000, Mr. Yates?
Yes, sir.
$10,000 of the property is brought into compliance.
Is that until brought in compliance or until the permit is, when we make, when we show due diligence to try to get the permit?
Ma'am, you are going to have to either come forward with a permit, and as I said, if you can permit that,
They won't
then
give it to us on the spot.
you
Yeah.
would be having an argument for a lien reduction or a total lien release. But until such time, right now, this has gone on for over a year, and it has to be resolved, and it's being resolved right now. You can either go down and obtain a permit, or you can have a fine on your, lien on your property. So, thank you. Next case, number 41, SMG 022282 604 Main Street, Inc., cited for failure to correct violations of Land Development Code at 604 Main Street.
Hello, Sharif Gindi, owner's representative.
Okay. Good afternoon.
Good afternoon, sir.
All right. Mr. Kendi, are you going to give testimony?
I am, sir.
Then you will need to be sworn.
Special Magistrate, we are also case number 55, if it could possibly be heard after this.
55?
Yes, sir, 504 Main Street.
We'll do that one after we finish this one.
Thank you, sir.
I was wondering, 504 and 604.
Yes, sir.
They might be related.
Coincidence, yes, sir.
Okay.
Sorry about that. And your name again?
Sharif Gindi.
It's G-U-N.
Guindi.
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, the action today that I have down is a progress report. Is that correct, Mr. Yates?
I believe it was for imposition of a fine, but if either way, we're going to ask for an extension, so.
That's fine.
All right.
Good.
Since the last hearing, the fence has been removed and the stair removal has been permitted. I would like to, if it's saying, I'd like to set a compliance date for August to allow them to remove the sign and finish getting the dirt and the grime off of the back of the building.
Sir, does that work for you?
I will be actually away during that period, sir, if it could be extended to September, but I do have a response as well.
We prefer to do Zoom or something. That it should be completed the next 30 days. There's no reason not to.
What?
Is
I'm not.
The sign?
Yes. Yeah, the sign, yeah.
Placard or whatever?
Yeah, that needs to be removed.
This has been an ongoing case for probably a year. Special Magistrate Vicalja has not remanded. The sign needs to be removed. That's an expensive process. To replace the sign is expensive. Another thing Special Magistrate Vicalja had mentioned is he doesn't believe in making a property owner spend money just to go ahead and spend money again. There is nothing wrong with that sign structurally. We have it covered very, very well. We've maintained the cover on it. That's just an expense that is unwarranted. And once again, Special Magistrate has not remanded that it be removed.
Can I ask this question?
Yes, sir.
That's for sign. Why
That-
don't you get a sign and get a sign permit, and then you don't have, would I be correct, Mr.
Well,
Yates?
Yeah, if he had all those things, absolutely. Be allowed to have it.
I mean,
So that's Beach Photo. That was a business there for decades.
yes,
It's the old Beach Photo sign.
okay.
So it's not that it wasn't permitted. We are just waiting for new tenants. It's a large building, over 7,000 square feet. We've spent a ton of money on it so far. The dirt and grime let's not leave the sign for the moment, so. But they will be businesses on that sign.
Unfortunately, the code's kind of clear. There's no business there. There hasn't been a business there. So the sign does need to be removed. You can see it in there. The violation is pretty clear.
Is there no tenant in the building?
No, sir, not now. The building's going to go through a renovation.
This has been from a citation from more than a year, once again. I appreciate the anticipation of a future, but we've gone more than a year under what a code says. You have to, if there's no activity for the signage, then the signage shouldn't be there. And so it's a violation of the code. It's a violation of the International Property Maintenance Code. And so we're just asking that they be, they come into compliance with the code.
Is it Kindy?
Gindy, sir.
Kindy. Here's the situation. You are saying that Mr. Vukelja has a different opinion. I don't know what Mr. Vukelja's opinions are.
Right.
Okay. And what the city has said is to give you an amended order of noncompliance to get things resolved by the August cutoff date. If you don't, then you would go to a hearing in August, at which time the city would say, we want a fine. I expect that Mr. Vukelja would then be at that hearing, because he usually, and then you could make your argument straight to Mr. Vukelja.
Yes, sir.
So if I was in your shoes, I would go along with what Mr. Yates is proposing.
Okay,
And
so.
then if you're going to make your argument over the sign, you can then make it to Mr. Vukelja.
Okay, so once again, sir, my owner is out of the country, and I will not be in town on the next date.
You don't have somebody who could stand in for you?
It's just been me for doing this for 2 years, and it's tiring. And, we have painted the building. We put a new roof, new gutters, dilapidated doors we repaired. The staircase, we got permitted and finalized the permit. So I'm not quite sure what are we looking at next.
Just once again, see the dirt and grime all along the back of the building there.
Okay, so when we addressed the other portion of the building that we repainted, we didn't realize you want that as well at this point.
Yeah, whole building, all dirt and grime must be removed from the entire building. So what we would ask, like I said, in the next 30 days is for the removal of the sign and the remaining dirt and grime.
I'm not going to be here to argue my case in front of Special Magistrate Vukelja. And he has looked at this case over a half a dozen times, 10 times, and he has never remanded for that sign to be removed because it is an undue expense for an investor who's trying to improve Main Street and has spent more money on Main Street than anybody has in this town in 3 years. It's just not fair.
Mr. Jackson, Captain Lee?
The position remains the same, Mr. Riggio, and I think your point's well taken. If it's an argument he wants to make before Vukelja, then that's next month. The ability to appear is something that folks all over the country has now recognized. This includes a Zoom ability, if that's what they so elect. With his assurance that Mr. Vukelja would agree with his perspective, it doesn't seem like it would be a concern of whether he's physically here or whether he's here by letter or by Zoom for this to occur. So our position remains the same. We believe we don't believe it was Mr. Vukelja's intent to alter the code, and so whatever decision he believes Mr. Vukelja would make or has made will be related to the facts as they exist today, and the facts are that it's been a year, and that pursuant to the code, it's in violation. It needs to be removed. Either that or initiate a business and start working on permits.
And I would just like to say, take a moment to just, put on record, because this keeps coming up for some weird reason, and we'll have to address it next time too, since it'll be a different magistrate. But this, you're cited for section 610G, which is sign maintenance and removal. And it clearly says that all signs, including all, this is subsection 1, all signs, including all supports, braces, guys, and anchors, shall be kept in good repair. 2 says a sign that no longer correctly directs or exhorts any person or advertises an operating business, leaser, owner, product, or activity conducted or product available on the premise where the sign is displayed shall be removed. The property owner is responsible for the removal of the signs, including all brackets, poles, and structural elements. So for us, from the city's position, the code is very clear.
Yeah,
And the code is written by the commission, and it's upheld by all of us. So absent of some type of change to that code, that is the code that we will be enforcing.
That's fine, and I would like to defer to Special Magistrate Vucalich's decision, because he has not made that decision on a number of different occasions.
I understand.
So that's all I'm asking, is just if that's the case, let's leave it up to Special Magistrate Vucalich. I mean, you know, how many signs are around this city? Hundreds that are not directing
And that's why
somebody
we're
to a
working,
bit.
that's why we're working very
So there's a
hard.
monument sign in front of an office building, and you go ahead and make them remove the monument sign.
I don't want to make the argument for the respondent here, but if I understand this, his argument is 1 extra month until September.
Yes.
You
Yes,
will
sir.
be here.
Yes, sir.
You will not be here in August,
Yes, sir. And I will be here in September, for sure.
and
The city doesn't have any objection to that. If he'd called and asked for a continuance, we'd offer that probably anyways, so that's fine if he wants to make
That
the
would be
decision now.
appreciated. Yes, sir.
and that way, if Mr. Vukelja feels that way, you have an opportunity to make an argument to Mr. Vukelja, and you may find in your favor.
Yes, sir.
I tend to look the other way, that if the code says something, there are means like variances and things of that nature that one applies for that allow you to essentially not follow the code. It's not really up to staff or me to vary the code
Yes, sir.
based under circumstances.
Yes, sir.
You may have a tenant lined up by then, or somebody who wants to use that business who could apply for a sign, at which point all of this might become moot. But right now, as it stands, there is no, from my understanding, there is no business that is using that sign, so therefore the sign by code should be removed. And so what I'm going to do here is continue this to the September 7th.
Can we set
I mean, the amended order of noncompliance to September 7th. And then if you don't have somebody who can make use of that sign by then, you'll have to argue that in front of Mr. Vukelja.
Thank you, sir. Thank you, the city.
Thank you.
Therefore, in respect to case number 41, SMG 02-2282, 604 Main Street, Inc., for property at 604 Main Street, I hereby order the previous order of noncompliance be amended to allow the respondent until September 7, 2022, to bring the property into compliance or be returned to a proceeding before the special magistrate on September 13, 2022, for consideration of a fine of up to $1,000 per day.
Yes, sir.
And you said you were also here on
Case number 55, sir.
55. All right. Case number 55. SMG 01-2215, 504 Main Street, DB Inc., cited for failure to correct violations of Land Development Code at 504 Main Street.
Yes, Mark Jones, Neighborhood Services. This case was opened back in April 5th, 2021, for no sign permit, damaged exterior surfaces, damaged parking lot, opened second floor door, and missing exterior staircase. The sign has been removed, though as you saw in one of the pictures, they still have not covered the electrical outlet. The second floor door has been locked. There is no stairwell going to the second floor, but they have assured us that they will not occupy the second floor until the property has an exterior stairwell to exit the building. Since the last hearing on May 10th, 2022, I've had no contact from the owner or the representative. They had stated they were looking at filing a project with the city to get the building remodeled, but there has been no project filed. There's been no application submitted to repair the parking lot. And if you look at the exterior finishes of this building, compared to the building next door, it's a mess. It just does not look good. We've asked that they attempt to either go back in and repoint the bricks or do something to at least bring the presence of this building, which is on Main Street, up to some sort of what we would consider appearance that matches the exterior of the other buildings.
Mr. Jones, just so I'm clear, the building in question is which one?
The one on the right.
The one on the right? The
As you're
far
looking,
end
yeah, the
building?
far end, you're seeing a reflection of the flag from across the street in their front.
Okay, and the
So-
one to the left of it with the air conditioner in the window is an occupied building?
Yes, it is. It's an occupied building, and you can see if you scan in how they have maintained their building. The bricks are all look nice. I mean, compared to these to the building that in complaint, the building just looks just unmaintained.
Okay.
Again, this has been going on since April of 2021. The staff is requesting a fine of $250 a day with a cap of $200.
Okay.
200,000.
200,000, yes, I'm sorry.
200,000.
Yes,
Oh, okay. Big difference.
yes, a little, sorry.
Yeah. It's basically an insulting number, but that's okay.
Okay.
All right, so let me respond. This has been going on. So we had Chief Building Inspector of Daytona Beach, Glenn Urquhart, come out and take a look at the building. He recognized it's a classic old brick building, and to address it or try to change it would just be unwarranted. We had a tenant in the building. It was an operating building. We had a $5,000 a month tenant. City didn't like some of the tenant's actions, asked us to remove the tenant. We did at the cost of $5,000 a month. This building has had a brand new roof put on it, two new HVAC systems. I think Chief Building Official Glenn Urquhart closed out the permits on it. The electrical plate, yes, of course, we can put a plate on that. Getting somebody to cover the driveway, top the driveway, pave the driveway has just been absolutely brutal. However, I do believe it looks better than the parking lot that's surrounding this building, if anybody wants to take a look on the exit. This has been an amazing situation. Special Magistrate Riggio brought an investor to town who really wants to impact Main Street. He spent a fortune on the restaurant at 115 Main Street, is now open and operating. We closed window permits to the tune of thousands of dollars there because that was a violation. We were also told by Chief Building Inspector that an administratively closed permit is a closed permit. So we're not even asking for the thousands of dollars that we spent on that building to close those permits to be refunded to us. Trying to work to impact Main Street in a positive manner. And as I said, it's an ongoing battle. Trying to do our best, and spent $3,500 getting those doors operational on the front of the building. As I said, a brand new roof to the tune of $40,000, and two new HVAC systems to the tune of another $15,000, $20,000. So we're trying to do our best, and finding tenants for Main Street is not an easy task, as everybody knows, because the city's been trying to figure out what to do with Main Street for decades, since I arrived here in 1982. And now I've got an inspector who spent millions investing in our, an investor who spent millions of dollars investing in our city, surely not trying to shun expenditures because he keeps spending money, and we're trying to do the best we can do. But to try to change the brick on that building would be unconscionable. It is a classic, beautiful building. The brick next door, it's lighter, and it's a different brick. But this has been here for decades. It's a neat building. When the sign goes back up on the front, that'll take care of that brown area. But we are trying to do the best we can do.
I guess the city's concern is all the other items he addressed were not on, we were not discussing a roof or air conditioning for this property.
We were, excuse me, when we bought the building, excuse me, sir, I didn't mean to interrupt. When we bought the building, there were code violations, and the roof and a number of others were found to be violations. We did them, we were found to be in full compliance, and now here comes the next set of violations that someone decides arbitrarily to apply. Why weren't there, nothing's changed on this building in all this time. And why weren't they violations when we were found to be in full compliance previously? It's just it's a brutal hamster wheel, and trying to keep this guy in town because he's really good for the city of Daytona Beach, but I'm going to be losing him if this continues.
Mr. Gandy, the problem that I have, and it's clear, is that what you are trying to do is something that really seems to work itself into more the legislative realm, where the city commission has certain authorities, redevelopment boards have certain authorities that allow them to work with property owners, if they so choose, to try to work on a neighborhood. This entity, from the standpoint of its direction, is to enforce codes. And I don't understand why you are not taking your arguments to redevelopment boards or city commission, because I understand, based on what you're saying, you're trying to invest in an area, and you've essentially created a shell building where you've apparently made improvements to the roof. Am I correct on that?
Brand new roof, yes, sir.
And some other improvements that the building can, until somebody comes along that you can rent it to or sell it to or whatever.
Yes, sir.
And recoup whatever you invested. But these are issues that are not code issues. These are legislative issues. And why are you not taking this to the city commission?
Well, with all respect, Special Magistrate, we have addressed the code violations, and we continue to address them. Like, for instance, the doors were supposed to be bricked in on the back. We bricked in the door on the south side of the building, okay? And I think that permit has been also closed out. The one on the side, which was a door that was unlocked, we have secured that door, put in a new door. It is not open. There is no access to the upstairs. Larry Robinson, a local architect here for decades, has designed the staircase. There will be a staircase on the interior of the building. And we are trying to address things as we roll, and just it takes time and effort and money, and workers are not prevalent and available on a constant basis, but we keep working at it. So, to impose a fine when we're trying to make improvements while we've been addressing code violations, I just don't think would be fair.
If I could just clarify, because he talks about a door in the rear of the building that was bricked in, and there was 2 windows on the back of the building. Those were 2 separate violations that were after the fact permits. They replaced 2 windows on the upstairs without getting a permit. They were then issued a violation. They were then issued a stop work order because they were closing in a stairwell on a door where there used to be a stairwell in the rear of the building. There was a stop work order, and then they ended up getting in after the fact permit to enclose that. But these violations that we've been requesting, the parking lot, the exterior of the building, that hasn't been addressed since we did these violations back in April.
Once again, specifically addressing the brick, I don't know how we address the brick. What a shame to try to change that brick. I don't know what that even means, to address the brick.
Okay.
If we put power
Jones,
wash.
with respect to the brick, are you referring to the white splotches on the brick?
Well, referring to that, as you can see, that building has not had the brick pointed in probably decades. That is what you do to maintain the brick.
I'm very familiar with
Yeah.
brick repointing.
Okay. And if you can see, in certain areas, they have literally painted the brick.
Okay.
And it's this way on the front and also on the side, where if they could get that cleaned up, get the brick pointed, the building would look so much better from Main Street than what we're dealing with today.
And that would help to, I'm just trying to understand, I think maybe people viewing might not understand either, but that would help with improve the divots and the damage that are on that brick and the look of that brick?
Oh, yes, that's what you would do when you would go in and point it. As you can see, there's, when they bring into a close-up, you can see many areas where the concrete is even missing, at the joints. That's when you go back and you point it. And I don't believe I have a good picture of the side today, but they've done the same thing on the side where they've painted it in certain areas, different colors of brown.
Okay.
We have not touched this brick since we owned it. Where the door was, we did a faux finishing on the two doors. The body of the building where the original brick has been, we have never even touched. It is exactly the way we purchased it. Oh, by the way, when we were found in compliance, that brick is exactly the way we purchased the building.
Unfortunately, brick is one of those strange building materials that requires that kind of repointing maintenance. And there are companies out there that do that. Now,
May I ask what repointing means? I don't even know what that term is, repointing.
Well, the grout that's in between the bricks is not,
So a building that's 100 years old, we're going to try to take out that grout and re-grout the brick?
I can tell you that is actually, the grout attracts salt, and the salt erodes away the brick. And eventually, the bricks will crumble from that. And that's, I know, for instance, the lighthouse has to repoint their brick buildings every few years. Otherwise, they fall down. That's one of the downsides of brick buildings. I don't know what condition your grout or your brick is in. These sound like things, again, that if the cost of the regrouting, then that is something that you could make application to the city commission to say that, as a good resident, we need this, and there are costs that we incur. From the standpoint of this entity, though, the focus is on trying to enforce the code, not trying on the bigger picture that is outside the scope of the authority of this entity.
And there are facade grants in redevelopment areas that are sometimes available for such things.
Well, if I could continue to the September meeting as well, that would be appreciated. I will reach out to a contractor. I will reach out to the city as far as any grants available and see if we could find someone who will repoint the brick and see how much it's going to cost.
I would suggest you talk to the folks at the lighthouse. They have
Okay.
tons of brick buildings, and they have them repointed all the time.
Okay.
They might give you some idea of folks who can do this. It's not something that any contractor can do. You have to actually know what you're doing
Yes,
when
sir.
you repoint bricks.
Could I also ask that they do something with the parking lot also? That's been in disarray since April of 2021.
The parking lot I see as a problem. I mean,
So there was a building there, sir?
yes.
And the city doesn't recognize it as a parking lot? Because when we go for special event permitting, anyway. Yes, we will also look at doing something to the parking lot to satisfy Officer Jones.
And if I could just ask Mr. Gandy, I realize there is a big picture. We all realize that. But if you could just keep in contact with the inspector or code and get
Yes, sir.
code involved in as we try and get some resolution, at least you know their perspective coming in.
Yes, sir.
And we can know what we can do to help you get where you're trying to go.
Yes, sir. So if it's possible for continuance to September, and we'll try to address these two issues and come back to this forum at that time.
I think that you really, if you come back, though, you would need to have some kind of plan
Yes, sir.
That's a realistic plan that shows that you have either the ability to do it, you have funding, you have something in place,
Yes, sir.
not just delay for the sake of delay. Does the city have any objection
I think we'll,
to a September 7th amended order of
I
non-compliance?
think we'll reluctantly stand unopposed. How about that?
Okay,
Okay.
all right.
Or
I
cautious-
understand
I
what
should
you're
say
trying to do,
cautiously
Mr.
unopposed.
Gandy, or is it Gindy?
Gindy, yes, sir.
Gindy. I understand what you're trying to do, but this is the wrong place to come to ask for this board, this entity. I do not have the power to change codes. I have power to give you some extra time, but I don't have the power to change codes, and that's something you have to take up with the city commission.
Okay.
So in case number 55, SMG 01-2215, 504 Main Street, DB Inc., for property at 504 Main Street, I hereby order the previous order of noncompliance be amended to allow the respondent until September 7th, 2022, to bring the property into compliance or be returned to a proceeding before the special magistrate on September 13th, 2022, for consideration of a fine of up to $1,000 per day.
If I may, Special Magistrate, back then, a stop work order was applied to the property. There's no way for us to address the parking lot and take care of other items with that in place.
That is, that is not true. The stop work order was issued for doing the door without a permit. It's very clear that if the stop work order that was posted on the property stated to stop work on enclosing an upstairs doorway, it had nothing to do with the parking lot.
Communication.
So we can work on it.
I'm sorry, and applying for the appropriate permits for those activities too would alleviate the
And we
concern
have-
related to a stop work order as well.
Okay.
Yeah.
Okay.
Talk.
All right,
Yeah,
thank you,
absolutely.
thank you, thank you, thank you, folks, thank you, Special Magistrate.
Our next case is number 43, SMG 01-2244, Donald Lee and Shirley C. Gay and Creative Kids Learning Center. Is there someone here on behalf of, it looks like we've,
There he is.
sir?
How you doing, sir?
Good. How are you?
Good, man. Best I could be.
Okay, and you are?
Christopher Wilson.
Okay, and are you
Owner.
here on behalf of the respondents in this matter?
Yeah, I'm the owner of the building.
Okay, you have authority to speak for them?
Yes, I have, sir.
Okay, then if you're going to give testimony, please be sworn.
Raise your hand. You got it already? Okay. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you.
Okay,
Yes, ma'am.
all right, Mr. Garcia.
Inspector Garcia, credentials are on file. Since the last hearing, I have had no contact from the owner, and the permit is still on hold. The owner attended the TRT meeting to discuss submitting the site plan for approval. Staff request, spoke to staff request imposing a fine of $100 a day, capped at $15,000.
Okay, with today as a starting date?
Yes.
All right, Mr. Wilson?
Yes, sir. Yeah, I did the meeting. I got a an engineer doing the plan, site plan that it's supposed to be done. And it's about the concrete around there. So I'm just coming to ask this. If it's simpler for me to just take this concrete up, make it a homeless stand, I think I'd rather do that than have these fines and all that. If you could give me 45 days to take the concrete up, and I'd really rather just take the concrete up, and we'll go from there, sir. And I just make it as an empty building down there and let them have their fun down there. Because it's going too much. I'm spending a lot of money in there since I bought this property. So if you could give me, they're willing to give me them many days just for me to take this concrete up, since it's a concrete issue, I'll just like to have that.
Mr. Garcia,
Well, and like,
Jackson?
I done paid contractors, I done sprayed the concrete, I done did everything they asked me to do, and I'm still coming in here about, they said they're gonna put all this together.
discussing with staff, we're gonna allow the owner to amend to the next cutoff, to the September cutoff, to allow him to see if he gets that permit. If not,
Is this for the, he
Let me
told me
get
3?
clarification, I'm sorry, just for my inspector's sake. What I think what we want to do is allow him till September to go ahead and come into compliance. If his compliance is that he would like to remove all of that, then fine. If he wants to let the engineer proceed and
Yes,
follow the
that's-
TRT recommendations.
He told me it's 3 to 4 months out, just for the engineering. That's not even including doing whatever else we got to do.
But we'll accept his alternative plan of removal, and we'll expect something to be significantly accomplished by the September cutoff.
Yeah, we'll just take it out now. Put it at a homeless stand.
That's what we're saying. That's what I'm saying.
Mr. Wilson, you understand that the city is willing to extend the noncompliance to September 7th. And during that time period, if it's possible, you can get a submittal in, although based on your statements there, it's probably not possible.
Yes, he's,
Or any alternative to tear it up, and then there's no fines, provided that's all done before September 7th.
okay, that's 2 months, right?
That's 2 months.
All right. It's because it's too much, boss. And it's a lot of money to put a driveway and everything in there and have it done in a couple weeks.
Okay? If that's
I don't know
agreeable.
what they had in problems, but it's enough coming in here, boss.
Let them finish discussing it, and
I'm sorry, anything else? I was just
oh.
updating Captain Lee.
Okay.
Nothing's changed on the position.
if that's agreeable to you,
Fine with me, sir.
then
I think it was, I'm sorry, I think it was asked about, like, if he's going to remove the concrete. I think that's what it was, right? And just make sure you get any permitting that would be required for that demolition of that concrete. Is that what we were talking about?
to be in compliance by September cutoff,
Yeah,
whether he takes out the concrete or gets the permit.
So I need a permit to hit the concrete out?
Well, if you need to at least check with them to make sure that they're not going to require a demolition permit for it at this point, because that is something that would require a permit normally. Yeah. They may in this case, because you're removing something that was originally unpermitted, they may sign off on it, but that's just a conversation you need to have with them before you start the work.
All right.
And I'm meaning permits and licensing downstairs, right?
Yes, I've been there plenty of times, sir.
There you go.
And it has to be final.
All right.
okay. So therefore, in case number 43, SMG 01-2244, Donald Lee and Shirley C. Gay and Creative Kids Learning Center for property at North Ridgewood Avenue, parcel 533808000030. I hereby order the previous order of noncompliance be amended to allow the respondent until September 7, 2022, to bring the property into compliance. And I think maybe I'm going to be a little bit specific here, either having applied for a site plan permit, would that be the appropriate?
Yes, I was doing that right now, but I'm fit to cancel.
Either a site plan permit or the removal of the concrete pad with any necessary permits applied for, or be returned to a proceeding before the special magistrate on September 13th, 2022, for consideration of a fine of up to $1,000 per day. If that works for you,
It's work, boss.
okay.
Had enough. That's it, sir?
That's it. Thank you. All right, next case is number 44, SMG 05-22-148, Crystal One LLC, cited for failure to correct violations of the Land Development Code at Wallace Street, parcel number 533932040150. Anyone here on behalf of Crystal One LLC? No? Then Mr. Garcia?
Since the last hearing, I have had no contact with the owner and no progress has been made. Staff requests a fine of $250 a day, capped at $15,000.
Start today?
Yes, sir.
Okay. Therefore, there's no respondent, and a reasonable request has been made by the city. Therefore, in case number 44, SMG 05-22-148, Crystal One LLC, I find the respondent who was previously found in noncompliance remains in noncompliance, and therefore order a fine in the amount of $250 per day to commence on July 12, 2022, and to continue each day thereafter until the fine has reached the amount of $15,000 or the property is brought into compliance. Case number 45, SMG 05-22-153, Lofts of Seabreeze LLC is cited for failure to correct violations of the Land Development Code at North Halifax Drive, parcel number 5305-0107-0140. Anyone here on behalf of Lofts of Seabreeze? Mr. Garcia, there's no one present.
Since the last hearing, I've had no contact with the owner. No progress has been made. Staff's requesting a fine of $250 a day, capped at $15,000.
Okay, and therefore, in case number 45, SMG 05-22-153, Lofts of Seabreeze LLC for property at North Halifax Drive, parcel number 5305-0107-0140. I find a respondent who was previously found in noncompliance remains in noncompliance, and therefore order a fine in the amount of $250 per day to commence on July 12th, 2022, and to continue each day thereafter until the fine has reached the amount of $15,000 of the property is brought into compliance. Okay. Next item is number 47. Case number 47, SMG 05-22-145, Cure Property, Inc., cited for failure to correct violations of City Code at 518 South Dr. Martin Luther King Jr. Boulevard. Anyone here on behalf of Cure Property, Inc.? There's no respondent present. Ms. Kirk?
Since the last hearing, I have had contact with the owner. There has been a lot of progress. The enclosure has been installed. The permit is waiting to be finalized. Staff's requesting to amend to the next cutoff for compliance.
Okay. Therefore, case number 47, SMG 05-22-145, Cure Property, Inc., for property at 518 South Dr. Martin Luther King Jr. Boulevard. I hereby order the previous order of noncompliance be amended to allow the respondent until August 3, 2022 to bring the property into compliance, or be returned to a proceeding before the special magistrate on August 9, 2022 for consideration of a fine of up to $1,000 per day. Case number 48, SMG 03-2299, Murray Creek Properties, LLC, cited for failure to correct violations of City Code at 705 West International Speedway Boulevard and 707, I believe that's West International Speedway Boulevard.
Okay, since the last hearing, I have had contact.
Ms. Kirk,
I'm sorry.
before you begin.
Oh, sorry.
Sir?
Yes.
Your name?
Ronald Tuholsky?
Okay. Are you here on behalf of Murray Creek Property?
I am, sir.
Okay. Will you be sworn, please, if you're going to give testimony?
Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Thank you.
And Mr.
Tuhalski.
Tahalski, what is your relationship to Murray Creek property?
I own it.
Okay. Okay, Ms. Kirk?
Okay, thank you. Since the last hearing, there has been contact. There was progress. The signs have been removed, and that's all those violations regarding the signage have been remedied. However, the violation of no business license is still in noncompliance. Staff is requesting a one-time fine of $250.
Okay. Mr. Tuhalski?
Tuhalski.
Tuhalski. The staff, or the city is requesting the one-time fine of $250 for not having a business license. And what is your response?
There's no business going on there. My tenant, Mr. Farrell, he signed a lease right before COVID happened. He intended to open a business in this place, which I've told everybody before, and wasn't able to. And now that he's trying, this is holding him up. He can't get any permits or anything because of this case. We tried to get sign permits so we didn't have to pay to take all the signs down and all that, but you can't get any permits as long as this case is open. So he cannot get a business license or anything until this is cleared up. And it's the first time I've ever been guilty until proven innocent.
Okay. Mr. Jackson, if you can explain what is going on, if you
Certainly.
could.
He was found in noncompliance. He was found in noncompliance because everything about what was being presented is a business. It has the signage, it has the setup, it has the appearance, and I think there was at least allegations that a business was taking place in there. I think something about motorcycles or something, if I remember right.
Allegations.
There's the signage right there.
Right. And all of those things together said there was a business. Well, once there's a finding that there was a violation, then the burden shifts to the respondent to show that they're now in compliance. They've elected and from the very beginning and even now that they don't want anyone going in or looking inside or anything else to that effect, so they don't want to do anything that would show that there's no business in operation.
Your Honor, according to his own testimony, I mean, all the signs, everything that is including a business is gone. All that stuff is gone, correct?
The signages.
The signs are gone.
There was a sign that was shown before.
It's all gone. Everything's gone. We've done everything
Is
that
that sign gone?
Yes.
Okay.
We've done everything that the magistrate has asked us to do.
And the next picture showed Midtown Cafe.
It's gone.
Is that Midtown Cafe been scraped off the window?
Yeah, everything is gone. There's no signs on the building whatsoever.
Except they had overcome the allegations of activity that actually was
I
consistent.
mean, if that's your evidence, then there is no signs.
No, our evidence is that all of the, everything taken in totality that included the allegations of activity going on inside and the refusal to show that there's no activity still leaves them in noncompliance. The burden shift to them to prove that there's no business activity there. And the mere removal of the signs doesn't mean that they're not conducting the business activity.
What is this? I don't understand this. What does this D&G Custom Motorcycles?
That was the business that was being operated at 70. Oh, I'm sorry, I was speaking. At 705. There's another pic. That's the website, and it says open on there, with a phone number. There's another picture, with the signage up. And then at 707, there was a cafe, internet cafe, from the complaints that I received, that the police department received. There was an internet gambling establishment in there.
Was there any proof for this, or is it just hearsay?
I'm sorry. So when I first spoke with them, I gave them the notice. They corrected some of the things, but then they removed all the signage, and you can't see inside the windows anymore. Only way to verify would have been to come in, and I've been denied multiple times.
Your Honor,
The way I feel is that I feel that they're trying to strong-arm me into letting them into private property, and it's a third party's property. I've already leased this property out. Do I even have the right to let you into a third party's property? And when I met Ms. Kirk there for the violation, she showed up with 3 cops. They surrounded me and they're like, you need to sign this. It was an open-ended release to let them into my building. And I feel I have the right not to. And I don't even know if I have the right to let somebody into somebody's building that they lease. That's their private property, not mine anymore. Is that correct?
If they're leasing the property, then they're a tenant. So that's why we'd like to verify.
So you need to get the permission from him, not me, correct?
Either way is
It'll be in
fine.
violation of the code, sir.
Code of what, doing business? There's no business going on there, sir.
Mr. Jackson, this gentleman owns the building. Is there a tenant?
Yes, sir.
Okay. And the tenant has the building, are those windows? They look like there's something behind them. Is there a cover?
Maybe a covering, you know, like a paper covering, you know?
Okay. But is there anything that demonstrates that there is a business going on there?
No, there's no signs, there's no activity.
I'm asking
Oh.
Ms. Kirk or Mr. Jackson.
Only way to verify would be to allow us to look inside, seeing that there was signage up, there was business activity there before, and then once the notice of hearing, went out, then they take the signs down and cover up the windows. So we just, to verify there's no business activities for an admitted tenant that he is leasing the property to, what is he leasing it to if there's no business?
In addition to that,
Carroll was never ever able to open because of COVID, okay?
in
I
addition,
leased it to him, and he was never able to open.
In addition to that, my observations are that B&G Custom Motorcycles is advertised on the internet. They have a Facebook page. They have a website. He appears to be an operating business on the internet. Additionally, when you are on the back side of the property, you can see things being stored through the back window, like a motorcycle and other parts and or tools. There were vehicles being stored on the property that were not registered. And then were later moved off of that property.
Why is that not on the violation?
Because it was remedied, it was removed. And
Not
so those
before
are,
the violation was done.
What is,
sir, that, I'm just providing my
It's a
observations to
separate
the
case, as a
magistrate.
matter of fact.
Yeah.
The vehicles was a separate case. The
Is
case
this-
is closed.
the property that is being cited, is it 705 West International?
705 and 707.
Okay. And I'm looking at the B&G, and it says 705 West International Speedway Boulevard.
Correct?
Is that an active website?
At the time that we located it, at least, it was being held out in that manner.
Can you
yes.
buy anything off that website, or is that just something that he put on in hopes of opening and never took off the internet?
Sir, the advertisement,
buy something from this
sir, the
website?
advertisement indicates that the use is being conducted at that address. That use has not been permitted. The permit process for that use would be to obtain a business tax receipt for it. That's how we've led to where we are now. It's very clear cut.
So if
And
you were
and
to
if
go on
you
this
if you
website,
if you
buy
believe
something from that?
if you believe our observations are different or things have changed since the day that you were found in noncompliance, see the facts in this case have already
You
been
all
argued.
were there. You were there walking around looking at it with me.
Sir, the facts in this case have already been argued and a determination was already made that you were in noncompliance. So at this point, like the attorney had mentioned, the burden shifts back to you to show us that you have remedied that. So the simple way to show that is to walk us through the place and say, hey, the guy's vacated it, or we terminated the lease, whatever you did.
You're going to force me to let you in.
No, we're not forcing you anything. The outcome.
That's what you just said.
The outcome, or the effect, if we weren't able to observe that, is that you end up with the one-time $250 fine for the business tax receipt, because of the way that we've addressed it in this case.
Your Honor, I think we need a special hearing for this case because it's just like the other guy said, it's a hamster wheel. It just keeps going round and round. We've done everything that
This
the other
is in
magistrates
no way,
asked us
shape, or
to do.
form even remotely close to the other case. The other case is a long-standing business for many, many years, and they may have some claims to non-conforming use. This business does not. This
My business
business.
is no good.
I'm talking about the BG Custom Motorcycles.
Okay. I've been presented as a matter of evidence with an active website that states that there is a business and it lists its address as 705 West International Speedway Boulevard. That is good enough for me to determine that there is a business going on there. And as Mr. Captain Lee said, if you feel otherwise, then the burden shifts to you to be able to demonstrate that there is some reason why that address is on there and it shouldn't be on there.
I've explained that to the court. He did all this in hopes of opening and was never able to open. Is this website open? Can you order something from this website? Or anything else that you put on the internet is there forever? There's stuff, I mean, it's there forever until he takes.
He can take it down.
Right.
He can alter that to the extent that says something that it's out of business. I've seen that done in other matters.
Temporarily closed.
That it's closed. It's active as far as I can see. So therefore, in case number 48, SMG 03-2299, Murray Creek Properties LLC, I find the respondent to be in non-compliant of the, which is city code section specifically relates to the business license? Chapter 9, or city code, Chapter 90, Section 90-297, for the property at, let's see, 705 West International Boulevard and 707 West International Boulevard. And hereby order, respondent shall pay a fine in the amount of $250 for failure to have a business tax receipt.
Will that close this matter, Your Honor?
This particular case.
Yes.
Okay. That's why people don't do business in Daytona Beach. Thank you very much, Your Honor. That's all you
Take care.
need from me, right?
That's it.
Thank you, sir.
Case number 50, SMG 05-22-151, Mary Hawkins Yan and Sharon Hawkins Holden, cited for failure to correct violations of Land Development Code at 227 Riva Street. Anyone here on behalf of Mary Hawkins Yan and Sharon Hawkins Holden?
Okay, since the last hearing, I have had contact, and there has been a lot of progress. All that's left is some outside storage. Staff is requesting to amend to the next cutoff for compliance.
Okay. Therefore, in case number 50, SMG 05-22-151, Mary Hawkins Yan and Sharon Hawkins Holden for property at 227 Riva Street. I hereby order the previous order of noncompliance be amended to allow the respondent until August 3, 2022 to bring property into compliance or be returned to a proceeding before the special magistrate on August 9, 2022 for consideration of a fine of up to $1,000 per day. Case number 51, SMG 01-2231, Luke Childs Jr., cited for failure to correct violations of the Land Development Code at 509 South Martin Luther. Good afternoon. Gentlemen, if you could state your name for the record.
My name is Luke Child Jr.
Okay, sir?
Edward Montgomery.
Edward Montgomery.
Senator.
And are you planning to testify?
Yes, I'm going to speak.
And then please be sworn in.
Please raise your right hand, Mr. Childs.
Raise your hand.
Do you solemnly swear or affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Thank you.
I do.
All right.
Okay.
Kurt?
Thank you. Since the last hearing, I have had contact, and there has been progress. Staff is requesting to amend to the next cutoff for compliance.
Sir, is that acceptable?
We're just wanted 2 months.
2 things, okay.
Just need 2 more months and we're done.
Oh, you've got 2 things left to do, and then you're finished?
Yes, I just have one thing. I just have to get her to come out. I gotta paint the board and put 1 5-foot on it,
Okay,
and that's it.
okay. That's why the next cutoff is August 3rd, so hopefully that will give you sufficient time to get all that done.
Can I just get another one just because, see what the point, it ain't the point of doing the work, he's on a fixed income. And the money, what we finna get it, pay the person out to do it, it's gonna take him 2 months to do it. It's gonna take a 1 month, one part of his money 1 month, and part of the money for the next month. That's the only reason I wanted 2 months.
Is that a home or?
No, it's a building.
Okay,
It's just a building that he have, and he's on fixed income, and we trying to keep it up.
okay. Well, it looks good on the front.
Yeah, we painted the whole building, and it was just the facing that she had to do.
The city is agreeable to giving them the
Okay.
2 months. We are aware that that situation was mentioned before as well, so.
You got you.
Right? Okay.
Okay.
Thanks.
Thank you, man.
Hopefully that gets it done and we'll just not have to see it back here in the first place, yeah.
Okay, therefore, in case number 51, SMG 012231, Luke Childs Jr., for property at 509 South Martin Luther King Boulevard, I hereby order the previous order of noncompliance be amended to allow the respondent until September 7th, 2022, to bring the property into compliance, or be returned to a proceeding before the special magistrate on September 13th, 2022, for consideration of fine of up to $1,000 per day. But it sounds like you won't be back, so. Good luck.
Thank you.
Case number 52, SMG 0522-139, Dwayne C. Campo, cited for failure to correct violations of Land Development Code at 411 South Ridgewood Avenue. Is anyone here on behalf of Dwayne C. Campo? Mr. Klieg?
Yes, sir. Since the last meeting, I had no contact with the property owner, no progress. The house is on Ridgewood Avenue, so the city's recommending a $100 day fine capped at $15,000.
Okay. Therefore, is there a picture of that?
Yeah, it should be.
Well, if you don't have one, is it your testimony that there's still dirt and grime on
Oh,
the
yes,
house?
sir. Dirt and grime, the peeling paint, porch is bad.
Okay. Is a porch still untreated?
Yeah, it's untreated, yes, sir.
Okay. Therefore, in case number 52, SMG 0522-139, Dwayne C. Campo.
Right, it's right there.
Oh, okay. That's the property?
Yeah, it's right on Ridgewood.
Okay. Therefore, case number 52, SMG 0522-139, Dwayne C. Campo, for property at 411 South Ridgewood Avenue. I find a respondent who was previously found non-compliance remains in non-compliance, and therefore order fine in the amount of $100 per day to commence on July 12th, 2022, and to continue each day thereafter until the fine has reached the amount of $15,000 of the property is brought into compliance.
It's a 10 or 50?
50.
Okay.
Okay, therefore, case number 53, SMG 0522-141, Bin Zhang, cited for failure to correct violations of the Land Development Code at 405 South Ridgewood Avenue. Is Bin Zhang present? Mr. Klieg.
Yes, sir. It's house is next door to the last one. Since the last meeting, I had no contact, no progress. City's recommending a $100 a day fine capped at $15,000.
Okay. Mr. Bin Jiang is not present. All right. Therefore, in case number 53, SMGO 522-141, Bin Jiang for property at 405 South Ridgewood Avenue, I find a respondent who was previously found in noncompliance remains in noncompliance and therefore order fine in the amount of $100 per day to commence on July 12, 2022, and to continue each day thereafter until the fine has reached the amount of $15,000 or the property is brought into compliance. Case number 54.
Yes, sir.
G 05-22-143, Living Realty and Investments LLC, cited for failure to correct violations of the Land Development Code at 2735 North Atlantic Avenue.
Yes, Your Honor. We are on Zoom.
Yes, I can see you on Zoom. And if you provide me with your names, and if you are going to give testimony, you'll need to be sworn.
Okay. My name is Alfred Sam. My mom is also online, but I don't think she turned her mic on. Mom, can you raise your hand and take an oath? Okay.
She'll need to provide her name as well.
Okay. Her mic is not on. I can call her on her home phone and tell her to.
If she's not
Raising her hand.
if she's not gonna,
asked her to.
if she's not gonna have her mic on, she's probably not gonna be able to testify. So it won't probably be necessary to swear her in, right?
I guess if she doesn't have her mic.
Okay.
Okay. Her first name is Paul, P-O. Last name Sam, S-E-M. That's her name.
My name is Sam.
Oh,
there she goes.
My name.
My name is Alfred Sam.
Okay. Do you solemnly swear to tell the truth, the whole truth? I'm sorry. Do you solemnly swear or affirm that this testimony you're about to provide is the truth, or the whole truth, and nothing but the truth?
I do.
Thank you.
Okay. Mr. Jones.
Yes, this case was opened back in February of 2022, excuse me. This is for an unmaintained vacant lot. It's the old Red Lobster site up on A1A. This is here for a progress report. I can state that no landscaping has been maintained, no mowing has been taking place on this property since this case opened. They have sent me an email that they were on site and picked up a little trash inside in the parking lot itself. What the staff is requesting is compliance for the next cutoff. They had stated that they were going to put together a project and submit it to the city, but there's been no project submitted for use of this property. It is located the school is located right behind it, and with the landscaping not being maintained, the residents next door, that's the Bel Air condominium, I received complaints from them due to parties going on in the parking lot, things being thrown over the wall. We would just like this to get into compliance.
Yeah, this property has a pretty extensive history with both us and the special magistrate. It's been before the special magistrate multiple times. It's received fines for some of these violations as well, even going to the extent of us initiating, the foreclosure process, and ultimately them remedying that foreclosure process by paying the fines. But yet the violations have continued to persist and not be corrected, and we're just that's why we're back before you again.
Okay. Is this the same response?
Okay. So I'm going to help my mom to tell you the progress. We want to change this. My mom is now 77 years old. She has a limited budget, but I've been talking to a person who owns a bunch of hotels in Lake City. and he is interested in having a land lease. We want to have the site get to the highest and best use. So I'm in negotiating with him to have a land lease. So he's going to bring one of his hotel to Daytona. He lives in Lake City, but he wants to move closer to the ocean. And we are in talk of that. And about the overgrown vegetation, we are going to have some professional guys to maintain it. I hope the city can give us some time so that I can submit a major site plan. I have talked to Hannah Ward of the building department. I learned the progress, how to approach to get a major site plan. And I hope that eventually this empty land will turn into a hotel this gentleman owns, and because he wants to build a hotel there.
Okay.
If I can give a little bit more information from back to the last hearings we've had. The last time back in May, they were going to go ahead and submit to the city that they wanted to do a car wash and parking lot here. They did meet or talk to Hannah Ward, who gave them all the information they needed to have to submit that, and nothing has been submitted to date. We're just asking for a finding of noncompliance.
Yeah,
We
I'm
have
going
a
to
finding
add.
of noncompliance, but we want to set a compliance date.
Your Honor, I'm going to add to that. Yes, the initial plan was to build it into a 4-store car wash, because I have looked into the project, and that is the most inexpensive way to turn it into something that is functioning. But when we were going through that plan, this gentleman that I know who owned the hotel in the Central Florida area, he owned hotels in Lake City, Ocala, and Gainesville, and also Valdosta, Georgia. He's interested in having a land lease, so I've been in talk with him, and that's happened during the last few weeks or so. So initially, we want to change it to a lower budget, like a 4-store car wash, because there is a beach entrance very close to that site, and I have talked to people who park on the ocean, on the beach. They are interested in washing a car once they leave that beach. So that's the initial plan, but like there's a change in plan right now.
Sir, the recommendation from the city is to amend the order of noncompliance until August 3rd. Okay?
Can I request one more month? Can I
I don't believe, I understand that you may have potential leads for use of the property, but this proceeding is not about those leads for the use of the property. This is about bringing the property into compliance.
Okay.
Okay, and there are certain things such as the, I wouldn't call it landscaping. It looks like it's just totally unkempt.
What was
And therefore, these things need to be remedied. And whether or not you have mentioned, based on what I've heard here today, other potential purchasers, these are all pie in the sky. And right now, we have to deal with the real fact of the matter that this property has to be brought into compliance, okay? It has to be.
Yes, sir.
The weeds and the overgrowth and everything else has to be remedied.
Yes, sir.
So that's what we're here for today. And God bless you if you can get somebody who buys it or can put it to good use. That's wonderful, but that is not the role of my proceeding here to deal with that. I
Yes, sir.
hope you have best of luck in that regard. My focus is on bringing this property so that it is not an eyesore and
Yes, sir.
bringing it into compliance with the codes. So the staff has made a recommendation that this property would come up again in August, at which time there would be consideration of whether or not a fine would be levied. That's not going to happen today, but in August 9th.
Yes, sir.
So if you have potential purchasers or issues that relate to that, or you want to send people out there to actually deal with the overgrown weeds and grass and brush that might work to your benefit. All of those things are out of compliance, and the more you can bring things into compliance, I suspect the more likely the city is willing to work with you, right?
Absolutely. Thank you.
It's just out of control. So therefore,
Yes, sir.
based on what I've heard in case number 5, let's see, this case number 54, SMG 05-22-143, Living Realty Investment in Investments LLC for property at 2735 North Atlantic Avenue. I hereby order the previous order of noncompliance be amended to allow the respondent until August 3rd, 2022, to bring the property into compliance or be returned to a proceeding before the special magistrate on August 9th, 2022, for consideration of a fine of up to $1,000 per day. So you
Yes, sir.
have now an entire month to do whatever you feel is necessary to bring that into compliance or comply with the city codes. And at that time, it will come back before the special magistrate, who will then determine whether or not what should be done, whether additional time should be provided, or whether a fine should be levied, or whatever remedies are available. But for
We
right
understand.
now, you've just gotten another month. But again, it would probably work to your benefit to go up there and try and remedy some of those things, such as the landscaping, which is, well, I wouldn't call it landscaping, it's just like it's overgrown.
Yep, just for clarification purposes, what was ordered in previous hearings and what we're really trying to achieve now is that the lot is returned to a vacant lot and maintained properly. Yep.
Correct.
Yep.
And so your interest and the city interest could coincide when that's a vacant lot that looks like an acceptable vacant lot in the city of Daytona Beach.
Thank you, sir.
You have
Understand.
another month to see what you can do about trying to accomplish that.
Thank you.
But if it's not brought into compliance, and you can get with Mr. Jones, and he can fill you in on what you need to do if you don't know already.
Okay.
As to what to do, and you have until August 9th.
Thank you.
Okay. Very good. Our next case is number 57, SMG 01-2247, 540B LLC, cited for violations of the Land Development Code and City Code for property at North Beach Street, parcel number 5-338-2503-0070. Anyone here on behalf of 540B LLC? Mr. Jones, there's no respondent present.
This case was opened in August of 2021 for no development approval for using the site as a parking lot, parking on unimproved surfaces, an accessory structure without a permanent structure, and outside storage. The applicant met with the city back in September of 2021, and they were notified they needed to have a site plan that showed the violations corrected. They were back before a hearing on May 10th. The engineer was present, stated he needed additional time because he needed to obtain a survey to design the site plan. Last evening at 8 o'clock, I received an email from the engineer stating that they had just hired a surveyor and would need another additional 6 weeks before they could even start doing any design on the site work. The pavement that they installed without a permit and they were told had to be removed has not happened. There's still parking on the site plan, which they were told they had to quit parking on that property. And they're still using the fenced-in area right here to store vehicles. Most of them are unlicensed junk vehicles. Staff is requesting a fine of $250 a day with a cap of $20,000.
Okay, to start today?
Yes, sir.
There's no one present here today. They're certainly aware of today's hearing if their engineer called you last night.
He sent me an email, and he was aware of it. My understanding from him through the email that somebody representing the owner was going to be here. But this is the area, as you see here, where they're parking on what's supposed to be a unimproved grassy area.
Mhm. There's been no approvals for that paving?
No.
Okay. Therefore, case number 57, SMG 01-2247, 540B LLC. I find that the for property at North Beach Street, parcel number 5338-2503-0070. I find the respondent was previously found non-compliance, remains in non-compliance, and therefore order fine in the amount of $250 per day to commence on July 12th, 2022, and to continue each day thereafter until the fine has reached the amount of $20,000 or the property is brought into compliance. Case number 58, SMG 01-2248, 540B LLC, cited for failure to correct violations of Land Development Code and City Code at Bungalow Street, parcel number 5338-2503-0050. Is there anyone here on behalf of 540B LLC? There is no one here. Respondent is not present. Mr. Jones.
Again, this case opened back in August of 2020. This is a parcel that is attached to the previous parcel. This one was cited for, it's a fenced-in area on this property. The fence was not permitted and could not have a fence because there's no permanent structure on this parcel. They are using this parcel for junk vehicles. You can see in some of the photographs, the vehicles are damaged. They don't have tags. They were cited to remove the storage Connex container, and none of that has happened since we originally cited them back in August. They are still in violation. Staff is requesting a fine of $250 a day with a cap of $20,000.
Okay. Mr. Jones, it looks like there's a business that's operating out of there.
Well, they're running different businesses out of there. The last I heard, some wrecking company was using this area to store junk vehicles that they had, pulled from wrecks. There is no business license attached to that. The parcel is not designed or approved for anything but a vacant lot per the city. It's not approved for this use.
Okay. Based on what I see, this certainly seems a reasonable fine to impose, and therefore, in case number 58, SMG 01-2248, respondent 540B LLC for property at Bungalow Street, parcel number 5338-2503-0050. I find the respondent who was previously found non-compliant remains in non-compliance and therefore order a fine in the amount of $250 per day to commence on July 12, 2022, and to continue each day thereafter until the fine has reached the amount of $20,000 or the property is brought into compliance. Case number 59, SMG 01-2212, Victory Temple of God, Inc., cited for failure to correct violations of the Land Development Code for property at 1047 Madison Avenue, parcel number 5338-01-180065.
What's your name, sir? R.T. Hillary? Okay. Yes, right here. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
And your affiliation to?
Victor Temple of God. I'm the chairman of the trustee board.
Thank you.
Okay. Mr. Jones?
Yes, this case was open for dilapidated buildings. Since the last hearing, they have gone through and received planning approval. They are in the process of getting their final approvals on this. We would like to ask to amend to the September cutoff, but with an exception that they police the property a little bit better. We've been getting reports of trash being dumped on the property or shopping carts being left there. But otherwise, while they're getting their approvals, we'd like to amend it to the September cutoff.
Okay. Mr. Jones, if they don't police the property, could they be cited separately on that?
Well, this is part of the original violation.
But that would constitute a new violation.
We could do a new violation. Our concern is, all we're asking is occasionally to have someone, if they could have someone, and we do realize that they're from out in Orlando.
Seminole County, Sanford.
Yeah, that someone comes by, they just have somebody, they are maintaining the yards, the landscaping's getting cut. The problem is it's a very large property, and I think even though they have it posted, people are taking advantage and occasionally dumping stuff on it. We're just asking they just maintain that.
I just want to be sure it's really the maintenance of the property that's the issue, that if I'm giving a 2-month extension, that there is a remedy if.
Yeah, the 2-month extension
But I don't expect, I'm hopeful that you will keep the property policed and.
The 2 months extension is, this is a very large parcel with many buildings on it. They're in the process of getting all approved. But we just want to make sure as they go through those steps that they also maintain the property. As you can see, the grass has been maintained, but even in that photo, you can see someone probably dumped all those palm fronds in the back, or the shopping cart that you see sitting on the side.
Okay. Sir, is that acceptable?
Yes, sir.
Okay. Therefore, in case number 59, SMG 012212, Victory Temple of God, Inc., for property at 1047 Madison Avenue, parcel number 533801180065. I hereby order the previous order of noncompliance be amended to allow the respondent until September 7th, 2022 to bring the property into compliance or be returned to a proceeding before the special magistrate on September 13th, 2022 for consideration of a fine of up to $1,000 per day. And as stated here today, that the city is asking that the property be policed, and if it's not properly policed, then it could be initiation of another violation for the new whatever issues that might arise. Don't expect that, but they want to be sure that you, because of your distance from this property and the fact that it's large and vacant and open, that it just be maintained.
Yes, sir.
Okay. That should do it.
All right, thank you.
Thank you. Okay. Case number 60, SMG 012260 Boardwalk at Daytona Development, LLC.
And this will actually be 60 to 67.
Yeah, for violations of, Mr. Baptiste, is there any problem?
Well, yeah, I was gonna explain how we'd like to handle these, or ask how we'd like to handle these, but I don't know if you wanted to swear him in first.
Why don't we swear you in first?
My name's Mark McDonald, Boardwalk at Daytona Development LLC. I'm the controller,
And McDonald's smelled like McDonald's.
like the restaurant without an S. Yes.
Will you raise your right hand and raise? Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
So, Mr. Mr. Riggio, case 60 through 67 are adjacent parcels. They the violations are consistent across all of those parcels, or they were at the time when we started this case. The testimony you're about to hear is related to all of those parcels, and we just ask that you consider all the testimony from both the respondent and us as it relates to all of those cases at one time, just to kind of speed the process up. In addition to that, we are aware that we've been in some communication. City staff has been in communication with Mr. McDonald, and there's been some delays on his part due to some unforeseen medical issues that he was in his family that he was dealing with, and we were just there is progress still occurring. They are working towards combining the lots. They're working towards resolving the approvals that they need to be approved. I think they have a second iteration of a site plan submitted that's just being reviewed and waiting for a response. And really, we're just asking to amend. Were we amending next cutoff or September cutoff? What was? Did you have? Let's go September cutoff. I think that gives us plenty of time to get all the approvals done.
I believe we should have everything done by then.
Okay. I seem to recall this from months ago.
Right.
I think I heard it when you presented it the first time, where you were aggregating parcels over on North Atlantic.
Right. And we had to get a survey and the, not an easement, we had to get the survey and the title work done, I'm sorry. I have all that in my hands now. I'll be submitting that with that so we can combine all these and we don't have this issue in the future. And then we're proceeding with all our other things with the engineers. I also had to get a topographical survey done for the ADA parking spaces. So that kind of got thrown in later. We've got that in the works and being done. And we're just proceeding, like Officer Lee said, to get it all completed.
Okay. Mr. Jean-Baptiste, anything to add?
No, sir.
Okay. Mr. McDonald, do you have any objection to the city's recommendation of amending your notice of compliance until September 7th?
That's fine with us. Thank you.
Okay. And Mr. Jackson, I have a question for you. This is somewhat a little bit different. Can I aggregate all of these, or do I need to do whatever it is, 8 or 9 of these separate?
I think if you announce it as doing it at this point, just for the sake of the issues of compliance and non-compliance, and we could address separately if we come to the point of non-compliance and fines.
So I'm looking at just one order that deals with all of these.
I don't know, I was a little confused by what you said, though, that this isn't up for compliance or non-compliance. This is imposition of a fine, so it's just amend.
Oh.
It's not up for
Yeah, but I mean,
compliance. We're just amending, we're
Right.
putting off that date. The city's putting off that date till September.
Right,
7th.
clarification.
Yes.
We're not at the point where we're at this moment where we're seeking fines. If we were seeking fines, we may want to separate it to address each parcel separately. But at this point, we're addressing them as a whole for a continuance or an amendment would be, I don't believe that's going to cause any concerns.
Okay, so therefore, for case number 60, SMG 012260, case number 61, SMG 012261, case number 62, SMG 012262, case number 63, SMG 012263, case number 64, SMG 012264, case number 65, SMG 012265, case number 66, SMG 012266, case number 67, SMG 012267, all of which have as a respondent Boardwalk at Daytona Development, LLC. I hereby order the previous orders of noncompliance relating to each of those cases be amended to allow the respondent until September 7, 2022, to bring the property into compliance and be returned to a proceeding before the special magistrate on September 13th, 2022, for consideration of a fine of up to $1,000 per day.
Thank you, sir.
Mm-hmm.
Thank you.
All right. Case number 68, SMG 012273 Sandals US LLC. Is there anyone here on behalf of Sandals? Sandals US LLC, who has been cited for failure to comply with Land Development Code at 151 South Atlantic Avenue. Is there anyone here on behalf of Sandals US LLC? No? Mr. Jean Baptiste, proceed.
So this is a continuation or set of progress report for our compliance date. Since last hearing, I've had no communication with the owner or the owner's representative. They have painted the property. However, as you can see in the pictures, there is still a broken window. There is still other things that need to be addressed. At this time, staff is requesting a finding of non-compliance, compliance by the next cutoff.
Oh, okay. Was this still in the compliance, non-compliance?
No, I believe there's been a finding of compliance, non-compliance. It's just looking for a compliance date, I believe.
Yeah, I'm sorry, compliance date.
Okay.
We're just
Well,
double checking.
That was what, if the compliance date is supposed to be set at today's hearing.
Correct.
And they're not here.
Correct.
Yeah, there was prior finding of non-compliance.
These aren't.
Progress report.
So, yeah, there was some prior order of non-compliance, so we're looking just to set a compliance date.
Okay. So, do you want to set a compliance date, or do you want to, how do you want to handle this?
Actually, it looks like we had an order of compliance, non-compliance. What happened there?
We're trying to confirm in the file for you
Yeah,
real
we
quick.
got more stuff that happened this moment.
73.
Generally, a compliance date is followed then by the possibility of a fine if you don't comply with the compliance date.
I'm looking at 012273.
Yeah, there was a finding of non-compliance, and compliance was ordered by June 8th.
Yeah, the last amended order of non-compliance was order in compliance for June 8th. So actually, yeah, where did it be finding for the,
So yeah, at this point, you have the choice to request a fine or request amend the next cutoff. What,
I would like to request a fine of $100 a day.
well, I'm not quite
I'm
sure.
reading from the minutes from
Yeah.
May, and Mr. Vukelja his finding was that special magistrate amended the current order of noncompliance in order to respondent to bring the compliance by June 8, 2022, or be returned to a subsequent meeting for consideration of a fine of up to $1,000 per day.
I think what we'll do, if it's okay with everybody, is we'll request amend the cutoff, or next cutoff, partly because our public notice of the agenda is incorrect. So I think that would be in the best interest of the respondent,
Okay.
if you guys agree with that.
Yeah, that's my thought as well.
Okay.
I mean, it's indicating what's a progress report, and a respondent reviewing that may not have realized the necessity to be here to oppose a fine.
Although it's kind of like if they're doing a compliance date, it's kind of like having a handshake with only one hand.
Yeah, that's the unfortunate thing, right?
Yes. So therefore, in case number 68, SMG 012273, Sandals US LLC for property at 151 South Atlantic Avenue. Hereby order the previous order of non-compliance be amended to allow the respondent until August 3, 2022, bring property into compliance or be returned to a proceeding before the special magistrate on August 9, 2022, for consideration of a fine of up to $1,000 per day.
And Mr. Magistrate, what we'll do also is that, just because there's a bit of confusion here, we'll make sure that we send the amended notice or the amended order certified, and we'll post it at the property as well, just so that they're clear about what their compliance date is.
All right. Case number 69, SMG 0322-113, Sandals US LLC, cited for failure to correct violations of the Land Development Code at 140 South Ocean Avenue. I would expect that this is also,
It's exactly the same scenario. Yes.
okay. So therefore, in case number 69, SMG 0322-113, Sandals US LLC, for property at 140 South Ocean Avenue, I hereby order the previous order of noncompliance be amended to allow the respondent until August 3, 2022, to bring the property into compliance, to be returned to a proceeding before special magistrate on August 9th, 2022, for consideration of a fine of up to $1,000 per day. Okay, case number 70, SMG 012259, Agro Parcel and Associates LLC, cited for failure to correct violations of Land Development Code at 402 Auditorium Boulevard. Is there someone, are you here on behalf of Agro Parcel?
Yes, I'm the owner.
You're the owner? If you could, are you going to testify?
Yes.
You need to be sworn in.
What's your name, sir?
My name is Xavier Gill, G-I-L.
That's probably this one.
That's 1L.
One.
You raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Thank you.
Okay. Mr. Jean-Baptiste, can you present the position of the city?
Absolutely. Since last hearing, I've had communications with the owner. About everything is done at this time in terms of the physical property. However, the building permit has yet to be finalized. Having talked to the gentleman, there were some issues with contractor. At this time, staff is requesting to amend the next hearing.
Okay.
You mean to the next cutoff? or-
Next cutoff, I apologize.
Sir, do you think that you can get everything wrapped up by August 3rd?
Yes, I was hoping it'll be done by this Monday, but couldn't do it, so, well,
Okay.
contractor.
Well,
didn't
those
work.
are the options that are available. And August 3rd gives you some extra time.
Yeah, sure. Thank you
Okay.
for that.
Therefore, in case number 70, SMG 012259, Agro Parcel and Associate LLC, for property at 402 Auditorium Boulevard, I hereby order the previous order of noncompliance be amended to allow the respondent until August 3, 2022, to bring the property into compliance or be returned to a proceeding before the special magistrate on August 9, 2022, for consideration of a fine of up to $1,000 per day. Thank you.
Thank you.
Case number 71, SMG 0422-130, Talib LLC, cited for failure to correct violations of the Land Development Code at 601 Main Street. Is anyone here on behalf of Talib LLC? Mr. Jean-Baptiste?
So it's worth noting that Talib LLC, this property changed hand. There's a new owner, and so at the last hearing, we were going to give them enough time to take care of the situation. The owner is Life's a Beach Rentals, Yates Jack Senior, Yates Jack Senior. The notice of violation was posted on May 27, 2022, with their reinspection on July 8, 2022. However, based on our conversation, he still needs more time. That's the new owner. As such, staff is requesting to amend to the next hearing.
Okay.
To the
Next cutoff.
Next
Sorry.
cutoff.
Same hearing.
I'm sorry, did we actually amend and add the new owner last hearing?
Should have.
Did you read into the record? That's what I'm asking. Did you bring in the change of ownership document and read it into the record, or was that something? It's not reflected on the agenda, that's why I'm asking.
I'm looking at the minutes, but there has had contact, but there's been, and I'll read from the minutes. Inspector Baptiste states that at the last hearing, he has had contact with the owner, but there's been minimal progress. However, it's worth noting, the property was sold recently on April 22nd. And he says, I did verify that with the county clerk of court website, yet it has not yet hit the Volusia County Property Appraiser's website. At this time, we wish to amend to give the new owner the opportunity to be cited and come into compliance.
Yeah, I think we just had a
But there's nothing in the
miscommunication.
disposition that states that the new owner
We would make that request now, that since I believe we're amending the next cutoff is a request, but also amend the order to include the new owner, Life's a Beach Rentals.
Life's a Beach Rentals. Okay.
And there's a Jack C. Yates Sr.
Is that an additional owner?
That is an additional owner that's on the new property, what's listed on the property appraiser site at this point.
The business name is Life's a Beach Rentals, the owner, Jack Yates.
Jack C. Yates Sr.
Correct.
Okay, I'm sorry if I could just, Life's a Beach Rentals, is that an LLC? Is it, what is that?
It doesn't indicate, sir.
But I can check for you.
And the other question would be whether Jack C. Yates is a principal of Life's a Beach, or is he an independent owner?
Is he listed individually on the deed?
It's listed as, they're both listed on the property appraiser site. As same as you would see two owners listed, it's listed in that same fashion.
That's the PCPA website, Volusia County Property Appraiser.
See, yeah, because the property appraiser's website would not be our absolute. Pull a deed if you can.
Yeah, I can probably do that right here in 1 second. The Life's a Beach Rentals does not show up with the Inford as an LLC, as a corporation. So we would have to do additional research to answer your question on that.
It's not on the Sunbiz website?
It is not.
Oh.
At least under the,
I'm wondering what's showing on the deed itself.
yeah, I'm pulling that for you right
Okay,
now.
right.
Yes, sir.
And yeah, we would need some clarification on
Seems kind of odd to have
put on the deed.
a name but not have a business in it.
Yeah, but not really exist, yeah. Looks like the transaction was a warranty deed recorded on April 27th of 2022. The deed was completed, it looks like, on the 22nd of April, 2022. And it changed hands between Talib LLC to the name Jack C. Yates Sr. So I think we would probably request is that it just, the case be amended to include the new owner as Jack C. Yates Sr. Is that what you like?
That's from the, at least from the current warranty deed. Perhaps the Life's a Beach is a fictitious name or something that hadn't been clear.
Business.
Yeah, business.
That operates there, but not an owner of the property.
Right.
It could be.
All right.
And if it's anything different, I'm sure when we get contact from them, we can get that clarified.
Then in case number 71 SMG 04-22-130, Talib LLC for property at 601 Main Street. I hereby order the previous order of non-compliance be amended to allow the respondent to allow the respondent until August 3, 2022 to bring the property into compliance or be returned to proceeding before a special magistrate on August 9, 2022 for consideration of a fine of up to $1,000 per day, and also order that the case style be amended to include the new owner, Jack C. Yates Sr.
And I will send this deed over to the clerk so she can add it as part of the record for the proceeding.
Okay. Case number 72 SMG 0322-115, Blue Daytona 1 LLC. Cited for failure to correct violations of the Land Development Code at 103 South Ocean Avenue. Sir, you finally get your chance.
Oh my goodness, been here. I've been trading stocks all day, so I'm okay.
And your name is?
Daniel Mondrian.
Okay.
You've been giving out tips, man.
And what is your relationship to Blue Daytona 1?
I am the general manager of the property for them.
Okay. And if you're going to give testimony, you will need to be sworn.
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
You're welcome.
Okay, this has been continued from the May meeting, a progress report and compliance date. Mr. Baptiste.
At this time, we're here for a progress report, so we'd like to hear what Mr. Mondrian has to say.
Since our last hearing in May, we have completed our boundary survey for the property, which we needed for the United States Army Corps of Engineering to get their plans in order. They did complete their plans. They were submitted to the reviewer, and they have been approved. I believe they filed for permitting last week, and looking forward to get the actual permit in hand by next week sometime. And this week, we have contractors on property for bids on the job.
Okay, if I can ask, what kind of permit are you applying for? You need Army Corps permit?
It was the engineering, it's for the seawall.
Oh, seawall,
Yeah.
okay.
It would be helpful with that. I mean, that was a lot of information that was very helpful, but it will be helpful for us to know when you expect the project to be completed, knowing that you probably won't be able to work in some of that area right away.
Correct. We are aware of the turtle nesting season. And just from hearing other communication correspondence throughout the day, I know it seems like we won't be able to do anything until at least November 1st. I'm happy with the progress we made since our initial hearing back in March. Our GC has been working on this to get the project going. Happy to see that the paperwork has been submitted for the permit. Right now, it's time-wise. They're looking to get 3 bids from 3 different contractors for it. And again, I'm looking at November 1st as the start date. We should not need more time than that to start.
Okay, if I understand, you have a project, something you're building there, I assume, and you needed a seawall permit, and that won't kick in really, you won't be able to do anything until after November 1st.
Correct.
As far as the other parts of your project, are they all approved plans?
The other parts were cosmetic painting of the seawall and all that. That has been completed.
So
Yes.
you don't need any further permits?
Yes, sir.
Once you get.
I think you're trying to clarify the same thing I was going to ask, is that have you gotten approvals from the county and the state already?
I'm not part of that.
Yeah.
Our GC handles all that.
Okay.
I'm just relaying the correspondence.
If you could put him in contact with JB, the inspector here, and because we need to find that out. Looking at it, I don't see a permit with us, but he's probably referring to maybe another permit from the county or possibly the state. He would need probably all 3 of those in this scenario unless they tell him otherwise, because it's adjacent to what is part of the seawall. So.
Yeah, you're probably need something relative to
It didn't clarify
construction.
in the email I sent. It didn't clarify
No,
where the permit was.
The email that I received simply, this is from DEP, Department of Environmental Protection, that there is a permit that was applied for the seawall.
Okay.
There is some repairs that needs to be made, that's why this is happening. And so this is all I received. that Mr. Mundrin had sent over.
Well, it sounds like you've started the most difficult part of the process. Just don't forget, or make sure your GC doesn't forget in the process. He's going to have to get county sign off from county coastal, most likely, and there's going to have to a permit ultimately pulled from us as well.
And just for clarification, I know that this, are violations as they appear on the agenda are shorthand. But I noticed it says discolored and peeling paint and then damaged concrete. Is that referring to the
That's the
seawall?
same area, yeah.
So that's all referring to
Correct,
seawall,
correct,
because we don't
correct.
make that clear reference
Correct.
on the agenda. So just for the record. So
The only thing that's in compliance, for the purpose of what's in compliance, is the dead vegetation. That's no longer an issue. However, everything else is in regards to the seawall. Once that repair is made, everything else will essentially clear itself out. Is that correct?
But the painting of the seawall itself was done.
Okay.
The concrete on the steps,
I would have to go and inspect that.
yeah, it was all covered on the May hearing. You acknowledged.
With all that said, I think probably the appropriate amend in this scenario, they're well on their way, is probably the January cutoff. We probably won't have a December meeting, I would assume, like we don't normally do each year. So the January cutoff, with the hopes that it's just done and completed and resolved by then, and we won't have to come back.
What is the January cutoff?
Whew, that's a good question.
Well, we could look. Wednesday before the first meeting.
Is it the Wednesday before the meeting?
Usually, yeah.
I will find it for you real quick.
One more on calendar.
February 9th.
Our meeting will be the second Tuesday,
So is it the 4th of January?
so it should be the fourth. Should be our typical. You said Wednesday? Okay, yeah, I believe it's the 4th of January. I would expect it to be the 4th of January.
Yeah, that's in line with the earlier this year's cutoff as well, so.
You're pushing the envelope. We're now moving into the next
Yeah.
calendar year.
I'll take it.
4th of January? Okay. Therefore, in case number 72, SMG 03-22-115, Blue Daytona 1 LLC, I hereby order the previous order of noncompliance be amended to allow the respondent until January 4, 2023 to bring the property into compliance and be returned to a proceeding before a special magistrate on, what would the hearing date be?
The 10th.
4th?
There we go. Yeah, I agree, the 10th.
January 10th, 2023, for consideration of a fine of up to $1,000 per day. But that's way off in the
I
future.
think we have enough time. Just concrete and some rebar in that one corner. It's just that the engineering took quite a bit of time for them
Right,
to get
but
it
you won't be able to begin work until turtle season ends, so you'll be much closer to that date when
And
you
I'll-
start your work.
I'll give them a date of December 1st to complete. They don't need to know.
Yeah.
The earlier you get it done, the earlier we can sign off on it, so we're good either way. Yeah.
That's it. All right, thank you, guys.
Thank you.
Can we take a quick five? I just.
We will take a quick
Yes, you
5-minute
definitely
break.
will.
It is now 3:29, and we will be in recess for 5 minutes and resume at 3:35. And I call to order the resumption of our afternoon session of the Special Magistrate proceeding for Daytona Beach on July 12, 2022. We have now are in the final portion of the proceeding dealing with lien reviews, and our first lien review is SMG 09-21-264, Lucio Ramirez, 1001 South Ridgewood Avenue, who has, at this time, an outstanding lien, which I see to be, with the recording fees and interest, $15,238.76. And
Want to swear him, Mr. On these, I know that typically in the past, we started with the respondent. But I have information to provide on most of them today, but I didn't know if you wanted to swear them in at first in that order.
I think it would be good to be sworn in.
Okay, what's your name, sir?
Lucio Ramirez.
Okay. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
So my name is Scott Lee. I'm a police captain with the City of Daytona Beach. I oversee neighborhood services. Mr. Riggio, we met with most, if not all, I think it's almost all of the folks seeking lien reviews. As you know, we've changed our lien review process in a hopes to kind of speed up the process and try to get these things that have already come into compliance moved along and clean the plate so that, respondents can move on maintaining their properties in the future, and the city can move on from that case and move on to other things to address in the city.
Yeah, I think it's important to note that there is a lien on these properties that limits what people can do with the property once there is a lien on it.
That's absolutely the perspective we have too. We don't want those things to continue to remain out there as just an obstruction to getting things done and progress going forward. Again, these are cases that have come into compliance and then sought to apply for that lien review process. In this case, when staff met with the folks related to this property, they agreed to, or I'm sorry, what was discussed, and all of it's contingent upon, of course, your review and your approval. We agreed to come before you and submit a collective request to reduce the lien to $8,000 total, payable within 30 days.
Okay.
And I do think we have the inspector here, if you have any questions about facts related to the case, and of course, the respondent's here to speak as well.
Okay.
Well, yeah, I mean, in the beginning, I don't know, I will have a meeting to extend time for the court, for giving days to fix the problem. And when I find out it was a lien, there was too many issues to fix that because, I don't know, I had to get permit. And then they asked me to get a permit to do the wall. And then after that, I had to do a survey that took like 3 months to do it. And then to get a permit, it takes another month. And, when I finished, I was working on that. So on the meeting, I feel like I don't have no choice to pay. I tried to reduce it way to $5,000, and they say no. And so I say, well, if you say, hey, I agree with that, but I was not, I know I was working on that, I feel it was not my fault, Even I talked to the inspector, the problem, I was in contact with him, and he said, no, take your time, no problem. So I feel, I tried my best,
Okay.
Nothing I can do,
All right.
Question.
Well, Mr. Ramirez, the city is saying that they discussed with you an agreed-on resolution of $8,000.
Yeah, they did.
Is that
that's what I feel. I don't have no choice, because I don't want to be in this, situation in court and all that.
Okay. One of the things, it's a balancing act between liens, which are the final way to get the attention of respondents and fines. And that is the tool primarily that is used to bring these matters to a close. On the other hand, as I said, that a lien does create issues for a property owner. It's difficult to get lending. You can't sell the property frequently without paying off a lien and things of that nature.
Yeah.
So it's a balancing act, and the city has an interest in seeing properties being used for productive purposes as opposed to sitting perhaps vacant and because the property owner can't make use of the land. And as Captain Lee said, apparently the figure of $8,000 was discussed and was considered to be a reasonable
Yeah, I wish, if you can help me a little bit better, better, but you can't, you know what I mean? Because I feel reasons why I don't finish the work,
Well, it's very difficult, and this is one of the reasons, the problems that I have is that everybody would prefer to pay less,
Yeah.
and the lien is imposed. It's not like it's a secret. And generally, it's imposed at a point where the city feels that it is not getting the kind of response. As you probably saw, you sat through the hearings today, there's a lot of these amended orders of non-compliance that keep the lien clock from starting. And usually a lien or a fine is imposed at such time that it's felt that it's necessary to sort of move things along.
Yeah.
And so, therefore, taking all of this into account, Captain Lee, you said $8,000 would be the amount that it would be reduced to?
Yes, sir.
Okay, so I think, unfortunately, the way this is done through a lien reduction. So that would be a reduction of $7,238.76?
Yes.
From, okay.
Yeah, I was just reviewing the numbers real quick. Yes.
And taking all of these factors into account, I am agreeable to reducing the lien by $7,238.76, which would result in a remaining $8,000 that you would need to pay to the city. Okay, and understand, and I know there's some others of you out there, that amount needs to be paid to the city within 30 days of my entering the order. So it's kind of a two-way street. You get absolved of something, but the city also gets some money. And if you don't comply with that, then the reduction goes away and it goes back to what it was.
Okay.
So.
Yeah, one more question. Sorry, this is a different thing, It was another lien that I don't know about that lien for the people I purchased. I don't know if they bring out that.
Mark.
When I purchased the property, it was the lien, but it wouldn't show when I purchased it.
Another lien on the
After
property?
they show after I purchased it.
The lien, the whole
Another
point of the
lien.
lien is to have it recorded so it does show up when you purchase the property.
Yeah, that time,
Lot clearance?
that time now, because the day was after I purchased it, and the problem was before that I purchased it, and they don't appear on the.
Well, I can't speculate on something
Yeah, all right.
that I'm not aware of.
Yeah, that was just.
I don't think, I think what's maybe occurred here is that the application for lien review did not include that in it.
Oh.
And, I can go back and look at that, and we can always bring that it would have been listed as a separate lien review anyways. Each lien is independently looked at. So
all right.
we can go ahead and research that for you. If it's something we need to send you an application for or something, we can get it brought back before here if that's something that needs to be resolved. Is that on this particular property?
Yeah.
Same property? Okay.
Yeah, it was been a long time ago
We'll
since
check
I
on
bought
that.
it.
Yeah, we'll check on that, and we'll communicate
All
with
right.
you about that.
Mm-hmm.
Okay.
Mr. Riggio, I think as we go along, I know how you worded it, and that's fine in this case, but the way they write the order is based on whatever the total amount is due at that point. So if it's easier for you, rather than saying two different figures, you can do that in the future if you want.
I don't want confusion because I do lien reductions because the lien actually exists at this point.
Right.
And so I am not essentially saying you pay this amount. I'm saying what you should pay has been reduced by this amount.
Yeah, I think the order says something to the effect of reduced to the amount of $8,000 contingent upon being paid within 30 days. But,
Well, let me go.
Yeah, however you'd like to do it is fine. I was just trying to be helpful.
Then let me do this, and I'll start with this one. In SMG 09-21-264, Lucio Ramirez, for property at 1000 South Ridgewood Avenue, order lien in that case to be reduced to the amount of $8,000, subject to being paid within 30 days, or the fine will revert back to the original amount. So you pay the city $8,000 within 30 days, slate's clean.
Mr.
If you-
Rizzo, I'm sorry, go on.
And again, I always put this caveat, if you run into any problem in making any payment during that time, you need to contact, in this case, Mr. Jackson, city attorney, immediately.
Just call,
Oh,
yeah, well, you,
Brenda?
it's actually, I'm sorry, it's Kim Reno, who you've already been speaking with, yeah.
Okay.
If you have an
need to
issue.
contact
Yeah.
City staff. But don't come in 40 days later and say, I didn't pay you, I want to.
Oh, no, we'll take
Yeah, if there's some reason you can't meet the 30-day deadline, contact us as soon as you know that in advance, and we have the ability to be able to adjust those timelines as needed, based on the customer's needs and what we think is reasonable.
They will send me a bill, or I just come and pay at the.
Yes, we will email you a invoice of the reduced, the amount that it's reduced to, and you can either pay it online or you can come into City Hall and do it. There'll be a link in the email for you to be able to pay online.
But it is important, in 30 days, it goes back to
That is
the
correct.
15,000 figure.
I see. No, I'll take care of it for 30 days.
Okay. That's it.
All right, thanks.
Thank you, sir.
Okay, next case is SMG 0322108, Edward P. Heapie, Fulton Street, for property at Fulton Street, parcel number 533866000100. And the amount of the outstanding lien at this time, I believe, is $3,274. And sir, I've probably mangled your name. How do you pronounce your last name?
Hafey.
Heafy.
Hafey. It's close enough. I've had it all, but Hafey is the actual pronunciation.
All right. Well, thank you.
Is it okay to proceed? Oh, he needs to be sworn, I think, right?
Yes.
Ms. Brenda, if you don't mind.
Yes, sir. And it's Edward Hefty.
Yeah, Hafey.
Okay. Will you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
So, Mr. Riggio, similar to the last one, city staff did meet with the applicant, and through that conversation, both parties agreed that they felt it was acceptable to present to you an option to resolve this at reducing it to the amount of $1,500 payable within 30 days.
Okay. Is that acceptable to you, Mr. Heafy?
I don't know about the 1,500. I guess that's per property. I guess there's two cases.
That is correct. Yes, sir.
Okay, but just to address it in general, just as a layman, I don't know if this is a new policy or a new way of handling these cases, but I'm sure it's beneficial to the city. It moved through these cases faster, but I don't see how it's beneficial to the public. I went to this meeting. They told me to come to the meeting so that I could avoid, they said, come, we'll take care of this. And then it's basically, I guess it's like a rubber stamp that, but now I moved it up so I could go on vacation. I've been here all day waiting for this Zoom meeting while I'm on vacation. And there doesn't seem to be it's not an opportunity to contest the case. So there's not really any point in me. I can see from the previous person that the meeting that I went to with staff, they're very friendly, but it didn't seem like any opportunity to discuss, I don't feel like I should be charged anything, but that's not, that is what it is. But if that's the end of it, what is really the purpose in sitting through the meeting today?
Yeah.
Can you?
I take that. I take that note, and we probably will figure out a way to schedule these better. We have some logistical issues with when the other cases start, and we're going to try to modify that, because I do agree. One of the benefits of coming in and having that pre-meeting is to not have to sit here and wait and then go through long, drawn-out lien reviews. This is a new process, and we're trying to improve it, and I do appreciate that feedback. I wasn't present during the meeting,
but those meetings are, intended to hear what you have to say that's in line with reasons why it would be reduced, meaning, was there a hardship? Was there issues that, prevented you from really getting the work done before the lien went into, or the fine went into place? I will meet with staff and make sure that they're expressing that and giving everybody those opportunities. I think that's all I have to say.
Well, we discussed them. It's just that they can't make any, they're basically making a suggestion to me. What do you think? We're going to propose this amount to the magistrate. And I mean, I have these properties under contract, so I don't have any choice. It is what it is, but I was never notified. And I've had these lots in the city for 20 years. I've never had any liens against them. We've always taken care of our properties. As I mentioned to them in the meeting, there used to be a woman that called me and we'd always take care of them. When I got notification by phone call, we went out and had like $500 worth of work done to the property. Somebody had dumped some things on the property. And then I called to see if, to try to contact someone, and I didn't hear anything back. And then when I finally did hear something back, there had already been a meeting and I had to go out and then spend another $1,000. That's not including, all the taxes I've paid and all the maintenance I've paid on these properties. We had to tear a house down on that property 20 years ago, but we used to build houses back before the crash. But, we went, once we knew, we cleaned the property completely, but I was never notified of any issues, or I would have taken care of it right away. But because I'm closing on the property, it's just, what can I say? It's like it didn't feel like that meeting was a place to argue a case. It was just, we're going to suggest this to the magistrate, and that's what it is.
So I think it's important to recognize that this really isn't about arguing a case. This is a process that the city's not required to go through. This is something that the additional that the city does to try to resolve these things so that they're not looming over the property owner's head and there's not just an uncollected debt out there that the city isn't pursuing. We want to resolve these issues as much as the property owners do, and that's why we enter into these conversations. It's not a requirement under the law. It's something additional that we do to try to resolve it. I think that Mr. Riggio specifically, you've mentioned that some of the problem is that we get in here and it is like we're rehashing or rehearing the case, and that's an unintended consequence of a lien review. People feel like they want to come in and discuss the merits of the case, but those things have already been ruled upon. They've been decided. When people apply for application for a lien review as part of this new process, we do check that notice is intact, the due process was followed. Mainly because most of the time, the first thing that people mention when they come into the room is they didn't know. So we come in prepared to discuss that. If we identified a due process issue, it would be a totally different conversation. We would be telling them that we would be setting it for miscellaneous business or resolving the fact that we failed to meet due process, without them having to come in and ask for a lien review reduction.
Mr. Heafy, I'm partially responsible for this process because frequently I'm hearing lien reviews on cases that I know nothing about. I was not involved in them. And quite frankly, legally, the failure to appeal a case basically brings things to a conclusion. That becomes a legitimate lien against your property for which you really have no recourse. You can't relitigate something where the period of time for an appeal has expired. This is just a sort of an accommodation that the city has made to try to keep properties viable and active, and to assist property owners in trying to bring resolution to these matters. It's not an opportunity, as Captain Lee said, to start relitigating and talking about things that may very well have been a basis for an appeal, but if the appeal wasn't taken, those arguments are waived, they're gone, they no longer exist. And so this brings finality to these issues and allows things to be resolved. That's what it is.
No, I understand entirely.
Otherwise,
I
you would
don't,
have a piece of property that if you are in the process of selling it, would have a lien, a legitimate lien against it for $3,724. And your closing agent would take that out and remit it to the city.
Right, no, I understand.
And so we're just trying, it's an attempt to try to cut out some of the arbitrariness, because everybody who came before me always says that they almost want to pay next to nothing.
No,
although
no,
they
I
were fined.
understand.
And the fines are legitimate. And so we're just trying to find a resolution to speed this along and make it work for your benefit, for the city's benefit. Everyone gets to wipe the slate clean.
I understand. I appreciate your time. The only one suggestion, and I don't even know if it's possible, but when I attended that meeting and I agreed to it, I just want to be done with the property. I'm not really arguing. I mean, I wasn't notified properly, but I just want to be done with the thing. It's not a big deal. But if there was something I could sign at that meeting and it could just be presented to you, it could be notarized, whatever, then I don't need to come to this meeting. And I don't know if that's possible, but it might save a lot of people the time of sitting through these meetings when they've already agreed to the reduction.
Yeah, and we've, if people can't be here, we still would have presented the same conversation. But I think the city's position and probably the magistrate's position is they prefer people be here so that they could hear from them. They did. I take the note, though, and if there's some type of way to do an affidavit or something in the future, maybe we look at that. But we'll have to have staff look at that process and think about that. Again, thank you for that feedback.
No problem. I appreciate your time. And I guess we got another case we got to do.
Okay, well, I have to do these individually.
Yeah.
So therefore, SMG 03-22-108, Edward P. Heafy, for property at Fulton Street, parcel number 533-866-000100. I order the lien in that case to be reduced to the amount of $1,500, subject to being paid within 30 days, or the fine will revert back to the original amount. Again, if you run into any problem in making payment during that time, you need to contact the city attorney immediately.
The only one question I brought up in the meeting, and I just wanted to clarify, this would be the same for the next case, is this is set to close in a couple of days. Will the title company be able to get notification from Ms. Reno or someone that this has been cleared and it's that the title company can collect that amount of money at closing? And
yes, sir. We will email over a invoice showing the new amount due, and we can. I'm assuming we have your email from the application process. If not, if you call Ms. Reno, if you spoke to her that way, then we can get the email from you and get it over to either you or the title company. Either way, but yes, that can be resolved rather quickly, probably within the next 24 hours. So.
Great.
Let me say this, the closing agent is not going to be able to close until the city provides it with a release. And I would expect right now they are looking for a release in the amount of $3,274 that would be taking out of the closing proceeds.
Yeah, they typically will take the invoice and they'll just escrow that amount of money, and they'll just they'll want the release at the end of that to be able to back up their file.
So
yeah.
Yeah, historically, they've relied upon, in good faith, our responses to them in terms of what the status of the
city sent them essentially an estoppel.
Yes, right. That would have the same effect, yes, by indicating the status of the lien through the lien review process.
All right.
Yeah, our title company's been in contact with Ms. Reno, so I'll just have them email her.
That's perfect.
Thank you.
Okay, SMG 03-22-109, Edward P. Heafy, Fulton Street, parcel number 533-866-000060.
Mr. Riggio, same facts on this one. City staff met with the applicant, and the parties agreed to bring before you a suggestion to reduce the amount to $1,500 payable within 30 days.
Okay, Mr. Heafy, that's The amount will reduce on this one?
Great.
Okay. Therefore, in SMG 03-22-109, Edward P. Heafy, Fulton Street, parcel number 5338-66000060, I order the lien in that case to be reduced to the amount of $1,500, subject to being paid within 30 days, or the fine will revert back to the original amount. If you run into any problem in making payment during that time, you need to contact the city attorney immediately.
Okay, gentlemen, thank you for your time.
Thank you. Okay, are we moving to lien review 4?
Yes, sir.
SMG 05-21-126, John and Mary Ann Odell, 1304 North Shangri-La Drive. This was an outstanding lien of $15,000.24. Good afternoon.
My name is Darrell Levine. I'm co-partnering with John Michel Bureau, and we own Earth Alliance, and we're planning on building a house on that property. We bought it as a tax deed.
Okay.
So I need, I guess, to swear in and whatever.
So you bought it as a tax deed? You
Yes.
bought all these encumbrances with it?
We found out after the fact.
Okay.
I need to swear you in.
Yeah.
And what's your name
Please be
again, sir?
sworn in.
Darrell,
D-A...
R-Y-L,
Oh, Daryl, okay.
Darrell
All right. And last name again, sir?
Levine, L-A, capital B as in Bravo, I-N-E.
Okay.
So, Mr. Riggio, on this one, staff met with the applicant. Oh, we forgot to swear. I'm sorry. I'm jumping the gun.
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Riggio, we met, city staff met with the applicant, discussed the property. I actually believe that the city, and we didn't come to an agreement on this one. So I'm just going to tell you how we closed the gap, and then ultimately the respondent, I'm sure, has some stuff to say, and then we'll just leave the decision up to you. On this one in particular, I think the city, if I'm recalling, we started around a reduction of maybe, I think it was like the $10,000 on this one. And ultimately, in the conversation, they wanted it reduced to zero because their intentions of building a home on it, a property that they're going to, move into the market, basically moving this lot into some type of use. When they expressed that to us, I think in the conversations where we ended up making the recommendation that it be reduced to $5,000, and that's where the conversation. It was a good conversation, but at the
5,000, there's two ongoing.
right, we're doing two.
Just
We're doing them
one
separately.
right now.
Yeah. And so we reduced to $5,000. Our offer to them was $5,000. And they were still kind of stuck at zero, mainly because he needed to confer with his business partner and talk to him before he could really make a decision and respond back. I did receive an email from him yesterday, and they offered to resolve both. It was like a global resolution, both liens and all of the lot clearance liens, which we don't have the authority to resolve here, for a total of $8,000. And unfortunately, like I said, the lot clearance liens themselves total $3,553.30, I think, right around there, roughly. And we don't have the authority to reduce those because those are money that was expended by the city, citizens' money that was used to cut this lot. There's quite a few lot clearance cases on this lot prior to their ownership, of course. So that would basically mean that we would be spreading a reduction of $4,446.70 across these two different liens. City staff just doesn't think that that's appropriate in this scenario. It is a property that was bought at tax deed sale. There was some due diligence that was expected of an owner that buys in that situation, and also somebody who invests in that way and buys property at tax deed sales knows that is a potential hazard or risk that they take. I think a reduced to $5,000 offer that we asked was rather reasonable on our part, and we do like the idea of them putting the property into use. We think it'll be better maintained in that way. But we kind of ended there. And so the way I look at it is if you divided that $4,446, you're roughly right around $2,200 on each property over these next two lien reviews, or not each property, I'm sorry, each case, each lien review. So I feel like the gap is closed down to between that number, $2,200 and $5,000. We're close, but we're just going to need you to make a decision somewhere in there.
You said $5,000 for each property.
For each property.
Total of 10,000.
For total of 10,000.
Yes.
Okay.
And with the understanding and clarity that will not resolve or cover any lot clearance liens. Those will be things that have to be resolved separate from this hearing. We don't have the authority to be able to release those liens.
Okay.
Yeah.
I didn't realize that, but, anyway.
Because it's expended community dollars towards abating something, those are not things that can be
Paying for
reduced.
somebody to actually do the mowing and removing.
Yeah.
It's a service fee.
Yeah, okay, then if you don't ask, you don't know. So,
Absolutely.
yeah, so, okay.
Okay.
That's it. That's where, that's up to, I'm not
Sir,
sure.
do you have anything that you want to add?
It was a good conversation with this, Captain Scott Lee, and the other gentleman was there. Mr. Garcia, which is the officer, was not available to attend for some reason. It doesn't matter. I had a good discussion. Yes, this is the first time my partner and I are coming into buying a house or buying a property to build a house. So maybe we have to do more due diligence, But as soon as we got it, the 18th of March, I cut the lawn. I actually had 3 neighbors come up to me at 5 o'clock at night and thank me. They thought I worked for the city cutting the lawn. It was quite interesting. But anyway, we moved forward and we've been maintaining it. We're just waiting for these 2 issues to rectify, and we're actually waiting for the survey guy to go back onto the property, and then we're going to submit all the paperwork. I do have the plans, and this is what the house will look like, what we're planning on doing, and I would like it reduced, but I understand. I did happen to see, I went online and saw the videos live, and I believe, and I just, you had said that the fine was against the respondents, the Odells, and this is a whole new process for me, so I'm kind of enjoyed it, but it is a long, tedious one in its own way, and I leave it at your discretion.
And I do need to clarify, Mr. Riggio, that is correct. The original lien is against this parcel and against the previous owner, and that we would ask that this be a partial release, no matter what decision you make, releasing the parcel from the lien if that amount is paid within 30 days, but the remainder part of the lien remains in place against the named party.
Okay. Usually when somebody loses a property in a tax deed sale, they don't have much remaining.
Well, this
been
was
my
an
experience.
interesting one. It was an arson. My partner had seen the property and was going to rebuild it, and then it was torn down. We happened to we got together and we bought the property as soon as but the Odells are long gone.
And quite honestly, Mr. Riggio, if you did a full release in this scenario, the city's not going to argue on that. We just do that as a procedural. That's how we would procedurally handle it normally.
Okay. I'm looking at these, and in total there's 30,000 plus in liens.
Yeah.
And from what Captain Lee has said, the city is willing to reduce that amount from 30,000 down to 10,000, which would be a third, plus the lot clearance liens, which the city, Mr. Captain Lee does not have the ability, nor I, to waive. And I'm usually a split the baby type person, and now we're doing thirds, so I think you did pretty well if you're down to 5,000. And to be honest, from my perspective, buying property at a tax deed sale is a fairly sophisticated thing. There's not that many people who know you can buy properties at tax deed sales, and the statute's pretty clear as to the things that are waived and are not waived at the sale.
Okay.
And so I think that what Captain Lee has stated is something that I could live with, but I can't live with going lower than that.
Okay.
So,
Well, I've asked, and that's all I can do.
okay. Then, therefore, I order the lien in case number SMG 0521-126, John and Mary Odell, 1304 North Shangri-La Drive, to be reduced to the amount of $5,000, with this being a partial release, not releasing the liened party, John and Marie Ann Odell, from any liability for the remaining portion. Subject to being paid within 30 days, or the fine will revert back to the original amount. So for your purposes, the lien will be
5,000 for the first one, 5,000 for the second.
Well, I have to do them separately.
Okay, yeah, okay, yes.
Your lien, if you pay the 5,000, the lien as to your interest in that property would be cleaned, but there would still be a remaining lien against the Odells.
Oh, okay, yes.
Okay?
That's great.
I assume that Mr. Jackson would probably be drawing up that paperwork?
It's a standard document that we
It's a
have.
standard document?
Yeah.
Okay. And we'll do the same thing with the second one, SMG 022277, John and Mary Ann Odell, 1304 North Shangri-La Drive, parcel number 5330-02-01-0100. I order the lien in that case to be reduced to $5,000, with the remaining amount to be still due and payable from John and Mary Odell, and subject to being paid within 30 days, or the fine will revert back to the original amount.
And I remember you saying that on lien number, the lien number 4 about.
He did.
I did.
30 day. Okay.
Oh, the 30 day? I think.
Did I say that? If I
Yes,
didn't,
you did. Yes, you did.
Subject to being paid within 30 days, or the fine will revert for both of them. If you don't pay it within 30 days, it goes back to the 15,000.
No, well.
You're
okay.
not forgiven anything.
Yeah, well, I'm not Odell, I'm Earth Alliance is the company.
Well.
Okay, I just want to make sure that.
Yeah,
This is an arrangement between the city of Daytona Beach and you, Earth Alliance.
Okay.
That Earth Alliance has a 30-day window
Okay,
in which,
okay.
if it pays the city
No, it will
$5,000,
be paid within
it
a
will be
few days,
released.
yes.
from that lien.
Okay.
Yeah, the parcel will be released, and
Okay.
you'll be free and clear as far as.
The only thing I was bringing up is I didn't hear Earth Alliance in this, it was just the Odells.
Because you weren't subject to the original lien. That's why.
Okay, okay then.
It's just the property that we're releasing.
The idea is that you would pay it because you want the parcel released, so it's free and clear for you.
Okay.
Yeah.
It's, yeah, okay.
And understand that the outstanding amounts for lot clearance liens, neither I nor Captain Lee have authority to waive. And
Okay.
that's a separate
Unfortunately.
Oh, well, I tried.
Okay, thank you.
Thank you, Your Honor. It was an interesting day. Will I be getting mail to me, or what?
Did we have your email address already?
Well, yeah.
You submitted it. Email.
Yeah,
We'll
Ms.
send it.
Rena.
Yeah, Ms. Rena, yeah, she'll send it to you. No problem.
Okay, next item is SMG 01-1209 David Walker, 147 Kingston Avenue. And the outstanding lien in this matter is $15,024.
Can you state your name for the record, sir?
Yes, David Walker.
All right. Will you raise your right hand?
Yes.
Do you solemnly swear or affirm that the testimony that you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
So, Mr. Riggio, this is one that city staff met with the applicant. They spoke about the details about the case and the lien, and through that process, they agreed to collectively come before you and recommend that this be reduced to $5,000 payable within 30 days.
Okay, Mr. Walker? That's acceptable to me, if it's acceptable to you.
I'm in a bit of a dilemma, Magistrate. I'd like to start off by saying that when I agreed to meet with this, to have a review done, I was led to believe that I'd be meeting with someone who actually had the authority to hear my concerns, to hear my case, and to consider what I was requesting, which was a complete waiver of the fees. Now, when I got there, that was not the case at all. It already had been pre-planned, the amount that it could be reduced to, because Mr. Jones and Mr. Stinson, they were there at the meeting, were limited in the amount that they could reduce the fines, the liens. If I had known that I was not going to be going before a magistrate, I may not have agreed to going to the lien review. My request is that, as a respondent, that I be given 2 minutes for each case, just 2 minutes, to make the points that are very valid that I could not express at the lien review. And upon doing that, I'll accept your just decision.
All right.
City
Mr.
doesn't-
Walker, I don't know if you heard me before, but what these lien reviews have turned into are essentially trying to rehear a case. And there is a way that that is handled. It is handled through an appeal. And then if appeal isn't taken, then I'm really not interested in rehearing a case. That decision was made. That's just the way this is the way it is. I was finding myself in these lien reviews having people argue that, you know, various things that they could have argued during the case, which they suddenly now remember or didn't bring to light, or they brought the things that they felt were worthy of, you know, a reduction in fine, or a reduction or related to their culpability or what have you with respect to the case, but they failed to ever take an appeal. And this is not a second appeal. If there was a right for an appeal and that time period is expired, then it's case closed. And these proceedings were really intended for somebody such who, for whatever reason, I think there was one a while back where they couldn't sell the property, and the property was a derelict home, and they needed to have a reduction in the amount of lien to be able to sell the home, to improve the neighborhood, which is in the city's best interest. Okay, that's what this is about, the city's best interests, and trying to bring resolution for all of the parties, not about rehearing the case. And I'm looking right now at your lien review request, and most of it focuses on things that relate to the conduct of the case that was held. And I'm not going to rehear cases. I can't do that. If facts should have been brought to my attention, then, or to any, I don't even know if I handled this matter. In a number of these lien reviews, I never even was involved in the setting of the lien. So it just makes it an impossible situation. And so what I'm trying to do is trying to work a process that brings the properties, brings peace to both you and the city, and allows things to move on. And if you want to ask for 0, you can, and I can also say no. And so that is where things lie as far as I see it.
Okay, I just want to state that I was told that you had the authority as special magistrate in the meeting, that you had the authority to.
Well, I have the authority.
Yes.
That's how this is done. On the other hand, I felt very uncomfortable with people coming before me trying to re-argue a case that was closed. And I'm not reopening them. I think that that's not correct.
Okay.
This is, the lien reviews relate to things that provide for the benefit of both the city and the property owner in terms of creating an encumbrance on a home or a property that somehow affects it and the surrounding neighborhood.
And the city also feels as though it's kind of, we're entering into a good faith conversation with these individuals. And it seems like now we have a pattern throughout the day here where people now want more than what was discussed in that room. And it's just putting us in a bad position because, you know, of course, part of why we did this was to speed the process up, but part of it was because we felt as though we were forced to always come in and say no reduction. And we didn't think that that benefited the city, and it doesn't benefit the property owners, and it doesn't really get us to a path of solution. And we're trying to avoid that. So here we've entered in, come in the room with what was agreed upon. You know, the parties are told during these meetings, all applicants are told that any decision that's discussed in that room is contingent upon the review of either the code board or the magistrate. They have to agree that it's acceptable and reasonable and approve it. You know, we'll add some information. I mean, it's often discussed with most people who want to rehear their case in the room too, that the process of rehearing the case has already been resolved. You had a hearing, you were found in noncompliance, there was some time given, and ultimately down the road, a fine was imposed. When that fine was imposed, you had a period of time for appeal. If you didn't appeal, like you said, those issues are over.
And Ms. Magistrate, if I could just, for clarification and clarity, this case actually arose in terms of, from the minutes in 2012. So in January 2012, as well as the minutes from January 2012, as well as the minutes from February 14th of 2012, shows that Mr. Walker was present and there was an ultimate ruling by Mr. Vakelja of the violation.
And I would add to this, Mr. Walker, just so you're aware, in law, there's a certain thing called finality. At some point, the game is over. The teams may be close in the 9th inning of a baseball game. That doesn't mean you play a 10th inning because they're close. The one with the highest score wins, and that's sort of the same process that's used in legal proceedings. The lien was lawfully imposed, and you have an opportunity to reduce it. And I look to both the applicant or the person who is asking for the reduction. I also look to the city. And if there is something you can't agree to, then there is no reduction. And that's simple. And so.
May I make a statement, sir?
You can make a statement, sure.
Yes. As I said before, my request was a simple one. I was led to believe rather by being informed by Mr. Jones that coming here I would have some recourse. I just want to say that I will accept your statements, but only in the light of this one particular case where a lien is being imposed upon a property that was demolished within days of the lien being imposed. And on top of that, I did not get a notice of the hearing. I have documents here showing where...
Sir, once again, you are going back to issues that should have been raised. They are now no longer valid.
Okay.
I have no interest in hearing those, okay, because the time period for raising those issues, and there's a problem with that as well, and it's something that courts often have to deal with is that very old evidence often and issues sometimes are not really what they seem. And if they're not raised in a timely fashion, they're no longer available for argument. And these issues could have been raised a long time ago, and I'm just not going to hear them now because those time periods have elapsed. So the city has stated, I believe that with respect to lien review 6, it can live with a reduction to $5,000.
Yes, sir.
And if that's not acceptable to you, then the lien, there will be no lien reduction. Is it acceptable?
Yes, sir. That's fine.
Okay. Therefore, with respect to lien review 6, SMG 011209, David Walker, 147 Kingston Avenue. I order the lien in that case to be reduced to the amount of $5,000, subject to being paid within 30 days, or the fine will revert back to the original amount. Again, if you run into any problem making payment during that time, you need to contact the city attorney immediately. Okay?
Lien review 7 is the same circumstances, same respondent, or I'm sorry, same applicant. The city and the applicant agreed to bring before you an offer of $5,000 to resolve this issue. Reduction to $5,000. Payable within 30 days, sorry.
Okay. Mr. Walker, I'm agreeable to $5,000. Is
So
that
am I, sir.
agreeable to you?
So am I, yes.
Okay, then in SMG 1111-117, David Walker, 147 Kingston Avenue. I order the lien in that case to be reduced to the amount of $5,000, subject to being paid within 30 days, or the fine will revert back to the original. Again, if you run into a problem making payment during that time, you need to contact the city attorney immediately.
Sure.
I know this seems, from your standpoint, to be somewhat perhaps a harsh result. On the other hand, you have $30,000 in liens against your property that have been reduced to $10,000. And the only one who can reduce that amount is the city. There is, as far as I know, no other legal recourse at this time, especially given the age of these liens. And so you are better off today than you were yesterday.
Of course. Thank you.
Mm-hmm.
All set?
Yes, sir. We'll review your email. Right? Is that how you sent the application in, was by email? Yes. Oh, we have it then. We'll send you an invoice for them both. Lien review 8, 9, 10, and 11 were all pulled from this agenda with hopes that they'll be back before you at a later date. Lien review 12 is where we're at, Mr. Riggio, when you're ready.
Okay, that's what I'm looking at. This is SMG 10-19-237, Alan J. Battle, 729 Lotus Lane. And I have a total lien amount of $17,288.40.
Do we have a respondent on Zoom for this by chance? Okay. Yeah. Well, this applicant was a no-show for our meeting, our pre-meeting. They're no-show today. Don't appear to be on Zoom, so we would recommend that this not be heard if the applicant's not here to actually speak on their behalf or have a meeting with us beforehand. I don't think there's any reason to hear the lien review.
Okay.
Or our city's position, if you do want to hear it, is no reduction.
I don't mind having it brought back again if you want to contact him. I am looking, though, at his lien review case and his request, and essentially he's trying to re-argue issues that could have been raised back in the previous proceeding.
For finality, what we like to do is when someone applies and they do not show up is to ask that you would deny the request without prejudice.
Okay, then that's fine. I will deny the request without prejudice for SMG 1019-237, Allen G. Battle, 729 Lotus Lane. Okay. Lien Review 13, SMG 06-19-135, Remco LLC, Wilgens Massalian, property is at 397 Jefferson Street. Do we have someone coming forward?
You can go. Yeah. Oops.
I'm okay.
Brenda.
Can you state your name, please?
First name is Shu, S-H-U. Last name is Dong.
I'm sorry, last name again?
Dong, D-O-N-G.
D-O-N-G. Okay, and your affiliation to this?
I'm the new owner.
Will you raise your right hand, please? Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Thank you.
Okay.
Mr. Riggio, staff met with the current owner of this property, the applicant for this lien review. During that conversation, both parties agreed to present to you a remedy of it being reduced to $7,500 payable within 30 days.
Okay. Ma'am, is that agreeable?
Yep.
Okay.
I wish it all went like that.
Well,
It's always the ones right at the end.
Mr.
Therefore,
Jones,
in
we already
case-
agree.
SMG 06-19-135, Remco LLC, Wilgens Massalian, property at 397 Jefferson Street. I order the lien in that case. Do you want this to also be a partial release?
Oh, yes, I'm sorry.
Okay. I order the lien in that case to be reduced to the amount of $7,500 with the remaining amount to remain a lien against the original property owner. Essentially, a partial release against something that the property owner owns, but no longer against this property. Your property would be free and clear of this lien, but if Mr. Massalian bought another property in Daytona Beach or wherever, it would become attached to his property.
Understand.
And
Just for clarity, I think there were two individuals on the previous lien. I think it was
Yes.
Remco LLC and then Mr. Massalian.
yeah. And it becomes they still would walk around with a partial lien of $7,500 against them, against other property that they may acquire,
Understandable.
okay? And that is subject to being paid within 30 days, or the fine will revert back to the original amount. Again, if you run into any problems in making payment during that time, contact the city attorney immediately, because once the 30 days lapses, it goes back to the original amount.
You're hitting that deadline. Just call Ms. Reno, like you've been speaking to, about the application process, and we'll take care of helping you out from there.
Okay.
Okay?
Thank you.
Thank you.
Okay?
Yes, we're on to miscellaneous business now.
We now have 3 miscellaneous business items. Miscellaneous Business 1, SMG 01-2233, Russell J. Dukes, 116 Anita Avenue.
Mr. Vikelja, this case was brought to my attention upon review. I discovered we had a due process error where the property owner was not properly not properly noticed at the initiation of the case. There was no first notice given. As a result of that, I reviewed it, and it's just one of those cases where we needed to vacate the finding of noncompliance and vacate the fine. Ultimately, just for some background information, the tree that was removed was a dead tree. And it was in danger of falling on the property. In our photos, when you review the case, you can see that the tree was very clearly dead.
Okay.
It would not have required a permit in this case.
Okay, and is Mr. Russell J. Duke still the owner of this property?
He is, yes.
Okay, so,
And I've been in contact with him. He was unable to attend here today, but it's our error we're trying to correct here.
okay. So therefore, in case SMG 01-2233, Russell J. Dukes, 116 Anita Avenue, I order the lien in case number, or in that case, to be reduced to the amount of 0.
Could we, I think we would like to vacate the order of finding a
you would prefer it
noncompliance
be
and vacate
vacated?
the fine. Yeah.
Okay. All right. I hereby order that, the,
Would be both the finding of noncompliance as well as the lien.
the finding of noncompliance as well as the lien be vacated in case number SMG 01-2233 Russell J. Dukes for property at 116 Anita Avenue.
Thank you.
You can't help me on this one, I don't remember.
I would also like, I assume the city will prepare a release of lien. Otherwise, it'd be something in the public record.
Yes, we will. As a result of you vacating it, we will prepare a release of lien that supports
I'd like to
that.
just add that to my
Oh, go ahead.
order, and that the city will prepare a release of lien.
Absolutely. Just stand by. I think I got you.
Okay. In case number SMG 01-2233, Russell J. Dukes, property at 116 Anita Avenue, I hereby order that the finding of noncompliance and order imposing fine in that matter be vacated and the city prepare a release of lien.
Perfect. I think anyways.
Miscellaneous business 2, SMG 01-2105 Tiger DB LLC, 2655 West International Speedway Boulevard. And there is a lien in the amount of $15,000.24, or $15,024, sorry.
So this is another one that was brought to staff's attention. Upon reviewing the case, we discovered that a change of ownership happened to occur between the time frame the case was sent to our support staff to come before the magistrate and prior to, well, it was after they sent it to them and prior to the finding of noncompliance. So therefore, the finding of noncompliance was really against the previous owner who no longer owned the property. This case kind of proceeded forward and ultimately ended with a fine. It is one that we need to ask to have vacated again because the owner at the time the fine was imposed had no idea about I guess we legally couldn't show due process of notification to them. We subsequently went back in and we'll address it with a new owner if the issues are still out of compliance.
Okay. Therefore, in miscellaneous business 2, SMG 01-2105 Tiger DB LLC, property at 2655 West International Speedway. I hereby order that the finding of noncompliance and order imposing fine in that matter be vacated and city prepare release of lien. Final matter, Ms. Gao, I guess, left, so.
Yeah, we told her she could go. It's again, we're correcting our error. So we didn't feel like tying the rest of her day up for this one.
Okay, miscellaneous business 3, SMG 10-21-282 Pelican Bay Golf Club LLC, 370 Pelican Bay Drive, parcel number 5236-00000030. And there is a lien in the amount of $20,000.24.
Yeah, Mr. Riggio,
I'm sorry.
Oh, I'm sorry, go ahead.
$20,000, $20,024. It's not cents. Sorry.
No problem. It's been a long day, so it's understandable. So on this particular case, This is one of those pesky little auto fines, and an auto fine was set in place. The case actually became into compliance prior to the auto fine starting, so there would have been no reason for the auto fine to start, but it wasn't reflected in our computer system, and our support staff created and recorded the lien as a result of the auto fine going into place. So we're just asking for the fine to be vacated in this one, just the fine only.
Okay.
And prepare a
There's no-
release.
Is there anything of record, no liens or anything filed?
In this case, there was. That's part of why we're coming back before you. We created the imposition of the lien after the auto fine, and we ended up recording it with the county.
But the finding of noncompliance was valid. It was just
Yes.
Okay.
put on the order fine.
So in case number SMG 1021-282 Pelican Bay Golf Club LLC, 370 Pelican Bay Drive, parcel number 523600000030. I hereby order that the order imposing the fine
Yes.
be vacated and that the city prepare a release of lien.
Actually, I'm sorry. Is that the way it needs to be? Because the order imposing the auto fine was correct. It just came into compliance before that deadline.
No. Well, let's see.
It's a particularly weird one because of the auto fine.
I will change that to read that vacated, just the fine be vacated.
Okay.
I think you were right the first time.
And we'll prepare a release, yeah, as you requested. Absolutely.
Because the fine was started even though, according to the terms of the order, it shouldn't have started.
Right, absolutely.
So we would still need to, this was recorded, right?
Yes.
So we would need to record something that will clear that, so.
Right, we'll record a release if that works.
Wouldn't it be a release of, there's a lien, I would assume it's a lien that was recorded.
It is.
Well, what was recorded was the order imposing fine lien. Is what
Right.
we recorded initially, which would have put the lien in effect if it went beyond that date. So we actually have a compliance issue. And I don't know if we do a general affidavit of compliance. Maybe the clearest way would be with a release. We've done this before. We'll do some follow-up on exactly. But our intent is that we will release the lien by a proper order.
Right.
And we'll have that
Okay.
signed by you.
Yeah, the important thing is to make sure that it no longer is an encumbrance on that property.
Yeah, so we'll make sure it clears in the public record. Follow up with it.
If we have if we have some kind of snafu, and we have to come back, we'll bring it before you, but otherwise we'll handle it at that point.
I understand it needs to be rectified, though.
Right, absolutely, absolutely.
Okay. Is there any further business?
I hope not.
Mr. Jackson, do you have any further business?
No further business from you?
Okay, it is 4:46, and this hearing is hereby adjourned.